what do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! My God!
We are mediocre, and all mediocre people can do is get drunk and forget.
Hey, bro, come on, let's get drunk.
I get drunk. Real drunk. I want to get drunk.
I mean, sure, when you get drunk, you're lawful disgusting. You smell, too.
Drunk and stay drunk.
Let's get drunk and pass out.
Did you get drunk, dance in your underwear and sing sea shanties?
I got a hell of a good idea. Let's get drunk.
All we want is to pass out and get drunk. Have a little peace.
So, we get drunk, and we're left like hell, and then we die. And the pipe dream vanish.
They deserve to unwind and get drunk.
We have to get drunk immediately.
Are you gonna get drunk tonight, Daddy?
Damn.
Well, I say we get drunk because I'm all out of ideas.
We gonna get drunk tonight, Daddy? Damn. Well, hey, we'll explain what what was going on there in a minute, but right now it is time for the drink of the day. What is the drink of the day today? It is Friday, so we're gonna we got a do-over of the El Presidente, which we did the other night, but due to me trying to rush a good thing, you should never rush the preparation of a good cocktail. I sort of like quadrupled some of the ingredients. I octupled some of the other ingredients. I just threw them all together, just kind of rattling things off the top of my head. But this is a true El Presidente. It's great. You have well, this is a double. This is like a straight double El Presidente. It's we'll just give you the single recipe. So if you want to follow along at home, it's 2 ounces of aged dark rum, 1 ounce of white vermouth. For the rum, if I'm just chilling, if it's just like a daily drinker rum, I'll go with like a plantation aged rum. For the white vermouth, I always use Lillet Blanc because I just love it. A half an ounce of Cointreau, a little splash of grenadine, a little splash of bitters, and then maybe like an orange wedge or an orange ring on top for garnish. You just stir it up in a glass with some ice and strain it into a cocktail glass, and you have this amazingly strong, flavorful El Presidente cocktail. Cheers. It's going to be a great Friday. All right, everybody's here. That's a good thing. So yeah, every other Friday, my cleaning lady comes to clean up my house because, frankly, I just can't be bothered. It's too big of a house for a solo single guy to be living in, and so I have her come and clean up my house every couple of weeks. But she is indelicate, to say the least. Every week I get a text message. Oh, I broke this. Oh, I broke that. She always panics when she breaks my glassware, but I tell her I have an entire cabinet full of glassware because I break it all the time as well. But she like moves everything, and especially the computer. I mean, for God's sake, sitting on my computer today, I have this USB 2 to a USB-C cable. I have no idea what this is to. It was just sitting on the middle of my desk today. I don't know where she found it or what it was connected to before she found it. And then all the microphone wires are jiggled and moved out of the way. None of the cameras are working. So yeah, that was it took me a while. And I had to as soon as I left the work, I had to take the dogs to the vet, to get their ears checked because they always lick each other's ears. And thank you guys for costing me $120 in ear medicine, you degenerate. Yeah, so that, and then as soon as I got home like 10 minutes before showtime. So I run in here, I turn everything on, and of course, it's all intercoursed up. So, oh, now does the cleaning lady steal beers too? Oh, I'll tell you, the cleaning lady I had before this one, that bitch stole beers. Like, I don't drink beer, but I keep beer in my fridge for when friends come over. And so this beer that I had in the fridge for like a year, was just missing. And like, I know it's missing because suddenly there was this hole in my fridge where there hasn't been a hole for a year. And I'm like, bitch stole my beer. And so I went rooting through the garbage, and it was inside of like a plastic bread bag wrapped up in paper towels, crumpled up and stuffed down in the bottom of the garbage bin. I had words. I fired her. And then I found this new lady. This new lady is good. She's too good. She just cleans the absolute hell out of everything. But I do have to talk to her because not only did she just put everything in disarray, well, to her it's organized. To me, she just touched everything so nothing works properly. But I had yesterday's bottle of whiskey. I had the Glen Grant bottle here on my little side table I have. Because I was going to drink it tonight. It's not here. She's moved it somewhere. I did a quick search of the house. I can't find it. It's somewhere. I know she doesn't steal shit. Because if she did, she would have stolen something much more precious than a cheap bottle of whiskey. But yeah, it's somewhere here, and I didn't have time to find it. So the sipper tonight for our anytime we hit $200 is a Balvenie 12-year. Oh, I'm sorry, Dougie. Am I bothering you? Am I bothering you, Strawberry? Huh? Go to sleep. All right, so that's kind of the back of the housing, and I was hurrying up so much to get here that I'm like actually sweating. Okay, let's see what's going on here. Thank you, everybody. There's 146 of you here right now. Why is there only 146 of you here? There was like 700 people here last night. Perhaps you'll join as the morning goes on. But although there's 146 of you, there's only 54 likes. What the hell is that? You guys are better than that. It's 2/3 of you haven't done your job. Don't make me post. I have to post a poll. So I'll post up a poll once we get going. It'll be some sort of guilt or innocence based poll, but please do not forget to like this video and subscribe. I think I'm guardedly optimistic that we've broken through the YouTube random unsubscribing thing, because like I said, every day we get up to about 320. Then by morning it drops down to like 36,025, and then by the morning it drops down to 35,995, and it's just been doing that for 2 weeks or 3 weeks. But today I think we may have cracked the YouTube just randomly unsubscribing people thing, because we are currently at 36,014 subscribers, which is pretty damn good. So continue to hit that subscribe button, continue to double check and make sure you're still subscribed, and eventually once we get going, I'm going to start a poll, and we'll have our little like and subscribe poll. This will be a guilt or innocence based thing, and you'll all choose guilt or innocence, and I'll yell at you for being jerks and idiots and stuff for not waiting till all the evidence is presented, but we'll get through it. Haven't sent to Andrew Branca the link yet. I'll do that. It's still 6 o'clock in the morning where he is, but I think today is the day that the state is finally going to start putting on some evidence to try to show us why this guy committed murder, rather than he just happened to fire 6 shots in the general direction of a woman of negotiable affections, 3 of which happened to hit her. One ironically hit her twice. It went through one side of her, through her shin, out of her calf, and into her thigh. So there you go. He shoots her 3 times, but hits her 4 times. Go figure that one out. So that's all that's really been proven so far, is there was lots of bullets fired. 3 of them hit her. Nothing's been proven why, how, or what, how she was shot. Let's see what the prosecution, because the prosecution has to prove murder, or at least prove voluntary manslaughter. And to prove murder, you got to have the mens rea. Mens rea. You got to have the mens rea. That he intended to kill her, or to the voluntary manslaughter. You just intended to kill her in a spur of the moment kind of thing, a heat of passion, if you will. Those are the state has to at least prove violent manslaughter, voluntary manslaughter, and at best they hope to get murder. But when the state arrests and the defense puts on their case, the defendant has the burden, or at least they did at this time in Ohio. The law has since changed, but he committed this murder at the time the old law was in effect. So he is being prosecuted under the old law. And under the old law, the defendant has the burden of proving that he reasonably acted in self-defense. A reasonable person with a preponderance of the evidence. So at least it's like 51% more likely than not that he acted reasonably. So that's what the state will have to show when it's time. I mean, that's what the defense will have to show when it's time for them to put on their case in chief. But right now we are on day 2 the afternoon of day 2 of testimony, day 3 of the trial, because the first day was only opening statements. Let's see if we do have to get this super important announcement out of the way. Marv White, brother, we got to talk here. Let me scroll up here so we can talk. We can talk. The wife and I enjoy your content greatly. We were talking about it last night. This super chat is our way of thanking you. We love the legal stuff, love the Maritime Monday, love OJ Thursday, love the, oh my God, The Last of Us reviews. I forgot to do the finale. Holy shit. It just hit on me. This thing ended like, what, a month or 2 months ago, and I forgot to do the finale episode. Holy crap. Okay, I'll have to upload the finale episode tomorrow. I'll do that tomorrow when I wake up. So we'll do the finale episode. Thank you for reminding me of that. And then I got to find a new show. I was going to do Mandalorian, but that just demonstrably sucks. I don't know. I have to find another show to do some reviews of. But oh yeah, so thank you very much. Yeah, love the Last of Us reviews. I'll do the one next one tomorrow, the last one tomorrow, I promise. Love the doggo cam. Thank you. No, thank you, Marv and Mrs. Marv. You guys are awesome. I deeply, deeply appreciate your support. It means a ton to me, and then you're always generous anyway with the super chats, and this is a big one. Thank you so much for that. And it's to the point, in fact, where you have put us halfway to doggo cam all by your little self. Thank you so much for that. I deeply appreciate it. And if we scroll down here, we have the next one I really super appreciate. Rick Nikita, $2. Thank you so much, Pupper. You have moved us a little further along the way to dog cam. Dog cam is a thing. We've got $50 to dog cam and $150 to just take a random shot because, hey, it's not F it Friday, but why not? You know, it gives me a chance to drink. So that's what we're going to do. All right, everybody, that takes care of the background stuff. So what we're going to do now is what we're going to be doing every day for the rest of the trial is we're going to be watching the afternoon session of yesterday. And then when we finish with that, we'll watch the morning session of today. And it's Friday, so I might be able to hang out a little bit longer. We'll just have to see how it goes. This judge likes to take ridiculously long breaks, so I like that. Usually the judges will take a 10-minute morning break. This guy takes 30 to 45-minute morning breaks. Most people take 30 to 45 minutes to an hour for a lunch. This dude takes like hour and 45-minute, 2-hour lunches. So I like that. Jim Satala, why aren't you drunk yet? I just got home, but we do have our El Presidente cocktail, the fine recipe of which I gave out at the beginning of the show. This is one of my favorite summertime cigar cocktails. So I didn't even have time to light a pipe or a cigar. I just barely got home and had to screw around with the house cleaning details. I got a rogue hair. Got one hair that wouldn't grow, and it's like tickling the inside of my nose. So if my cam goes off for just a second, that's just because I'm picking the hair out of my nose, just in case you were wondering. And well, hey, where do we go? Cliffhanger says a little bit sleepy. I mean, technically, law enforcement is taught to point your weapon at anything you don't intend to injure or kill. Yeah, he had a bit of an aim problem. Rick Nikita again dropping to $2 with the K9 cam. We're moving slowly along the spectrum of dog cam. Is he in the Philippines or something? Me? Who? Why? What? That first season of Archer. Where are we talking about Archers? Suddenly, oh, the hookers. Oh, when they're dead, they're just hookers. Okay. Yeah, Chandler's talking about Archer. Yeah, that is one of my favorite Archer episodes. I need to put that into like one of my opening statements. I'm gonna do that. Well, once we start the trial, I'm gonna put that into one of my introduction things. And this is the next. I have 2 goals. One of which is about a year overdue. I have 2 goals for the channel right now. One, to get an intro video set up. Like an intro and an outro video. I'm talking to a dude on that. Some like rocking guitar solo and throw up some clips and pictures and stuff, kind of make it cool. The other thing is to get the Law Racks merchandise out. And I know I've been saying this for just months and months and months. We have a great supporter here in the chat who drew the awesome artwork. This is the artwork that's going to be on myself entirely. Just wanted to stop the cam. This is the artwork that will be on the Law Racks merchandise, and we'll talk her up with when the time comes. We'll be putting this on some mugs, some hoodies and t-shirts. It's got the law racks here, and then underneath it says "Enjoy your legal vices." So that's the law racks merch, and that's what we're going to be. Those are the two things. One, an intro that'll probably involve Archer and hookers, and two, the law racks merchandise. Whew. All right. Okay. Notes on a phone. That was an Archer reference. Okay. Any episode with Babu is my favorite, of course, because Salvador Dali actually owns a Babu. Dude actually owns a freaking ocelot. You rock more than anybody else on the entire planet because you actually own a Babu. And the reason I'm stalling right now is because this is how out of it I was and how much I haven't been able to do. As we're speaking, I'm typing in YouTube and getting us to law and crime so we can start yesterday's deal. All right. Law and crime. How many peeps we got here now? Oh, we got 223. Well, and there's so many things to talk about. I need to do something over the weekend about this as well. The Shanquella Robinson case. If you don't know who she is, she went on a trip to Mexico back in October 2022 with some friends, and they posted this video of them beating the ever living shit out of her on camera. I mean, this just her roommates lighting her the F up. And then she disappeared. They all went home and said, oh, she went somewhere else. They found her body. She had like a broken back, I think a broken neck as well. But anyway, she was dead regardless of how it happened. Gee, I wonder who did that. The Mexican government, they've asked for one of the friends to be extradited to face trial in Mexico for her murder. The U.S. hasn't done it yet. And because this murder happened abroad, it's a federal case. But just the other day, yesterday, the feds said that there is not enough evidence to pursue criminal charges against Shanquella Robinson's alleged killer. So they're in the U.S., at least for now, unless there's some major evidence that comes uncovered, the Shanquella Robinson case will not be tried, and there is no indication that the U.S. government has any intention of extraditing the person that the Mexican government has filed charges against. But we'll talk about the Shanquella Robinson case. I'll probably make a short form video about it over the weekend. It kind of makes me angry. But all right, sorry, it's just got law and crime, got law and cuck sidetracked there. All right, Shanquella Robinson, we don't need you right now. We need to bring up the live video. And did y'all see that thing that Matthew McConaughey and Woody Harrelson may actually be biological brothers? I don't know if you saw that, but that was pretty wild. That's also something I've got to talk about. Because apparently Matthew McConaughey, and if you look at them side by side, they do look a lot alike. I didn't notice that until I read this. Look at a picture of Matthew McConaughey and Woody Harrelson side by side. It turns out that Matthew McConaughey's mother knew, or I mean, it was one or the other. I think it was Woody Harrelson's mother knew McConaughey's dad, but it may have been the other way around. But either way, one of their parents knew the other one's parents, and perhaps intimately. So yeah, they may actually be brothers. Check that out. Check that story out. All right, we've got where we need to go. Now we just need to fast forward to the afternoon session, which I'm doing as we speak. And this guy, the afternoon guy, he's an odd looking dude, man. I'm trying to think of who he looks like, and I can't think of it. But all right, let's see. Separate that and bring it up. Strawberry, stop licking Yoda's head. You just cost me $100 today. Hey, don't do that, dumbass. All right. Yeah, well, a 50% hit rating with less than 3 feet is a serious problem for this officer. But again, we don't know why. It seems he was shooting with his offhand because he was stabbed in his right hand, which we believe statistically is his dominant hand. But it may be that he was shooting with his offhand, which may have been weak, and it may have been like a limp wrist thing. But anyway, let's find out. We're going to bring up this guy here, and I'm going to pop out just for a quick second because I have to give the dogs some water. All right. Here we go. Let's share this up. Embiggen it and go. Okay, we have no audio yet. There we go. Let's see. Is it going to be quiet chord or is it going to be loud chord? This guy looks like a thin version of the old man from Up.
Under penalty of perjury, your testimony in this case will be the truth, the whole truth, and nothing but the truth. Have a seat and pull yourself up.
Now, somebody's going to have to tell me who this old codger looks like, because it's on the tip of my tongue and I can't. Hal Holbrook. He looks like Hal Holbrook. That's who it is. It just came to me. And if you're like under 45, you probably have no clue who Hal Holbrook is. But.
Up close to the microphone.
All right. See if we can actually talk into the microphone.
May inquire.
Thank you, Your Honor. Good afternoon. Settled there.
Good afternoon.
All right. The volume sucks ass again. They didn't change it from the morning session. So I'm going to pump up the volume, pump up the volume, pump up the volume. Okay. The volume is now this before anybody asks. And I swear to Christ, I will just flat out ban anyone that talks about that. No, just kidding. This is it. Volume, as you can see here, volume is totally maxed. That slider doesn't go over anymore. Plus, I have a 600% boost on. This is, oh, sorry, microphone, didn't mean to hit you. This is as loud as it's going to get. So, not a thing I can do. Bear with it.
Would you please introduce yourself to the jury?
And of course, there is no audio on the right channel.
I'm a retired.
Wait, who's he?
To the jury.
My name is Yuri Patrick. I'm a retired FBI agent. I've worked over the last several years as a consultant and expert witness in police training matters and use of force matters.
Right. Mr. Patrick, you're from Virginia?
Yes.
Right. And so we flew you out here as an expert witness. Is that correct?
You did.
All right, I'm going to pop out and give the dog some water. I'll be right back.
Industry standard?
Yes.
Would you tell the ladies and gentlemen of the jury a little bit about your background?
Well, I served 24 years in the FBI. Roughly 15 of that period, I was at the FBI Academy in Quantico as a full-time instructor in the firearms training unit, where I worked on tactics, firearms, both technical, new weapons specifications, new ammunition, as well as arrest and techniques, mechanics of arrest. And we worked in close conjunction with the legal department because we changed, during my time there, we changed FBI training over to a more judgmental based training curriculum.
All right, dude does need to learn how to tie a tie.
Also went into police training to apply judgment to try to recognize situations and adjust accordingly. Prior to that, agents were qualified on the range, and that was the end of their training. So we kind of went to a 2-semester system, basic skills, and then how do you apply those skills in a practical sense relative to the job you're going to be doing.
All right. Why do we get no?
I retired from the FBI in 1997.
Sorry, folks. There seems to be no entertaining subtitles for the afternoon session. Apologies.
In 1999, I was approached by Maine law enforcement, wanted me to do some instruction and provide some services to them through the Maine Criminal Justice
Crafty Flaw Lady, new member. Thank you.
Attorney General's office, which are the two primary training and certification authorities for the state of Maine. I did that for the next almost 20 years, traveling around the state, working at the academy, giving regional training to police departments, sheriff's offices around the state. At the same time, I began this expert witness consulting business in 1999, which took me around the country on a wide variety of cases in a wide variety of locations, dealing with police and use of.
Wow, so he's been consulting since the late 1990s. Wow.
Okay, with State Exhibit I-1.
This is my CV.
That outlines your training, your fields of expertise, accomplishments, things of that nature.
Yes, my employment history, areas of expertise, accomplishments, publications, instructional background, and.
All right, I'm just going to listen here on my phone, but I think I'm going to have to bring my volume way down.
I want to to ask you about your fields of expertise, and just a few. I don't want to get into too much detail. There's a lot of information here, but field of expertise, deadly force.
Yes.
You've testified and trained officers in deadly force over the course of your
Yes. Yes.
20-something years?
Yes, starting with when I was still a full-time instructor at the FBI Academy, and then my second career with Maine law enforcement. It was the primary topic of instruction for the schools and regional seminars I would give to law enforcement around the state.
Would that be the same of the use of force judgmental training?
Yes, essentially the.
And there's a lot of various firearms trainings that you've listed as a field of expertise.
Yes.
Over the whole course of your career, you've been trained others.
Yes. Yes.
And you have techniques and mechanics of arrest. Also an area of expertise for you?
Yes, that was primarily a basic level training for new agents and for basic level police.
Okay, I've lowered the volume here for me. Let's see how that sounds.
Practical considerations you need to take into account, how to organize, how to control and subdue, if necessary, any resistance you might meet, how to try to plan ahead to prevent resistance. Just the whole.
Somebody let me know how it sounds. Do I still need to lower my volume more?
Planning and successfully executing an arrest.
While working for the FBI, did you also help shape policy and national standards?
I worked on firearms, ammunition. The ammunition test protocols that we developed are now industry standard for law enforcement throughout the country. I also worked hand in glove with the legal unit. My associate and co-author, John Hall, who was instrumental in.
Okay, while he's going through his CV, I'm going to check this one more time. How's my volume?
All federal law enforcement. And yes.
Then on page 3, you note various publications and articles. I'm going to focus in on just one in particular. You wrote a book was it about 2005?
Yes.
In Defense of Self and Others, Issues, Facts, and Fallacies.
Yes.
Who was your co-author on that?
John C. Hall. He's another agent. He was a lawyer, legal expert, and in fact was the Department of Justice go-to expert on constitutional law dealing with use of force and deadly force. Not just the FBI called upon him, but the DOJ did as well. And he and I were
okay, court is up 600%. I'm down to 25%. This is the best it's going to get.
Cross-train. We would, especially once we got into our practical applications and judgmental training courses, there would always be a firearms instructor and a legal instructor working with the students. So we could draw lessons from what they did. We use computer simulations and we use role players and a variety of techniques to try and put them into rapidly changing and dynamic situations without actually getting somebody hurt. And then John became the unit chief of the firearms training unit.
Okay, I'm going to back my mic off a little bit too here, but this is literally the best it's going to get.
He went back to legal and I went to Maine.
You have an instructional background. You did a lot of training out at the FBI of new agents, firearms training, things of that nature?
Yes. Plus police schools, regional police schools around the country. The field office would sponsor a school.
And for those of you that aren't hearing anything, there is no sound in the right channel. All of the sound is coming through the left channel. So boost your left channel up as much as possible.
Officers all over the state.
Yeah.
All over the country.
Yes.
Let's talk about your courtroom experience. As an FBI agent, just testifying for the government, I know you said you testified in over 200 federal criminal cases. Would that be in your capacity?
That might be on the high side, but over the course of 24 years, although when I was at the academy, I didn't do any testifying other than in contract disputes. And there was an FBI shooting where one agent killed another agent. Not to get into the details, but he was terminated, fired, and then was suing to be restored, and I was the government's expert witness to refute some of his allegations. Those were the only trials or courtroom cases I had during my time at Quantico. But before then and after then, I testified in a number of criminal cases.
And I note from your CV, you have testified in 31 states and in Puerto Rico. Is that accurate?
I've been retained in those
Okay.
states. I've not necessarily testified. I may have been depositions, may have been courtroom testimony. Overall, I've testified in 26 trials and roughly 30 depositions.
Okay. And What percentage of those are criminal versus civil, if you know?
The trials, there were 10 criminal trials, and that would be 16 civil.
When we're, just for the jury's benefit, when we're saying civil trials, do those civil trials still involve your expertise
Yes,
with regard to use of force?
civil trials involve somebody suing a police officer or a department, usually alleging excessive force or wrongful death, any number of things having to do with an officer's exercise of force.
So the analysis in your criminal and civil is still using essentially the same standards. Would that be accurate?
Well, there's, yeah, I mean, the standards are established by the Supreme Court for which determines when and under what circumstance a police officer can use force. And those standards apply to every department, every officer across the country uniformly. There's no variation. And those are the only standards we've got.
And you said maybe about 10 of the cases went to trial and were criminal?
Yes.
Right. And how many times of those 10 cases were you testifying on behalf of the officer?
8 of the 10.
And so there's been 2 times you've testified against an officer in your
Okay,
entire
that's
career?
interesting to know.
And is one of them this case?
It is.
So there's one other.
Yes.
So he's only testified on behalf of officers
Part of
twice.
a big case here in Ohio, State versus White, that involved use of force by an officer, right?
Yes.
Who did you testify for in that matter?
Officer White.
And you were retired. When did you quit taking cases as an expert?
I started slowing down about 2018, 2019. I still had some cases that hadn't wrapped up. I was going to honor those, but I wasn't planning to take any more cases.
What?
By about 2019.
No, I don't want to see him sucking on his glasses.
And at some point, we reached out to you regarding this case. Were you taking new cases at that time?
No, I wasn't.
Yet here you are.
Here I am. Yeah, I think originally I was contacted to recommend an expert, someone to work with you. And then I was called by Chief Flynn, and I do not recall whether he was with the PD or the sheriff's office. He was urging me to take this case. And another colleague, a man I...
No, I'm going to object to the hearsay. I'll sustain that. You can ask your next question.
So I reached out to you asking if there was an expert since you were no longer taking cases, right?
Yes.
And what was it? We were just asking for an opinion, correct?
Yes.
When you decided you were going to work with us, did my office tell you we were looking for any particular opinion?
Oh, no.
So we asked you to just make an independent judgment about this case. Is that correct?
Yes.
Do you ever have situations where you give an opinion that maybe doesn't help one of the parties, I guess their theory or their case, and they don't ever use you any further beyond your opinion?
Yes, that happens happened relatively commonly.
You don't know anyone involved here in this case, correct?
I do not.
Let's discuss discuss the law and standards that apply when we're judging an officer's use of force. Tell ladies and gentlemen of the jury what standards we use, the prevailing standards in case law.
I was just saying, I hope you're talking to the people at home because I'm already boosted 600%.
Non-deadly force.
So people at home should download Volume Booster. A Volume Booster.
Any use of force is, by definition by the Supreme Court, a Fourth Amendment seizure matter. So they've established a standard by which any use of force is to be assessed as to whether it was justified or not. That standard is objective reasonableness, which means that those who are assessing or sitting in judgment of a use of force are to look at the circumstances of a use of force, are to look at the circumstances, the events, what the individual people did from an objective viewpoint, independently of subjective fears, such as I was in fear of my life or that type of, and make a determination whether the officer's use of force or perception of the need to use
that was
force
them. They turned up the court, not me.
Now,
That
for
was them
non-deadly
that turned
force,
up.
the standards are essentially that an officer may use that degree of force reasonably necessary, but no more. It's capped. For deadly force, there are only 2 circumstances in which the court has established are the only circumstances in which deadly force is justified. One is to prevent an imminent risk of serious death or serious injury or death. And the second is to prevent the escape of a dangerous individual. Now, the court defined a dangerous individual as someone who has inflicted or attempted to threaten to inflict serious injury, but most departments have pulled back from that and have a much more stringent policy regarding using deadly force for prevention of escape. In the first instance, though, protection of self and others, the officer perception that that risk is imminent and deadly force is necessary to terminate that risk is what triggers is what those assessing it need to look at. Hopefully corroborating that perception with realities of the circumstances, forensic evidence, the realities of dynamic confrontations. Police officers experience physiological effects in high-risk life and death situations that have to be taken into account in assessing use of deadly force.
You're familiar with cases like Graham versus Connor, Tennessee versus Garner, and obviously State versus White.
Yes.
And those cases are what kind of help us decide what we look at in deciding whether force is reasonable. Is that accurate?
Yeah, I mean, Garner established the circumstances in which deadly force was reasonable. The Graham case established that use of force is a Fourth Amendment.
All right,
issue,
now my
and the
volume is
objective
way too loud in my
reasonableness
ears.
standard is the only standard by which use of force is to be assessed.
So how do you come to an opinion on whether or not a use of force is reasonable? What do you look at?
I look at whatever, as much as is available to me, forensic evidence, videos, witness statements, officer statements, whatever is about what is the prior investigation, and some cases what was known about the individual, what was learned about him leading up to the confrontation, what that individual did, as much as you can, and apply to make that determination as to whether the officer's perception of imminent risk that led him to use deadly force, decide to use deadly force, was reasonable in those circumstances.
Okay. And we look at what he knew at the time, correct?
Yes.
What does it mean when we say we don't review in hindsight? This sounds like we're judging them. We're looking in hindsight. Can you explain that?
Well, hindsight is when, if you take an event, say a shooting, and you have the result, and then you work back from that, and you say, well, if the officer had done this, or if the officer had done that, this wouldn't have happened. And then if the officer hadn't done this at an earlier stage, that wouldn't have happened. And the officer should have done this, and the officer should have done that. When often hindsight applies factors that the officer didn't know or couldn't know. When you examine a use of force incident, you need to move forward with the incident. And you look at what was known about the individual. You look at, again, forensic evidence, whatever you may have. You look at what the individual did, and you look at what the officer did in response. Now, if what the officer did in response was reasonable within those circumstances, that's okay. The officer isn't required to do the one correct thing you think he should have done a year after the fact. The officer's required and trained and expected to act reasonably based on the exigencies and the urgencies of the moment. And then you move forward through the incident that way until you get to a point where you can make a judgment as to whether the circumstances corroborate what the officer's perceptions were.
And you've mentioned in your report, you look at factors. We look at the totality of the circumstances, such as the severity of the crime. What's the importance of these factors? What are we looking at?
Well, different people have different levels of dangerousness. I mean, that's what you're looking for. The severity of the crime. You would approach an armed and violent bank robber a lot differently than you would approach somebody who was late on his child support payments.
Come on, people. No spoilers. We don't want spoilers.
Those are the factors that lead officers
No
to
spoilers.
make a judgment as to how much risk this particular individual or situation could embody, and hopefully be prepared accordingly. Risk rises and falls, and officers are trained and expected to recognize changing circumstances and react accordingly. You can't just initiate a response at the start of a confrontation and apply
He's a
that
boss.
response as a blanket
He's got two
response
rings
throughout
and an Apple Watch.
confrontation. It may well be necessary, but that's one of the things you need to look at is as circumstances vary, officers are trained and expected to recognize changes in circumstances and adjust their response accordingly, given physiological realities and time constraints.
Are factors, when we're looking at the use of force on the parties involved, factors such as a person's size or skill level, are those things important?
They are, again, depending on what the officer knows. An officer breaking up a drunken bar fight in a remote logging camp is going to react a little differently than an officer breaking up a drunken bar fight in a local university frat house. Again, it's what do they know and what can they reasonably surmise from the circumstances that they do know.
When an officer is trying to consider whether a person's a threat, are the things the suspect is saying to them important?
That's certainly an important factor. If a suspect, I always told my students and officers, if somebody's telling you they're going to kill you, it's okay to believe them. You don't need to wait for them to actually try to do so, to take some sort of protective action. It may not be shooting them, but certainly be on your guard and be prepared to respond more drastically.
Okay, nice theory, but she didn't say she was going to kill him.
And on the flip side, if someone said, I surrender, well, maybe you don't necessarily need to believe them. Should an officer consider that in the totality?
Yes. Again, it depends on what the person being confronted does. And if the person is resisting arrest and then gives up, the level of force being used needs to be adjusted.
And what does it mean when we say stop the threat?
It means ending whatever it is that threatens your physical safety, your health, well-being, your life, or someone else's. Now, the standard is that you can use deadly force to prevent an imminent risk of death, or actually, standard really, it doesn't even mention death, it says serious injury. And what is serious injury is often debated. Some states have statutorily defined, I think Alaska is one. I've done a couple of cases up there where they have a statutory definition of serious injury. I don't know what Ohio's, but that's the standard. You can prevent serious. Now, that means deadly force can be preemptive. You don't have to wait for someone to actually hurt you. You don't have to wait for someone to actually try to hurt you. Although many police officers do get to that point because they're reacting. But it means if the circumstances are such that, if you're approaching someone you recognize as dangerous, who has done dangerous, violent things, and is believed to have been armed the last time he did a dangerous, violent thing, and you approach him and he responds, you tell him, raise your hands, and he does, and he reaches into his coat pocket, you could make the reasonable perception, it would be reasonable that he could do you harm, and you don't have to wait to see, because the circumstances support a reasonable belief that what he's doing could lead to harm. On the other hand, if you approach someone who's not dangerous, not violent, and you give them the same commands and they do the same thing, you're going to have to wait a little bit longer and maybe see what they pull out of their pocket. There's a higher level of risk you're going to have to take on yourself because there's no corroborating circumstances to say, yes, a perception of imminent risk of serious injury is reasonable in these circumstances. In that case, it wouldn't be.
So let me circle back a bit. So someone can no longer be a threat either because they stop the action, they maybe put their hands up, they maybe run away. Would that be accurate?
Yeah, or they've been shot and fall down. It behooves the police officer to recognize when the threat ends and stop applying deadly force. Now, frequently that takes a little time, again, because of the physiological responses, and people don't react as fast as they do in the movies. So if somebody is posing a threat and the officer is shooting and it's a dynamic threat, and I'll tell you, no officer knows whether he's hitting his antagonist or not. You don't know. That's why they're trained to keep shooting till the threat ends, until they perceive that the threat ends, but it can take time. The individual can, if we look back at it, we can pinpoint a point and say, well, at this point, he's no longer an individual or a threat. But nevertheless, a couple of shots are fired a second or two after that. That's what you might call the biological, physiological inertia. An officer's engaged in a trained reflex, he's shooting, he's protecting his life, the threat disappears, and it takes maybe a second for that awareness to get through to him. And in the meantime, he's still shooting. So it's not uncommon for shots to be fired in the immediate aftermath of the termination of a threat. But again,
so what you mean is maybe shots 1, 2, and 3 hit somebody consecutively, and there's still a 4, 5, 6 that come right along with it. Is that
Yes.
what you're referring to?
Yes. But it'd be in pretty close, they're in close succession. When police officers are shooting to protect their life, they shoot fast and they shoot a lot, which is what they're trained to do. And with modern weapons and modern training, a police officer can fire 4 or 5 rounds a second. That's not unusual. And as long as that threat is there, they're trained to keep shooting. The old days, we used to train, well, fire 2 shots and then look and see if you need to shoot anymore. The realities of these confrontations change that. You don't shoot and assess. You shoot as long as that threat is apparent.
And so when we say until the person's no longer a threat, we're not saying shoot until they're dead.
No, just until the threat. And now, unfortunately, a lot of people do die because deadly force is that force likely to cause death. But the intent is not to kill them. The intent is to stop them posing or acting in such a way that they are a threat to the officers and others. And as soon as that action is stopped, the justification for deadly force disappears. They don't finish off the wounded.
So now let's get into this case. You were asked
Hey,
to.
this hypotheticals are
This
done.
case and give an opinion as to whether or not the use of force was reasonable, correct?
Yes,
And you prepared a report.
I did.
I2 is marked. I'm going to approach with State's Exhibit I2. Tell me if that looks like your report.
Yes,
And you were given information from my office in order to prepare your report.
yes,
Did you feel you had enough information to make a decision based upon the materials given to you?
I did.
Part of that information was a synced up audio and video,
Yes,
and you had statements of Mr. Mitchell to review.
yes.
Looking at your report, you start out by discussing kind of a rendition of the facts of what happened here. That be accurate?
Yes,
And I think you note that Mr. Mitchell was ill prepared. I'm trying to find the exact language used to perform his job. How is that relevant to the analysis here?
I think that that contributed to the resistance to the confrontation between the two. Police officers who are not in uniform are trained to have some of their official proof of authority, their badge or whatever it may be, depending on the jurisdiction. Because if you're not in uniform, there's nothing about you that says police officer. And people you approach in your official capacity may not believe you are a police officer, which can lead to resistance and can make whatever legal activity you may be
Fine.
involved
I
in
believe that
much
sounds
more
reasonable.
difficult because you can't establish your bona fides as a police officer. In this, that's what I saw. It doesn't mean he didn't have the authority, and it certainly doesn't mean that his attempt to
Important
arrest her was invalid, or it just contributed to the difficulty of the situation. She didn't believe him. He's negotiating, trying to convince her.
That's
that he's
exactly
the
what I was
best
saying
police officer.
yesterday.
This goes on
I should be an expert.
for some time. That's what I mean by not prepared to really function.
It was a failure to
And-
communicate. The knife was found in
Did you
the
find in the
driver's seat,
situation
on the driver's seat.
that at one point in time,
The
Mr.
what
Mitchell
fell out was
may
the
have been
officer's
justified
phone,
in using deadly force?
and he
Yes,
dropped his weapon.
Relatively immediately after
Yes.
the point he was injured. Clearly, there was a weapon. They were in close proximity. He was injured. I think if he had employed or decided to use deadly force fairly, at that point, it would have been, in my mind, it would have been a justified decision.
And are we assuming he'd been cut by Donna Castleberry at that point?
$20
Yeah,
away from
even,
Doug, okay.
he could be mistaken about that. I mean, she may have displayed the knife, and he very well could have been reaching for it and impaled himself on it. I don't know, but he wouldn't necessarily know that under the circumstances, and that wouldn't affect his perception that the reasonableness of his perception that he had been attacked.
So you found that at one point, while he may have been justified, what was your opinion when the circumstances changed, and when did they change?
For me, the circumstances changed when, after he had been injured, and he opens the door, and I could see on the video that you can see his head outside the car, and you can see her moving into the back seat. Now, to me, that tells me that she's not attacking him. She's trying to get away, and that's as far away from him as she can get, is the back seat. And at that point, the circumstances are changing, and they continue to change. She's in the back seat, as far away as she can get. She's not. He suffers no further injury. She's
reasonable,
verbally pleading and submitting and giving up. To me, that tells me that the confrontation has whatever physical resistance she had posed or danger with a knife, she's submitting at that point.
And does the fact that he stated he was being choked with her foot in the front seat affect that analysis?
No. Yeah, I have trouble picturing that. And once the door opens, he has room to remove the pressure. I mean, if she did have her foot up against his neck, just leaning out the door would relieve the pressure.
Does he have a duty? I mean, is that retreat? Does he have a duty to do that?
Oh, that's not retreat. No. I mean, retreat would be if he ran away. If he just said, never mind, go, But if he were to get out of the car, for example, he's gaining a tactical advantage. He has her locked in the car. She can't, childproof locks. The driver's side door can't be opened. I'm not saying that he should have done that, but I'm just saying that would give him, it's not retreat. If he had gotten out of the car, it's gaining tactical advantage and buying time to address her and her fears and talk her down or get help or whatever would be necessary.
And are some of the factors we look at in judging this based on the totality of the circumstances? Do we look at the ability to create distance and the ability to have time?
Yeah.
Don, you're weird. You're correct, but weird.
Yes, that can have an effect. You would expect a police officer under fire to take cover, even if he had to back up to do so. That's not retreating. But you do expect a police officer to recognize changing circumstances and be aware of the behavior and the behavior patterns of the person he's confronting and make judgments as to what level of force needs to be continued in order to bring them into submission.
And what if he doesn't recall that the door was open? How does that play into it?
I can't answer. I mean, the door was open. That's one of those.
He doesn't remember opening the
objective facts
door?
you can look at. He opened it. He had to. Nobody else could have opened it.
So do we get to ignore evidence if an officer can't remember it?
No, you look at evidence and you have to make a judgment based on what that evidence means and how credible the officer's account is of what happened.
So we could still do an objective review whether he remembers that or not. Is that what
Yes.
we're saying?
Well, you have to. You have to do an objective review of any use of force. You can't just take the officer's word and be done with it.
Is there any objective evidence you found of the knife being in the backseat of that car with Donna Castleberry?
No, there's no damage to the car. There's no damage to the upholstery. There's no indication that she was trying to attack him. At one point, when he let go of her hands and was getting his gun out, if she were attacking him, I would expect there to be additional injuries. Close quarter knife fights, there's almost no way to engage somebody with a knife in hand-to-hand without getting cut. And the fact that he did not suffer any further injury tells me that, again, she was, in essence, retreating, not attacking.
And is it an important factor that the knife was found in the front seat?
It's an indication that she was unarmed when she was in the back seat.
I'm going to try to boost this
What
to
if he
1.5.
doesn't know where the knife is? He
Tell
says
me
he
if this
doesn't
is too
know.
much.
Does that give him the ability to presume that she's got it and she's a threat?
It's not uncommon for officers not to know things. And
It's not uncommon
it
for
wouldn't
officers
surprise me
not
that
to
he
know things.
didn't know where the knife was. But the fact that he was not being further injured, further cut, and the fact that she had retreated to the back seat and her manner of submitting, pleading, giving up, he should have recognized that.
And what if he couldn't hear her pleas?
Again, should have been aware of the changing circumstances, her location, the lack of any attack. I mean, I think she's in the back seat kicking at him. I'm not sure that would rise to the threat level of justifying deadly force.
And where are officers trained to focus when they're dealing with somebody presenting a deadly threat?
Well, on the individual, most officers will focus on the weapon. It's amazing how many shootings end up with the individual wielding the weapon has wounds to his weapon hand because there's a phenomenon called tunnel vision, which when things get really dangerous and the adrenaline kicks in, your subconscious kind of takes over and your field of view contracts. And that primordial being that we all have.
Okay, guys, I got to know, is this too fast? Or I put it up to 1.5 speed. I just want to know if that's too fast for you. It's perfect for me, but I know people hear things at different speeds and different rates, and not all of you are native English speakers. Should I put it back down to 1.25, or should we leave it where it is? I'm just curious what you all want me to do, because I want to make you happy. That's my goal in life, to make all of you happy so that you feel comfortable and loved and welcomed to Legal Vices. Too fast for you. Speed is perfect at 1.5. 1.5 is good. Sounds 5. Greg Herrick. I'm sorry. I want no child left behind. I don't want anybody to feel it's too fast. Put it at 0.5. Shut up, John Gordon. Yeah, 2.0 would be way too fast even for me. God dang it. Well, we want you naked, Jeff. Turbo Goat, go away. But don't go away. Go away, but don't. All right, looks like 1.5. One of you have said it's too fast, and I really apologize for that. We'll try to catch up, and then we'll adjust accordingly.
From our evolution is saying that's what could hurt you. Focus on that. It's no longer a wild animal. Now it might be a gun or a knife. And in the extreme case of the penalty, that's all they're aware of. They can see that weapon and they're focused on that weapon. With training and experience, officers can widen that field of view some, and they can look around. There are various measures that can be brought to bear, but it's common. It's one of the most common physiological reactions to a dangerous situation is the sudden tunnel vision. So most officers say they're looking at the suspect who presents the threat, and many of them are actually looking at specifically at the weapon that is being wielded.
Your report talks about the moment of decision to use deadly force. When you say that, are you talking about when the officer puts it in his mind or when he actually begins to start?
No, when he actually makes the decision to begin shooting.
There's literally no reason to have my right earphone in.
The assessment of a deadly force confrontation, one of the most important factors is that first shot. If the decision to fire that first shot is justified under the circumstances, subsequent shots are justified, almost invariably, because they're all part of a single event. What starts that event is what's key, and then consequently, what ends that event is also an important consideration. If it's common for deadly force to continue beyond the point where the threat is ended, but it wouldn't be acceptable for deadly force to continue minutes after a threat is ended, or long after
I like this, guys. Making sense. I like this.
So if an officer is feeling a threat at a certain moment and decides, I'm going to get my gun and shoot, but doesn't have his gun yet, and then circumstances change because he decided and may have been justified at the moment he thought about it before he reached for his gun, does he get to then later shoot?
Again, the act of deciding to shoot has to stand alone, independently of what the officer may have thought or said beforehand. If at the moment he decides to shoot, the circumstances support a perception of risk, a reasonable perception of risk, it doesn't matter what he thought before. I mean, he may have thought, the day before, I'm going to force a confrontation and shoot somebody, but he doesn't. And then he gets into a situation where somebody tries to injure him and he does shoot them. You have to restrict yourself to that specific moment, not what went before.
You talk about Mr. Mitchell not issuing any commands. Are commands required?
They're certainly trained.
Okay, but they're not required.
Officers are trained to tell people what they want them to do and to keep telling them what you want them to do until they do it. And so it's unusual to see, to me, it was unusual that he from the moment he was injured to the end of the incident, he never said a word to her that I could tell.
Did you? So you didn't hear anything like "show me your hands" or things were?
No, or stop, or back off,
me
or
your
drop the
titties.
knife, or
Do you recall hearing profanity
yes,
from him, from Mr. Mitchell?
yes.
Yeah, we know you're just
Are officers
joking
trying
about
to
knowing the
de-escalate?
verdict because the trial's going right
Increasingly
now.
these days, there's an expectation that police officers will recognize changing circumstances and de-escalate accordingly.
At what point in this situation would there be an obligation to try to de-escalate?
More of an, I'm not sure I'd call it an obligation, but an opportunity when she was in the back seat. By de-escalate, I mean, he had every right to arrest her. He had every right to physically try to handcuff her and subdue her. Her resistance was unlawful. That goes back to, again, being unable to authentically establish your authority as a police officer, but it doesn't mean he didn't have that authority under the circumstances. Once he was injured and she's in the back seat, you know, the opportunity to do something other than shoot her is in that time frame. And, you know, from once she has fled to the back seat and is verbally, if I don't, no way to tell whether she was physically surrendering or not, but we could certainly hear her verbally submitting. That would have been the opportunity to de-escalate to the degree necessary, again, to bring her under control and effect the arrest.
So there was an opportunity to de-escalate early on before the handcuffing and the cutting occurred, and an opportunity to de-escalate when she was in the back.
Well, yeah, I mean, yeah, when he says essentially, fuck it, I'm going to handcuff you, that's drawing a line. And again, you know, that's within his authority. Don't get me wrong. That's may not have been the best decision at the time, but it was certainly within his discretion and authority.
And if he says, I was in fear for my life, or she was trying to kill me, do we end it there? Do we take his word for it and have to?
Well, no, that's, you look at all the circumstances, the forensic, whatever you've got to corroborate that subjective statement.
Yeah, you can't just
I'm in
say
fear
it.
of my
You
life
have
by
to
itself
corroborate it.
is not enough. It has to be supported by the facts, by an objective determination of what the forensics reveal you, by an objective look at what the suspect did, and what the officer knew about the suspect, and what the how that contributed to a risk of harm or not. You know, officers can be mistaken, and their mistakes can be acceptable. I mean, again, it's the circumstances dictate. But I'm in fear of my life is not a magic shield that authorizes you to shoot anybody you want.
Let's talk a little bit about.
Oh, that's a good. I like that.
You
I
said an
like that
officer can
statement.
shoot 4 to 6 rounds a second.
I'm in fear of my
Believe-
life is not a magic shield to allow you to.
You've been a
I
part
want to hear
of
that again. I want to hear
many,
exactly what he
many-
said. I like that.
Let's talk a little bit about.
Again, if it's the circumstances dictate, but I'm in fear of my life is not a magic shield that authorizes you to shoot anybody you want.
I like that. I'm in fear of my life. I'm gonna write this down. I'm in fear of my life is not a magic shield that allows you. Can't remember what he said at the end. I like that. That was a good
My
statement.
life is not a magic shield that authorizes you to shoot anybody you want.
That authorizes you to shoot anybody you want. That authorizes you to shoot anybody you want. I really like that statement. There we go. This guy's good. I like him so far. He's making a very compelling argument, and the state is finally discharging their burden of proof by putting on experts to talk about what he could have, should have done. I like that.
Let's talk a little bit about. You said an officer can shoot 4 to 6 rounds a second, I believe.
Yeah.
You've been a part of many, many cases involving officers use of deadly force. Is that right?
Yes.
Yes.
And how does the shot cadence here comport with your experience and training?
It's uniquely slow and deliberative. Most of the only other case I've seen where there's a series of shots fired over a similar period of time was a case in Chicago involving an officer who shot a young man.
So there were
14 times over
6
the space of
shots
about 15
fired
seconds.
over the space
I
of
mean, shot at
12
him that
seconds.
and the young man had fallen down and was incapacitated after the first couple shots. We just continued shooting. Most shootings they're over quickly, and a lot of shots can get fired, but they're fired in a brief period of time, mere seconds. It's unusual to see, in this case, 6 shots spaced out over a 15-second period of time. That's unusual.
And you were aware that the gun jammed here?
Yes.
Correct? So that gun couldn't have fired anymore if he had even continued to pull the trigger, right?
At that point, you'd have to clear the jam for it to continue firing.
And do you know a fellow by the name of Kevin Davis?
I do not.
So you're not familiar with any book or literature he may have written?
I've been made aware that he's written a couple of books. I know he's been retained by the defense, but I have no personal knowledge of him.
And did you review his report as part of your
I did.
work here? Did you find anything troubling in his report?
I'm trying to think. He expressed a greater willingness to validate the subjective experiences of the officers when the standard is an objective one, independently of that. And there's more, you have to look so much at what the suspect does and what the officer does in response to that and make a determination as to whether the officer's responses are corroborated, supported by that. And I found him unpersuasive.
Okay, well, finding him unpersuasive doesn't mean he's
wrong. The need
wrong.
to reassess or react to changing circumstances.
I don't believe he did, no.
Did the two of you disagree on the shot cadence here and the significance?
Yes. Well, he didn't find anything unusual about it. My question essentially would be, what would Miss Castleberry have had to do not to get shot at the point she's in the back seat? If she'd been shot at the initial point of injury, that would have been understandable. But I don't know what she could have done once she's in the back seat. What could she have done?
Could have given him a blowy and she wouldn't have got killed.
Based on what Mr. Davis had to say,
Yeah.
there was nothing else she could have done.
Yeah, apparently.
Yes.
Yes.
Jesus. I can't believe I said that.
And did Mr. Davis account for or acknowledge that the door was open?
I don't recall.
Okay, that's right.
I think Bronca knows the defense's guy. But
I
Branko will
believe
be
at
here in a
one
few
point
minutes.
The
and he
term
can
reasonably
talk.
necessary appears in your report. You're not saying that reasonably necessary is the legal standard here, right?
Oh, no. But it is part of the objective determination when you are looking at a shooting. And this is what you folks will be doing. You need to make an objective determination as to whether it was necessary at whatever point.
So based upon your expertise, knowledge, training, years of experience and familiarity with the law, what was your opinion as to whether or not Andrew Mitchell acted in an objectively reasonable fashion in shooting Donna?
My opinion essentially is that his decision to use deadly force was not reasonable under the circumstances at the time he made that decision.
Yeah, pretty much daily. I was being
Nothing
facetious.
further at this time
Yeah.
for Mr. Collins has.
Okay, that was all right. That was a good direct testimony. I liked that. I did like that. I think he was very persuasive in his direct testimony. Well, now it's the defense's turn to have at him, and some of you are saying that it doesn't go really well for him. We'll just have to see. But currently, there's 424 of you here and 254 likes. Come on, people, hit that like button, smash that like button. And while you're doing that, please make sure you're subscribed to the channel. If you're not subscribed, I would love it. I would be deeply indebted to you for all time and eternity if you would just hit that subscribe button. And if you think you're subscribed, if you know you're subscribed, if you believe you're subscribed, please just double check to make sure you are still, because YouTube sucks, and not in a good way. And they keep deleting subscribers. I think we've overcome that. Oh, no, we haven't. We started the stream with 36,014 people. Now we're down to 36,012. 2 people have left since we started. Screw you. So if you haven't subscribed, if one of the 424 of you that are here now has not subscribed to the stream, have not subscribed to me, please do that. I would deeply appreciate it. Make sure you hit the like button and then take our little poll over here. How's our poll going so far? I hit the like and subscribe buttons. Now I'm voting that 12% of you say not guilty. Wow. 18% of you say guilty of 17% of you now say guilty of negligent manslaughter. Oh, so it's not negligent manslaughter. Shit, that's wrong. It's voluntary manslaughter. I must be liquored up. I should be voluntary manslaughter. Damn it. I blew the poll, and not in a good way. Shit. Okay, well, frick. 26% of you say he's guilty of murder. And of course, 44% of you take the joke answer for, I don't know, was Steve did it. Hit the like button, hit the subscribe button, take the poll. Andrew Branca should be joining us anytime now, whenever he's available. I've reached out to 2 other people to join us. We'll see if they're cool enough to be part of the Cool Kids crew. If they are, they'll join us. If not, they're just not cool enough. And again, I thought he was very persuasive. I like that. We'll have to see what the defense says. But before we get to the defense, I want to take care of a couple of these super chats here as we work our way to Doggo Cam. $20 Dog Cam, you're matching the agreed upon price of the proposed tonsil work from this case. Tonsil work. Oh, I see what you mean. Shame on you. Shame on you, JKD. But yes. Sparkle TBD says, thank you for the stream. One step closer to Dog Cam, yes, we are one step closer. And Bella Stella also says Doggo Cam Fund. Thank you. Melvin Silver, thank you as well. Disturbing profile picture, but thank you for the super chat anyway. The victim could have complied with the lawful arrest instead of using deadly force to resist arrest. Okay, Melvin Silver, I have a question for you. I don't know how much of this you've been watching. Maybe you know everything, maybe you know nothing. But let's assume that you're not familiar with this case. Answer me this, riddle me this. Would you have a different opinion on submitting to arrest, to a lawful arrest? Would you have a different opinion of submitting to lawful arrest if you knew that there was a rumor going around that someone was kidnapping and raping prostitutes? That this guy was in an unmarked car, wearing plain clothes, did not have his badge to show her, did not have his walkie-talkie to show her, and only had a plastic card that says, I am a police officer on it. Would it change your mind if you knew that other than a simple little piece of easily forgeable plastic he had on him, she had no way of verifying whether or not he was an actual police officer? Would that change your mind? If he's in a marked police car wearing his uniform with his full utility belt and badge showing and, you know, body cam and all this stuff, his computer in his car and whatnot. And then if he says, you're under arrest, and she resisted, I would have a different theory. But I just want to, would your opinion change if you knew those additional facts? Just curious. But again, we're in the early stages of this, so we don't know how it's going to go. And Soul on the Lich says, dead hooker stories are fun until you're in it. Also, I guess maybe true. I don't know. Doggo Cam is just OnlyFans, but for your dog. Yeah, my dogs are totally naked. My dogs, and they're unshaven and totally nude. Just thought you guys should know that. He showed his department photo ID and police forms. He didn't show the forms. I didn't hear anything about showing the forms. All right. Well, that was my questions. Let's see what happens on cross-examination. Some of you are saying cross-examination is kind of fierce. We'll just have to see. Now, okay, so Broken Baker says, but what was the rule for the Vice Squad? Do they have those things on, or do they use only the card? Undercover, apparently at that point in time, the policy was that they did not have to have their badge. So I don't know, it's a thing. All right. Let's go. Let's watch the cross-examination and see what happens. Oh, well, thank you for that. I'm not sure what that means, Law and Cook. How long does that go? Are they taking an afternoon break already? Holy shit, they talked to him for like 5 seconds and they take a break? All right, whatever. Let's go ahead. Jeez. All right. Huh. And then they just go straight on through for for about an hour and a half-ish, it looks like. Well, about an hour and 45 minutes.
Jim is a dear friend and
All right, let's see. Okay, this guy is from Virginia, so let's see if the prosecution does what they always do. They always do. Oh yeah, I've cross-examined you a bunch of times. How you doing there? You see, they seem to know everybody. Marv White didn't have to, so they are line steppers. Well, the only thing I can say is people are making good arguments, but we just have to see what the prosecution proves and then wait for the defense to make their case for self-defense. Because at the time this was charged, at the time the crime was committed in Ohio, the defendant had the burden of proving beyond a reasonable doubt, beyond a what's the word I'm looking for? My English is failing me. I know it is in Korean, but that helps no one but me. Preponderance of the evidence. Okay. Yeah. It has to prove beyond the preponderance of the, by a preponderance of the evidence of like a 50.00001% that a reasonable person would find him justified of for using self-defense. So there we go. Let's see what they're going to say.
The hall earlier today, correct? Along with my partner, Caitlin Stevens, we represent Andy Mitchell in this case. First and foremost, I think you did some time for the Navy, correct?
I did.
Thank you so much for your service. Appreciate that. Second order of business, a good friend of mine, Jim Scanlon, said to say hello to you.
Jim is a dear friend and a colleague.
And you and he both testified together in State v. White, correct?
We did.
Okay. I want to start, sir, by just some basics of your past and stuff. You were never actually a police officer, correct?
Correct.
You were an FBI agent, correct?
Yes.
An FBI agent is subject to the Department of Justice policies, correct?
Yes.
And the Department of Justice policy for their employees has a different use of force standard or analysis than what we have here in the state of Ohio, correct?
They both stem from the same source. We're bound by the Supreme Court standards, and I think you'll find that they both require, they both say the same thing. They may use different words, but there's no difference in the tenor or intent of the policies.
We'll go through that. And you're aware that my client was a Columbus police officer, correct?
Yes.
Not a federal employee or a federal corrections officer.
Correct.
And in terms of, you were never trained in OPATA or Ohio certified or anything like that in terms of law enforcement tactics,
No.
correct? Okay. And so first I want to look
Oh
at
my
your
God.
report,
I have to make this is just a random thing that this is just a random comment that today StreamYard has changed their layout here, the back of house layout, to where now super chats are automatically brought up on a separate column. So now I don't have to keep watching and trying to figure out if I got all of the super chats. They're all listed here. And speaking of people that are listed here, even though he's fuzzy, I'm either drunk or he's out of focus. One of the two. It is potentially criminal Sean. Welcome, sir.
Hi. Good morning. Good morning.
I'm leaning towards drunk, but we'll put out of focus if we need to.
Yeah. So how far into the trial are you going? How are you guys gotten to?
Right now we are in yesterday afternoon, which is the second full day of testimony.
Oh, are you guys speed running it to catch up?
Yeah, we're doing the afternoon session this morning, and then we'll do the morning session as soon as we finish up with this.
Okay.
Have you seen this new thing that StreamYard just did? The
Yes,
super chats are now in their own column.
Yeah, I saw that last night.
Sweet.
Yes, I saw that. I did want to say I mentioned I mentioned to you in the DMs, and in case people are wondering, in Ohio, I don't know if you explained it. If you guys have been watching, if you guys watch this in Ohio, cross-examination is unlimited in scope. So I could go, if I'm cross-examining you, I could start running down roads that were not brought up on direct. We don't play that game of you've got to do the elaborate dance of drawing it out from one side and then going to the other. Now, for redirect and recross, yes, your scope becomes limited. But if the cops want, if the prosecutor's talking about X, Y, and Z, I can say, hey, what about these parking tickets you have? Now, as long as it's relevant and I can get to it, I can go wherever I want to go.
And so that explains why the lead investigator yesterday was asked why his direct testimony was pretty short and his cross-examination lasted forever, and he was being asked about things that were never brought up.
Yeah, well,
it's relevant.
Yes, and it's the way the Supreme Court of Ohio, when they put the rules together like that, said we are more concerned about getting the truth and getting the facts than we, sticking to these rules. It doesn't that doesn't help get the fact finder the information they need. So, we do things a little differently. So,
and this was also, as we were talking about before, this is charged under the old standard where the defense has to prove by a preponderance of the evidence that they were justified in using.
Yes, but they
force.
they are not. The defense's burden is not to a beyond a reasonable doubt standard. It is to a lower standard, and once you cross the threshold of clear and convincing, it then becomes the prosecutor's job to disprove it beyond a reasonable doubt. So in reality, it is still pretty much how it goes, because if you can't even get a 51% showing that you had self-defense, you're going to be toast anyway. And for the most part, appellate courts in Ohio generally attributed it. The prosecutor still had the burden ultimately. So in cases where courts had, most courts would say, okay, you've met the burden of self-defense proving it. Prosecutor, it's your job to disprove it. So, all
right. And we just had a use of force expert from, he's a former Glowy. He was a
no such thing. That was a Glowy.
He was an instructor at the FBI's force judgment training.
Oh, so he trained the liars. Even better.
Yeah. So he was just on, and he gave a very, very good direct testimony. But apparently, people say that kind of goes off the rails during cross-examination, ends up sucking on his glasses, which kind of disturbs me. But Andrew Brink is going to be joining us.
Does he do this like the that?
Well, see, I'm hoping that's what he does, because that's what I do. If he's just not like going deep throating his glasses.
Yeah, it's like the What really does this mean?
Yeah, I hope he's just not going like full.
You'd be allowed to punch people in the face to do that.
Yeah, X-hamster on these glasses. But anyway, we'll have to see. And sorry to everyone I just offended with that, but hey, Sean's here, so I can loosen up a bit.
Yes. Also, by the way, everybody, go read all the stuff that got leaked by that brave lad on Discord.
You mean by the traitor, by the whistleblower that we're identifying? Which
he wasn't even a whistleblower. He's sitting there on Discord sharing it with his bros. But that's not treason. Treason is not sharing it with, pigfucker 1342 on Discord. That's not treason.
Unless that was one of his friends' names.
Well, no, it was one of the friends' names on Discord. It probably was.
That's what Discord's for.
Yeah. That's not treason. And yes, it would also show that the U.S. military has been lying in Congress. Oh, Ukraine's gonna win, Mr. You watch it and you'll see that basically this has been Reddit goes to war. That's what this has been.
I'm still stuck on Pigfucker 324.
Yeah.
Okay, but we have people saying this guy gets killed on cross-examination or murdered, so to speak.
Oh, that'll be good.
Let's see how that goes. But
I will say, the trial first came through the first time through. I was covering the Dr. Husel trial that was going on at the same time. That was a doctor who was accused of murdering 50 people with fentanyl. So we didn't get to cover this a whole lot, and I was probably going to be covered. I didn't realize his new trial was already going on, so I'll probably be trying to. I was going to be looking at this myself a little bit coming up, but yeah, I'm curious to see how this plays out, because it's from having watched a bunch of the first trial, I've got my own opinion, so I don't want to say it really too much about it.
Well, I mean, like I said, my opinion is he probably just got pissed that a hooker stabbed him and blasted her a little bit, because but we know that he's under federal indictment for actually kidnapping and forcing hookers to do these things. But the jury shouldn't know this, so I'm excluding that, and I'm waiting to see what the argument is. But it looks so far just like
so you got that. Okay, yes, with that information out there, yes. I didn't know if you knew that, and I didn't want to bring it up. But yes, this guy is not Imagine that, a vice cop who's crooked.
This entire vice squad, this entire vice unit was done away with because they were all dealing drugs and shit.
Well, and that's the thing, guys. If you aren't aware, it's Training Day is not a made up thing. Yeah, the
It's the
Shield as well. Yes. Vice units are notorious. I mean, think about it. You're running around dealing with drugs and hookers and organized crime. Well, it's kind of like being when they find out the volunteer firefighter is an arsonist, like they kind of end up, it happens a lot. And Vice units are notorious of being corrupt.
JSD says this is the last state's witness they arrested just now. Well, that can't be good. That doesn't look good for them. We'll have to see.
Yeah. Also, are you guys is Diane Menashe one of the attorneys? She can't be because she was already in trial.
Doesn't sound familiar.
Who are the guys?
There's two chicks and two dudes.
Okay,
the dudes are just like giant fat people like me.
Yeah, you're fat, huh?
There's a reason the cam stopped right fucking here.
Yeah. Okay, but
I'm one of those lucky people that when I lose weight, the first place is my face.
Yeah,
the last place is
people
everywhere.
Like you, like I'm so fat. I'm just a big fat hog. It's like, motherfucker, you don't spare me.
No, see that's literally like you'll never see anything other than a headshot if I have anything to say about it. Because
guys, I know Diane Menashe was on the Husel trial. I didn't know she was on this now because that woman is a fucking savage. She did a couple other trials.
There's a little blonde chick for the defense that sounds like Lisa.
That's
Simpson.
not. Oh, this is not her. This is not. Okay. No. She's an attorney out of Columbus. She did another case that we covered, where the guy was accused of murdering his wife and hanging her in the woods with a USB cable to kill her.
Oh. Hey, and it's interestingly enough, my house cleaner, she just found a random cable and I have no idea.
It was a longer one than that, but she had been in the woods for so long, her body turned into like this big sack of skin with just like goop inside of it because she was she had disappeared for months,
like the Vallow kids,
kind of. And actually, by the way, I need to plug this. It was a case called State of Ohio versus Matthew Moore. He spent 15 months in jail. He got acquitted. Jury came back, I think, within like 3 hours. They acquitted him of murder. They acquitted him of everything. Next Wednesday at 8 p.m., I'm actually going to be interviewing Matthew Moore, and he's going to come on and he's going to talk about. He's going to come in and talk about what it was like, the whole process. But he's also going to just, kind of his experiences, and people are welcome to come and ask questions. And nothing's off the table. I mean, I said, people are going to ask you, did you do it? People are going to ask you, what do you think happened? And he said, he's totally fine with answering all the questions.
So he's going to write a book if I did it.
Well, no, but he did write a book on Amazon, but it's kind of like his kind of recounting of what happened, because his wife disappeared and they couldn't find her for a while. And then they found her, and then he wasn't arrested right away. It took a while, and just like that whole process of like how it felt, and then sitting in jail for as long as he did, and then it's
when's that again?
That's going to be Wednesday at 8 p.m. So
8 p.m. your time, Central.
Yes, 8 p.m. Eastern, Central time.
Okay.
I am not one of those.
But you're Eastern. God, I keep forgetting.
I'm an East Coast elitist.
Yeah, for some reason, Ohio belongs in Central. I don't know why.
No.
Isn't a corner of Ohio in Central?
No.
All right.
No. We don't do those games.
Weird. For some reason, I just always think Ohio is in Central. That's why I started streaming this too late. But speaking of which, we got to get back to this here. Andrew Branco will be joining us as soon as he's able. We have two starred chats, and I love these super chats now. I love this column. I just saw it right as you were signing on. The Broken Baker says, so now us non-paying plebes won't. No, you'll show up. There's just a random live chat column, and then there's a starred. So if I star it, you'll show up. And here's super chat.
Yeah, guys, and here's the thing: if you didn't star the super chats, they weren't corralled. This is corralling them, because if otherwise you can miss them. So that's
going to be such a good help on Fuck It Fridays when I'm liquored out of my gourd and I'm like, hey, it's a super chat. So I can just look at the list. Maybe one day they'll add good audio controls. Yeah. What they have to do is take away their existing audio controls and have faith in us that we know how we want our audio to sound. That's all they have to do. So, all right, We've got, let's see, Dead Hooker stories are fun until you're in it. We got that one read. And Marv White, we read you as well. Don't have to. So they're line steppers talking about the cops and their requirements. So we are $14 away from dog cam. So just keep that in mind, super chatters. And let's get back to business. $14 to dog cam. No white girls, just dogs. Only dogs. All right.
Oh, so you saw my show last night.
I did.
Universal Truth number 3.
Flux, bringing the heat. Bringing the lesbian heat. So now you have a special place for Clear's Throat. Mocha Dick Poon, XOXO, fully adjustable. Hi, Sean. Says Flux. We love you, Flux. Now we're $5 away. We got $5 away from dog cam, but we don't have a $5 step, so let's go down to the 10. All right, let's bring in Dr. Hal Holbrook for more testimony. Dr. Cadaver.
Looking rough.
Yeah, it's reminds you like, oh, and these cheap bastards, they've only got Kirtland water, which is like $2 for a pallet of 24 of these damn things.
Hey, in Franklin County, times are tough, man.
Come on, get some Evian or something. Make him feel important. Evian. This guy came from Langley.
I mean, Quantico.
I just said Langley, didn't I?
Yeah. Oh, he's probably a spook as well.
Yeah.
Not that kind of spook, guys. The intelligence kind.
He's just an FBI guy. Yeah, not a Langley dude. Yeah, he's a Quantico dude. All right, back to Hal Holbrook and his random eyebrows and the bad curler day.
Your copy up there?
Yes, I do.
Okay. So if you could turn to page 3.
The beginning of cross-examination.
Title a section of that, correct? And it's entitled Regarding the Use of Deadly Force by Officer Mitchell, correct?
Yes.
And then when you go to page 4.
This segment brought to you by Kirtland Water.
You use the phrase law enforcement and correction officers ... may use deadly force only when necessary. Okay.
Yes.
Now that ... you left a lot of stuff out, correct? In that ellipse.
Uh-oh.
I'd have to go back and look. I don't know what that took out.
Okay. May I approach the witness, Your Honor?
Uh-oh. That's not a great way to start.
Mr. Patrick, at the bottom, you're attempting to show that
you're supposed to prepare your witnesses ahead of time.
Somehow flows through Ohio, somehow flows to the Columbus Police Department's use of force, correct?
No, I'm not. I'm attempting to use the Department of Justice policy statements to explain the standards that apply to everybody, all police officers.
May I approach, Your Honor? You just for identification purposes, Defendant's Exhibit 16.
Mm-hmm.
Could you take a look at that, sir?
Yes.
And you know what that is, correct?
Yes.
And that's the Department of Justice policy with regards to lethal force, correct?
Yes.
Okay. And that's what you're referring to in your report that you footnoted and you talk about on several pages, correct?
Yes.
And that says in the first sentence, law enforcement officers and correction officers of the Department of Justice.
Yes.
So that applies only to them, correct?
It is a Department of Justice policy. Yes.
Correct. And so nowhere in Graham v. Connor does the term reasonably necessary appear, correct?
Correct.
Nowhere in State v. White does the term reasonably necessary appear, correct?
I haven't read State v. White in years. I couldn't answer that off the top of my head.
Would you like to read it?
No.
Okay. Would you take my word for it that it doesn't appear there?
I will.
Okay.
Oh, the glass is
And in
sucking
that
his
situation, sir, you still put it into your report, the wording about necessary and reasonable necessary on page 4, the second paragraph, right? Right after the ellipse, may use deadly force when necessary, right?
When necessary, yes.
Okay. But again, you just agree with me that it's not in the constitutional law of Graham v. Connor, and it's not anywhere in the state of Ohio's seminal case, State v. Ohio, correct?
I can't imagine that Ohio wouldn't want the deadly force to be necessary.
That wasn't my question, sir. My question is, Graham v. Connor controls State v. White for the state of Ohio, correct?
Yes.
And nowhere in there does it use the words reasonably necessary or necessary, correct?
Correct.
You put those words into this report, correct?
Because I was quoting the Department of Justice policy, yes.
That only applies to federal law enforcement officers and correction officers, correct?
Yes.
And you're aware he's not that, correct?
Yes.
Okay. Other things that you didn't put in your report, or that you do in the report. All right. Let's go to nowhere. You talked to Ms. Pritchard a little bit about an officer can be mistaken, right?
Yes.
They can be mistaken about a belief, correct?
Yes.
As long as that's reasonable, correct?
Yes.
And nowhere in your 8-page report do you ever mention the term mistaken belief where an officer can be mistaken, correct?
Correct.
You specifically left that out of your report, correct?
I didn't. Yes, I did not. I mean, I didn't use that term because I didn't see any reason to.
You didn't anticipate that potentially Mr. Mitchell's belief could be mistaken about whether or not Ms. Castleberry was a threat in the backseat or whether or not the door was open? or whether or not she was a threat as she passed by him. That's common sense, correct?
And that'd be good hooker marketing.
Next,
Threat
on
in the
page,
backseat.
your timeline events, okay, on page 2, if you go to page 2, sir. All right. Paragraph 3, okay? And Mr. Patrick, I apologize. Sometimes I go very fast, so anytime if I go too fast, please let me know, all right?
Read your
Okay. So you're with me now at the
private
timeline
chat.
on the paragraph
I'll
3 on
stay
page
white.
2?
I got some. I know
And you walk
background on
through
that.
different things about what you hear, correct?
Yes.
Different things at times of what you see, correct?
Yes.
Now, when you base that timeline, you're basing it on information you've reviewed, correct?
This is based on the video, yes.
Okay, but you had reviewed my client's written statement, correct?
Yes.
Okay, you had reviewed his testimony under oath at prior times, correct?
Yes.
And at nowhere in that timeline do you mention anything about the choking situation, correct?
Correct.
Okay. You were aware of it, right?
I was aware of it, yes.
Okay. And you mentioned to Ms. Pritchard that on direct that you had a hard time visualizing that, right?
Yes.
Okay. So let's try it hypothetically. I'm seated in a seat and I'm belted in, okay? I have my seatbelt on. You're aware Mr. Mitchell had a seatbelt,
Yes.
correct? And Ms. Castleberry had her seatbelt off.
All right, it's Duggo Cam
Okay.
time.
And at some point in time, there was a struggle over the handcuffs, correct?
Yes.
And at that point in time, he's still seatbelted in, correct?
Yes.
And at some point in time, there's a struggle, right?
Yes.
Non-compliance by Ms. Castleberry to being under arrest.
Yes.
My client announced that he was going to place her in handcuffs, right?
He did.
Long before he said F you, right?
Yes.
Long before that. Then he tried to handcuff her, correct?
He did.
There was a struggle, right?
Yes.
And then on your timeline, she's got a knife, she cut me, right?
Yes.
Based on what you read in my client's statement, as well as his testimony, you then realized that my client had a struggle with her to gain control of the knife, correct?
Yes.
So both his hands were to both of her hands, correct?
Yes.
She positioned herself so that her back was up against the windshield, and he had both hands like this, right?
That's what his account says.
And I'm just trying to help you visualize it because you told Ms. Pritchard you couldn't visualize it very well. So now, he indicated that as he pulled to gain control of the knife, her foot was underneath his neck, correct?
Yes.
And the more he pulled, the more he thought he was going to lose consciousness, correct?
Yes, that's what he said.
Okay. And were you aware that his DNA was found on the bottom of the sandal of the foot that was under his neck?
It's his fucking
Yes.
car. His
Okay.
DNA is all
You
over the
didn't look at that
goddamn
objectively,
car.
did you?
I saw what I saw in the video. I didn't see any. This timeline is based on the video.
Sir, I'm asking you if the fact that my client, in this report several times, you say his statement alone isn't enough, correct?
I said his statement needs to be corroborated by the circumstances and evidence available.
Would you agree with me that the DNA on the bottom of a sandal of someone who says that the foot was underneath his neck and squeezing it, that's corroboration, right?
That's indicative that she did that, yes.
But you don't put that in your report.
I did not.
You don't tell that to, ladies and gentlemen, the jury, do you? You discount it, right?
I didn't assign any relevance to it for the decision to use deadly force.
That's his perspective, right?
Yep.
You have to address it from his perspective, correct?
In part, yes.
Yes. And so at the time, when was his decision made to use deadly force, Mr. Patrick?
Why?
No, at the time, wasn't his decision to use deadly force right before he lost consciousness, correct? That's when he decided, hey, if I let go of these hands, she might slash me, but I can try to get to my weapon, right?
He did let go of those hands to get his weapon.
Correct. So at that time, he made a choice to use deadly force, right?
At that, again, as I said before, the critical point is when the deadly force is the gun is actually fired. But yeah,
in order to fire the gun, I apologize for interrupting. In order to fire the gun, you got to get the gun, right?
Yes, you do.
You're not getting the
But
gun.
the fact that you're getting the gun doesn't commit you to shooting the gun.
The fact that you're getting the gun doesn't mean you're going to wave it, right?
I've seen people do just that.
Okay. Now let's put in the other factors. He's been slashed on a cut that goes down the gash of his hand, correct?
Yes.
Okay, 34 stitches, correct?
Yes.
That happened first, right?
Yes.
Now he almost is losing consciousness as he's getting choked out, right?
According to his account, yes.
And the corroboration of DNA that you said is indicative of that, correct?
Yes.
That you didn't consider, correct?
The DNA does not indicate whether he was losing consciousness.
Okay. So he's lying about almost losing
I'm not saying he's lying. I'm just saying that's his account.
So at that point in time, when he lets the hands go, that's a risk, right?
Yes, it is.
That's an increased risk caused by Donna Castleberry, correct?
It is an increased risk. And my point earlier was that when he would.
Let me interrupt. My question was, that was an increased risk caused by Donna Castleberry, not my client, correct?
Under the circumstances, when he let go of her hands, he enhanced the ability of her to attack him. Yes.
He did, and he enhanced the ability of her to attack. she could attack him as she came closer to get to the back seat, right?
She could have.
In his mind, and that's reasonable, right? For him to believe that.
But she didn't.
That's not my question, sir.
No, but that's the answer I can give you.
No, the question is it reasonable for him to believe that after he's been sliced once and after he's choked, as he lets go of the arms, you just said it increased the risk of the chances of her enhancement to attack him, correct?
Yes.
So if I've been slashed once and choked, it's reasonable for a police officer to believe that as she comes towards me to get to the back or here, she could slash me, right?
That's possible, yes.
And it's reasonable, right? Mr. Patrick, we're not dealing with possibilities.
It could be reasonable.
Yes. And it's reasonable that if someone is more dangerous behind an individual than they are from in front of them, correct?
Again, depending on the circumstance, yes, it's possible to be more dangerous behind. But this was not a surprise attack. This was not an ambush. She was retreating from him.
Sir, a surprise attack. He never saw the knife the first time. That's a surprise attack, correct?
That was.
So you did, but okay. So, but if I'm confronting someone and I can see them, the risk of injury to myself is far less than if they're behind me and I can't see them, correct?
Correct.
Okay. So someone is more dangerous if they're behind the officer than in front of them, correct?
In general, yes.
Okay. He's coming in.
I want to switch gears, okay, and talk about threats, all right? You would agree with me that attack with a knife is violent, correct?
Yes.
You would agree with me that verbal, I'm not going to be handcuffed, is a sign of noncompliance, correct?
Yes.
Resisting is a threat indicator, correct?
Yes.
Physical assault is a threat indicator, correct?
Yes.
All danger cues, correct?
I'm sorry.
All danger cues, right?
Again, it depends on the circumstances, but yes, people resist. Some are dangerous, some aren't. It's an indicator of certainly that you have to take into account.
Okay. And you would agree with me that you've testified under oath before that the moment the baseball bat hit the other individual, that shows an intent or a desire to harm the officer or kill the officer, correct?
Baseball bat?
Yes, sir.
I'm sorry, where's that coming from?
Okay.
Yeah. Well, huh?
You had previously given a deposition before in a state of Jonathan Fontes versus Broward County Sheriff's Department, correct?
Oh, a different case.
It's been a while. I don't remember the details.
Do you remember that the suspect had a bat and was trying to hit officers?
I don't remember anything about the case at this point, but I'd be happy to review it if you like.
Absolutely, absolutely. Okay. So I'm going to turn to page 114. And for identification purposes, we've acknowledged this as Defendant's Exhibit 15. No, there's no copies.
That was no. There's no copies, dumbass. I mean, what was the, he's testy. I like this guy.
So we approach you.
No, just continue. We'll get copies if need be.
I like this judge too a lot. He takes 45-minute breaks and 2-hour lunches. He's my kind of guy.
Yeah. Guys, if you want to, that case they're talking about, State v. White, it involves an officer getting into he pulls up behind two guys on motorcycles. One of them takes off. Oh, are they on break right now, Jeff?
Nope. We're just pausing because we have another amazing guy here. We have Andrew Branca, attorney at law.
How you doing,
self-defense guy.
Hey, Andrew, how you doing?
How are you?
So far, so good, man.
Good morning. Good, very early morning to you.
Not that early for me. But I had some stuff I had to take care of. I got a big event tomorrow. So
yes, you do. Which you should probably talk about right now if you're.
Oh yeah,
yeah.
You think so?
They're running out of time to join, so you got to do it now. Otherwise, they're going to lose out.
In fact, today is the last day to sign up for. Jeff, you got the word.
I'm scrolling down. There we go. Well,
all right,
there we go.
Tomorrow. It's like the old race car days, right? Sunday. Except this is Saturday. Law Self-Defense Advanced class, full day class, taught live by me, streamed to you at your computer, where you learn how to be hard to convict, how to be an unattractive target for prosecution if you're ever compelled to use force in defense of yourself, your family, your property. And it's tomorrow. So today is the last day to sign up, folks. This is the only class scheduled for 2023. This is it. And by the way, if you have a conflict tomorrow, sign up anyway. We're making the replay of the class available to all the registered students for a couple weeks, so you can watch it at your leisure sometime after Saturday. Learn more and register right now at lawofselfdefense.com/advanced.
And go there, and it is incredibly affordable. You think just because he's one of the leading experts in the entire planet on self-defense laws can be ridiculously cost prohibitive? It's not. What's your life worth? It's the old motorcycle thing. Is your head worth a $25 helmet or a $250 helmet?
$600 helmet.
Yeah, well, there we go. So please do this. If I and I'm thinking I'm kind of probably dumb because even though I don't live in the States, it would be fascinating to know.
So thanks, Jeff. And now I want to hear about this white case with the motorcycle.
Okay. So he pulled up behind the guy. Guy 2 takes off, and guy 2 almost hits a curb and gets thrown out almost into traffic and run over. Guy number 1 stops his motorcycle, and he doesn't take off. He stops, complies with the officer when he lights him up. He stops. You can see him take his glasses off and kind of put them on his leg, and he turns around, and the next second you just hear bang off screen. Guy falls over, and he's paralyzed. You see the cop come back onto screen. He's now drawing his pistol again, and where's your gun? Where's your gun? He's like, I don't have a gun, sir. Please help me. This bike is on me. It's crushing me. And shortly after that, the cop realizes, like, he doesn't have a gun. You see him clip something off of his shirt, and that's his microphone. You hear him throw it into the car, and then you see him on camera whipping out his phone and calling his attorney. In the middle of all of this, though, the other police have shown up, and the guys on the motorcycle, his buddy was driving a car, pulled up behind them, and you could tell this. Officers don't ever let you get involved in the crime scene. But this guy is stuck under his motorcycle, and the cops are not helping. He gets in there, is trying to help his buddy, give him first aid, and it's clear that he didn't do anything. Like, he fucked it up, and he shot the guy, and he didn't have reason to. He goes to trial. He gets convicted of, shooting the guy. He also gets convicted of a firearm specification, meaning that he used a firearm in the commission of his crime. This went up quite a bit through the appellate courts in Ohio, and they said that doesn't count because he was doing his job and he hadn't deviated from his job. So in Ohio, the firearm specification would have only counted like if he had decided to go rob a bank. But if he's trying to do his job, and his job was to stop these guys who took off, that was okay.
So the shooting was basically reckless, is what they're saying.
Yes,
It wasn't.
Yeah.
Okay.
So he got and he ended up he got 10 years. He got appeal bond, which, I mean, I'm just gonna say, like, ain't nobody else getting appeal bond if you get a 10-year sentence like that. While this whole thing got appealed, the Supreme Court also found, like, oh, by the way, his jury instructions were bad, so it went back down. And when they were getting ready to retry it again, he pled out to a misdemeanor. So, yeah.
And this is the case that they're essentially the people here in this case are basing their arguments on.
Which people? Who? The defense?
All right. What we've got here is the prosecution has finally put on an expert. Yeah. He's a use of self-defense expert from. He's a former FBI agent, and he is a trainer at the use of force judgmental training.
I've never heard of it. I've been around that space a long time, but whatever.
And he's been working solely as an expert since the late 1990s. His name is Yuri somebody or other.
Okay.
And we'll bring him up just for demonstrative purposes here. Almost.
I previously worked with KGB on force training.
This is Mr. Yuri here. He looks like Hal Holbrook a little bit. But what he made a very, very good argument on direct examination. I thought he'd made some very, very good points. These are the main points that he made. He's done over 200 federal criminal cases. These are statements he's made. Use of force is automatically a Fourth Amendment seizure issue, objective reasonableness. You have a right to, there's a protection of self. The officer's determination is what triggers. And that was his pun. The trigger is the argument. So you don't base the judgment on the one thing you think the officer should have done a year later. You don't have to believe
a prosecution witness. Yeah.
Yes.
Okay. Well, this is all. I mean, this is all Tennessee versus Garner. This is all the normal stuff.
Yeah. You don't have to base you don't have to believe the suspect if they say they surrender, but you should reconsider the situation. It's not uncommon for shots to be fired in the immediate aftermath of the neutralization of the threat. This case was use of reasonable force. I mean, that's what he was brought there to testify to. I mean, it was not a reasonable use of force. If you're not in uniform, there's nothing about you that indicates you're a police officer. That can lead to resistance. It doesn't mean he didn't have the authority to arrest her. It just contributed to the difficulty of the situation. She's trying to get away. That's as far as she can get, the back seat up against the window. He suffers no further injury, and she is pleading to submit. That is when the situation changed. He choked her.
Feels weak for, I mean, it's presuming a lot of facts that are in dispute, right? Like he would know she's trying to get away and not trying to stab him again. Like he didn't suffer he's not required to suffer any further injury before he can defend himself.
He alludes to that here when he says he choked her. She choked him with her foot in the front seat. That doesn't change the situation, but once the door opens, he has room to remove the pressure on his throat. Him opening the door is not retreating from the situation. He doesn't have to retreat from the situation. It's an objective fact. The door was open. There's no indication she was trying to attack him other than that first stab.
Well, the first stab is an indication.
Whether he knew she had the knife or not, he should have known he was not being cut further or attacked further.
Oh, that's weak.
Even if he couldn't hear her submit, he should have known that the situation had changed. Kicking out at him from the back seat does not rise to the level of justification for deadly force. Then he talked about tunnel vision a bit. He says commands are not required, but they're trained to give commands. It's unusual that he gave no commands from the time he was stabbed until the time he shot her. He had every right to subdue her and arrest her. I'm in fear of my life is not a magic shield that authorizes you to shoot anybody you want.
Well, that's
true. His shot cadence is uniquely slow and deliberate. And his last statement he made was he found something troubling in the defense expert report. The defense expert was overly willing to validate the subjective feelings of the officer.
Well, that's what you'd expect the state witness to say. By the way, in the box of you never do the right thing, according to the prosecutor, if he'd shot quickly, they would have said he was shooting too fast and was not reassessing between shots. Now that he's shooting slowly, it's a slow, deliberate cadence, and that's what's wrong with it.
Yes, yeah, it's like arguing with a woman. It's never going to be right.
And speaking of arguing with a woman, the last statement he made said, I don't know what she would have had to do in this officer's eyes to not get shot.
Comply?
And then the cross-examination started just a few minutes before you joined us, and it's off to a blistering start. It starts out with in his report, he was basing everything on a Department of Justice requirements, which doesn't apply to the defendant.
I'm always nervous every time they start bringing this Tennessee Garner stuff, which of course is good law, but these are all civil cases. Every time they start bringing that into a criminal case, he has the same right of self-defense as you or I.
And he got the expert to admit that the DNA on the bottom of her sandal is corroboration of the officer's statement. The critical point is when the gun is fired, you can pull out your gun, but you don't have to fire it. The first stabbing was a surprise attack, but then she tried to escape. And you got him to admit that it's probably more dangerous to be behind the officer, generally speaking.
Okay.
And that's where we pick up this cross-examination that is pretty damn aggressive. And people in the chat are saying he literally gets murdered on cross-examination. So we'll have to see how that goes. But that's where we are. And let me bring this up and share a couple of the super chats that have come in. Free the doggos. The guy looks and sounds like Abe Vigoda. Where'd we go here? All right, those are our two super chats that have come in since we started talking here, and we'll pick this up a little bit later.
It's always funny seeing in the chat people repeating bad facts as if it were true, like that he had nothing to indicate he was a police officer. He had his police identification. He didn't have his badge, but he had his police ID.
Yeah, and as I was saying yesterday, I mean, this is just a really good case of failure to communicate. She doesn't believe he believes he's an officer, and he's not prepared or even apparently authorized to explain and prove that he is an officer. You have two people probably with justifiable arguments and justifiable actions. But we're just gonna have to see how it plays out.
And I mean, yeah, he has his police ID, but how many people have ever seen one of those compared to a police badge? And it's like, you know, that's where it's like, why don't you have your badge? Like, why do you have only your ID card?
Well, apparently at the time, it was policy. They weren't required to have their badge if they were undercover. But in any case, that would only go to her state of mind.
Yeah.
Right? And her state of mind does not determine his privilege of self-defense. They could both be right? She could be reasonably in fear that she's being subject to criminal attack, and he could still be lawfully defending himself from a stabbing by a suspect.
Oh, I agree. I just think that's a failure point induced by the, not necessarily him, but that's where, the government has induced a failure point unnecessarily.
Yeah. So, I mean, it's a very reasonable policy argument, right? And they keep saying at the time a badge wasn't required if you were undercover, which suggests to me they've changed the policy.
Yes.
Right. Well, let's get on with Hal Holbrook testimony here.
May I approach the witness, Your Honor? Yeah. Okay. You're familiar with it when you testified in the estate of Jonathan Fontes versus Broward County Sheriff. It's take a look at this. I'm sorry.
Okay.
Okay. And you were under oath, correct?
I don't recall. Yes, but I don't recall the details.
Okay. All right.
Well, we're going to refresh your recollection right now.
Okay. And you can go ahead and read a question or two.
Oh, what was that? I didn't hear you.
He says they're going to impeach him now with prior testimony he's given in other cases under oath, and he's like, "Well, I don't remember this." And I'm like, "Well, don't worry, we're going to refresh your recollection right now. Isn't this you? Didn't you say these words? Could you read that aloud to the jury?"
That's apparently what they're going to do. They're apparently just going to crush him with previous statements for the next hour or so.
Take your time to read that page, okay?
Okay. Yeah, and I agree with that.
But tell the ladies and gentlemen of the jury, you actually say that at the moment the contact the bat makes with the individual, the suspect's intention is clear that they're going to continue to harm, to cause serious physical injury or death.
Yes, in this case, I will quote from this document: the accumulative effect of his behavior, the attacker, I'm presuming, I don't recall this, his continuous fighting, his continuous resistance, his aggression. The moment he hit Wagers, the police officer, in the head with a baseball bat, he established that he was willing and intending to kill that police officer.
Yep.
And you agree with that, correct?
I do.
Now let's relate to this case. Donna Castleberry resisted, correct?
She did.
She continued to resist, correct?
She did.
She fought with him, correct?
She did.
And then she took a knife out and she slashed him and committed a felonious assault, correct?
He was definitely cut. Again, as I mentioned earlier, whether she did it intentionally or he did it grabbing for the knife, he was cut, and he was reasonable to think that he was at risk at that point.
So just like the person making contact with the bat, Donna Castleberry made contact with a knife on my client, correct?
She did.
Okay. So you agree with that it fits that same scenario, that there is now a belief in my client, and it's reasonable that the attack, she's going to continue, or that she's going to seriously physically injure him or cause death, correct?
I think it would have been reasonable for him to look for a continued attack, yes.
Okay. And that's reasonable. To look for a continuous attack after you've been slashed, after you've been choked, you have to believe that the attack's going to continue, correct?
Yes. And that's why I said it would have been reasonable for him to use deadly force at that point.
And by the way, folks, anybody can buy a police badge.
When we talk about,
you just order them from a catalog.
Right? Eminent means something's going to happen.
I mean, a real
soon,
police badge.
Well, it could happen. Doesn't mean it's absolutely going to happen.
Possibly, right?
Well, the state is admitting it was her knife. The state admitted
in your analysis, right?
Yes.
And eminent, and you remember the Laquan McDonald case that you testified in?
Yes, in Chicago?
Yes.
Yes.
Okay. So you testified that when you use it, it means something could happen soon, right?
Yes.
Okay. And you would agree that a person who is unarmed can still be a deadly threat, correct?
Yes.
You would agree with me that an officer is authorized to shoot to prevent an imminent attack from becoming an actual attack, correct?
Yes.
So had Andy Mitchell, now, Ms. Castleberry didn't have the knife in her hand when she got in the car, right?
I don't see any evidence. No, I'm sure she didn't.
And if you examine the knife or look at pictures of the knife?
I've seen pictures.
It's a knife that you have to hit a button to open, correct?
Yes.
Pretty big knife, right?
Yes.
a knife that's common sometimes in those circles with prostitutes and drugs and the danger.
The knife looked like a little tiny, little like 3.5 inch blade. Maybe I was mistaken.
Move in those circles. I don't know whether knives are common with prostitutes or not.
What you're trying to say to the ladies jury is you've never been in a situation where you've had to
his prostitutes carry a Walther PPK.
You were in the federal level.
I've arrested violent criminals, but I've never arrested a prostitute.
Right. That's what I just asked you, correct?
No, but that's what you implied that being at the federal level, I didn't arrest anybody who
He
was
just
dangerous.
kills him. He doesn't arrest
I
him.
asked if you ever arrested someone in a prostitution
And I
type
said, no,
scenario.
I did not.
Right. And so had he seen the knife ahead of time, under your theory of the perceived imminent threat, he could have shot her before he got slashed and be justified.
It would depend on what she did with the knife.
Hypothetically, Mr. Patrick, then he sees her with a knife. He sees a knife coming at her. If he was able to, he's allowed to shoot and use that.
That would be justified, yes.
May I finish my question? He's allowed at that point in time to use deadly force against her before he receives an injury, correct?
Yes.
Okay. And then you also testified to Ms. Pritchard that he's allowed to do that recently right after that, correct?
Yes.
After receiving it. Okay.
A 3-inch blade is plenty. I've worked murder cases where the little girl killed a guy with a 3-inch blade, one stab.
That's more than enough.
All right. Okay. I have a copy here.
But he described it as a very large
You believe in the
knife.
things that you say in your book, right?
I'm sorry.
You believe and adhere to the principles in your book. Okay. You're proud of this book.
Yes.
Okay. And you reference it many times if you testify or if you're trying to form an opinion, correct?
Yes.
Okay. Now, on page 83, it's a section that you list called irrelevant factors, right?
I have not memorized the book. I couldn't tell you if it's on page 83 or not.
May I approach the witness, Your Honor? May. For the record, it's just for identification purpose, Defendant's Exhibit 22. Sorry about the highlights. Mike.
No, don't worry.
That's a copy. I apologize. That's a copy of your book, correct?
Yes.
Other than some of the notes aside as highlighting, that appears to be the same as similar.
Okay.
All right. So on page 83, you talk about irrelevant factors, right?
Yes.
The first irrelevant factor is the subject.
Oh, good God. I think I have that book on my bookshelf.
Correct?
Yes.
It doesn't matter what the officer thinks, correct, in terms of the subjective intent.
Yes, I think I had that same conversation with Ms. Pritchard.
And Graham v. Connor explicitly prohibits that, correct?
Yes.
Okay. And so the second one factor, irrelevant factor, is the subjective intent of the suspect, correct?
Yes.
And there you say not allowed. It doesn't come into the analysis of whether or not force is reasonable, correct?
Correct.
It's an irrelevant factor.
Yes, because it can't be known.
Right. So, and they are irrelevant. And you've also testified and given a quote, or in that book, I'm sorry, an officer's intent is irrelevant because the standard is reasonableness. The standard intent is irrelevant. The suspect's intent is irrelevant. And I quote, because it requires very little mentation to be dangerous. Even a rattlesnake is dangerous, but does not possess the requisite mental capacity to be prosecuted for homicide. You've said that in your book, correct?
Yes.
Okay. So the intent doesn't matter for the suspect, correct?
Yes, it's not. Because it can't be known.
It's an irrelevant factor.
Yes.
Okay. However, in your report, you refer to intent of Ms. Castleberry in your report. Do you have your report there, sir?
I do.
Okay.
Not just because it can't be known, because it doesn't matter. It doesn't matter. You could have two people both thinking they're acting in lawful self-defense.
The first sentence there, sir.
Yes.
Castleberry did not believe he was a police officer, right?
Yes.
You're inferring intent there, correct?
I thought I was just repeating what she was saying. I mean, it's evident from the video that she didn't think he was a police officer from the soundtrack.
You're an expert that testifies all over the country, and you're an expert that your words matter in your report. And your report says Castleberry did not believe. You're making a determination in your mind that she didn't believe him, correct?
I did, yes.
And that's exactly opposite what you say in your book. An irrelevant factor, correct, Mr. Patrick?
I don't, intent to cause harm is unknowable and irrelevant. A rattlesnake is dangerous, but can't form the intent to hurt. The fact that she didn't think he was a police officer was manifestly obvious to me, and that's why I mentioned it.
Okay, obviously to you. It manifests obviously. Let's talk about that for a second. So were you aware that she had a warrant out for her arrest on August 23rd of 2018?
After the fact, yes. I mean, after I've looked at the incident, yes.
Well, sir, you wouldn't know it before the fact because you didn't get it until about a year or two later, right?
Correct.
So were you aware that she had all sorts of high amounts of narcotics in her system?
I wasn't at the time. I have since been aware that she was on.
I'm having problems with at the time. What do you mean at the time?
That I wrote this.
So you wrote that without knowing that you had the case file with you, correct?
I did, yeah.
You had the coroner's report, correct?
Yes.
In the coroner's report, there's a toxicology part that says high levels of cocaine, fentanyl, and a veterinary drug, correct?
Yes.
So when you wrote that report, you didn't even know that she was on that stuff?
No, I had seen the report.
You just told, ladies and gentlemen, that you didn't see that stuff when you wrote the report. You found out after. Had you known that before you wrote the report, you probably would have included it, right?
I would have, yeah.
Might explain non-compliance, correct?
Might have.
Might explain why she resisted so hard so she doesn't have to go to jail because she's dope sick, right?
Might have.
Might explain why she tells him on the audio tape going to that direction, I got to score some dope, right?
Yes.
Okay. So had you known all those things, you probably would have said, geez, the form of noncompliance, her irrational behavior, all those things might explain why her manifest belief that he wasn't a police officer, correct?
I might have, but the fact that she was on dope doesn't mean that she was more predisposed to disbelieving his status as a police officer. I've never denied that he had the authority to arrest her.
The officer didn't know she was on drugs either. But
we're talking about her physical actions towards him, what he perceived, correct?
Yes.
You indicated that you believe in your report, you said her intent, Donna Castleberry, did not believe he was a police officer. Had you known that she had a warrant out, and in the state of Ohio, then I think in other testimony I've seen, when there's a warrant out, you have to take him in, right? There's no discretion.
Yes.
Did you know that there was a warrant out for her when you wrote the report?
Yes.
Okay. So because there's a warrant out, because she has a drug system, it probably makes sense that she doesn't want to be incarcerated, correct?
Yes.
That's a reasonable thing to believe, correct?
Yes.
But you didn't take that into your consideration of her belief whether or not he was a police officer, correct?
No, I did not.
Okay. And then in terms of you mentioned on direct something about the fact that he was undercover, right? Led to some issues that he was ill-equipped to do, right?
Yes.
Okay. Isn't it true, sir, in that same deposition that you told someone let me just ask you, would you agree with me that whether a police officer is in uniform or undercover, it does not factor into the decision to use deadly force?
Correct.
Doesn't matter if a person was working undercover or not without his badge, correct?
Correct.
That has no bearing. And you testified that before under oath, correct?
Yes.
So all this intent about whether he had his badge or not badge, or whether she believed him, that doesn't matter according to you and your prior testimony, correct?
I wouldn't characterize that as intent, but no, it doesn't matter.
You just said she didn't, you believe her intent was that she didn't believe he was a police officer.
I think that was her belief, but there's no intent there. I mean, intent implies some planned action, some intended goal.
The intended goal was not to go to jail, right?
I think, yes.
Okay. And so so we've talked about the irrelevant factors of the intent on each party, correct?
Yes.
Now, you would agree with me that officers are trained, and I think you said a little bit of this, officers are trained not to injure, correct?
I'm sorry.
Not to injure, correct?
Not to injure?
Officers are trained when they shoot not to injure somebody.
You can't shoot somebody and not injure them.
Sir,
maybe you need to
not to merely injure, not to shoot
Is that
to
what
wound.
you mean?
There you go. Yeah.
Well, say that. You can't shoot somebody fatally or not fatally without injuring them.
Sure. But a wound is injury, correct?
Yes.
Okay.
The tide has
officers aren't trained to
turned.
wound somebody, right?
They are trained not to shoot to wound. Yes.
Officers are trained not to kill somebody, correct?
They're trained, the intent is not to kill, but yes, they are trained to shoot at the center of what they see.
And they're trying to make the suspects incapacitated so that threat stops, right?
Correct.
So you would agree with me that officers are not trained to kill somebody.
I agree.
They want to avoid the Amber Geiger problem here, where she testified, yes, I meant to kill him.
I want to switch gears a little bit. You mentioned about some law enforcement concepts with Ms. Pritchard. You would agree with me that officers are not required to engage in a verbal warning when using deadly force, correct?
Correct.
They're not required to, and that's in your book on page 226, right?
Among other places, yes.
Okay. And you also indicate that verbal warnings are notoriously ineffective in resolving physical confrontations, correct?
Yes.
Okay. However, on page 5 of your report, if you want to go to there, the third paragraph, first sentence.
Yes.
You criticize Mr. Mitchell for not giving a verbal warning, even though it's not required.
Yes, I'm noting. It's unusual for officers not to issue verbal warnings.
Well, it's not
They're
required.
it's not required, but it is unusual.
And in your own opinion, you just said that it's, quite frankly, not very effective, right? Notoriously not effective.
It is.
Okay. I want to talk in terms of eminence and the perceptions of a law enforcement officer, okay, in terms of their training with regards to lethal force being used against them, all right?
Okay.
Tell the ladies and gentlemen of the jury what the lethal reach concept means with a knife.
I'm not sure I've used that term.
Okay. Have you ever testified that a person's lethal reach is well beyond their arm's length?
Yes, a person with a knife is dangerous beyond arm's reach.
Wasn't that the question I just asked?
Your inartful terminology.
Oh.
Okay, so let me try if I can get it correct. The concept of lethal reach means that it is much further than a person with a knife extending their arm, correct?
Again, I think we're talking about the same thing, but a person, because of the action-reaction cycle and because of the individual denial and physical delays, a person with a knife can be dangerous. In other words, get to you and injure you with the knife far beyond arm's reach.
Distance and time matters.
Yes.
The attack can reach the harm of the victim regardless of the victim's reactions and responses, correct?
Yes.
Okay. And lethal reach, actually, you use and define it as distance and time within the attack can reach and the harm the victim regardless of the victim's reactions and responses, correct?
Yes.
It involves the physical surroundings of the event that it occurs in, correct?
Yes.
Okay. So in this situation, were you able to go out and view the car?
I have not seen the car.
And your report is dated?
I mean, I've seen photographs of the car, but I've not. The report is dated June 28th, 2020.
June 28th of 2020. So 21, 22. So roughly 34 months have gone by and you didn't go see the car.
I did not.
Okay. Do you have the measurements off the top of your head of the car, the inside of the car?
Not off the top of my head, no.
Did you review any measurements?
Just what was in the file, the forensic.
If I told you there's no measurements in the file, would you disagree with me?
No.
You just look at the pictures, correct?
Yes.
Okay. Is it fair to say that entire encounter, that the two parties were never outside of an arm's length away from one another?
Yes.
Okay. And the closer the proximity is to somebody, the more dangerous the suspect is to the officer, correct?
Yes.
Now, you're aware after reviewing my client's written statement and testimonies that my client believed that when he let go of her arms, that she still had the knife, correct?
Yes.
Okay. And that's a reasonable thing to believe, correct?
Yes.
Okay. And then, as indicated, Ms. Castleberry came towards him to get in next to him, correct?
Yes.
So if my client had a reasonable belief that she still had the knife when she was in the back seat, it's reasonably for him to perceive another imminent threat, correct?
Yes.
May I have a moment?
This is the stuff that matters. Not her belief.
Carla, could you read back that question and answer for me, please?
And real quick here, we do have a little bit of an update from the trial. They started about an hour ago. This is the prosecution's last witness.
Oh.
They rest after this. They do their usual motions. The defense does their usual motions. And then right now, as of 2 minutes ago, the defendant has taken the stand.
Okay. Well, this is not a great witness for the state. I mean, he's providing the raw materials the defense needs here.
Yeah, his opening comments, his opening during direct was was okay. The initial statements, but he's just getting dismantled here. It's not looking good. Do you think this is a problem, Andrew? I mean, with this guy who's allegedly testified in over 200 federal criminal cases, when you're the hired gun expert, you're gonna be contradicting yourself at some point. Is it like a market saturation problem?
Well, no. First of all, you shouldn't be contradicting yourself. I mean, you should be working from a base, because your view, your understanding of the law and the dynamics of a fight shouldn't change from case to case, right? You're testifying as an expert after 20 or 30 years in law enforcement. Your views should be pretty concrete, and you're just supposed, as an expert, you're supposed to show up and just tell the truth as you see it. And that shouldn't change from case to case. If it does change from case to case, if you are customizing your conclusions based on the party who's paying you, yeah, then it's going to vary. And then you're going to be caught out in inconsistencies and you're going to have, considerable damage. when you get on cross-examination. But it doesn't have to happen that way. If it happens that way, it's because the expert made that possible. Now, that happens for sure because some experts do make that possible. They know they're only going to get paid. Listen, my legal practice is a consulting practice, essentially an expert practice. I know I'm not. When we get calls in my office and I take a preliminary look at the case and I say, listen, this just doesn't look like self-defense at all. We don't get paid. We don't get retained for that case because they know I'm going to write my report is going to be damaging for their client. So they just say, thanks for your opinion, your preliminary view, and they walk away. If I was more interested in the money, I would take all those cases and just customize my report for whatever the client wanted. But I won't do that. Experts shouldn't do that. When they do that, they run the risk of getting caught up on impeachment on cross.
And it only takes, especially a trial where you get seen nationally and you're on TV and everybody in the world sees that you're a hack. That kills your business right there. So,
right. Yeah, if only because they know that your hackiness is going to be exposed if they retain you for their case.
Yep.
Okay, and we have some misunderstandings here. The guy came off as a creepy John. There was a guy in the area kidnapping prostitutes too. WTF? Well, even if he did come off as a creepy John, that still doesn't mean he doesn't get to defend himself if she attacks him with a knife for being a creepy John.
People get confused. They think because she may have had reason to believe he was a bad actor, that he therefore doesn't have a privilege to defend himself. That's not how it works, folks. These are two independent analyses.
And that's, what she believed has nothing to do with whether he has a right to defend himself. The standard is what he believed, what he thought, and whether that was reasonable belief or thought. If you don't like it, I'm fucking sorry. That's the law. And that's the standard you have to judge it by. Mac Turner, chill out and be respectful of Jeff's guest, please.
Oh, it's okay. He's just hating on me, but it doesn't bother me a bit. It's fine.
I think Andrew can take care of it.
I don't care. Just to think that someone would waste her energy doing something like that. It's pathetic. But
I'm concerned more for Mac Turner's well-being in this particular exchange than Andrew's.
So, but the important testimony here is this expert for the state is saying the things the defense needs. A knife is a deadly threat even outside of arm's reach. It's certainly the entire inside of the car is within arm's reach. The entire fight happened inside the car. He'd already been stabbed once. He's privileged to prevent a second stabbing, to use deadly force.
Utah generally subscribes to the 21-foot theory that somebody can advance with a knife 21 feet before you have an opportunity to respond.
Yeah, so that's a reference to something called the Tuller drill, which, by the way, is from Utah. It was Dennis Tuller, who was a police officer in Salt Lake City, who came up with that concept. But the general idea is, and he was a trainer for his police department, so his guys ran into this all the time, right? There's a suspect with a knife. He's a certain distance away. At what point is he close enough to be an imminent deadly force threat? Certainly when he's standing next to you, but presumably at some point earlier, because he can rush with the knife and get on you faster than you can get your gun out. And Dennis Tuller said, well, most of my guys, they can get the gun out and fire a shot in a second and a half, which I think is pretty aggressive, really. Most cops I know can't do that. But he said it's a second and a half for the cop to defend himself. So the question is, how much distance can someone with a knife cross in a second and a half? And that turns out to be about 21 feet. That's where the 21-foot rule comes from. But of course, it's really dynamic. It depends on the circumstances. How's the defensive gun being carried? Right? Dennis Tuller assumed a service pistol and a service holster outside the body. How fast can the other person run? If someone's running downhill, they can cross more distance in a second and a half than if they were running uphill. So you do have to take all the totality of the circumstances into account. But the general concept is someone can be deadly with a knife, even if they're not standing right next to you at some greater distance. And certainly within the confines of a car, it's well within that distance.
And that's just really the thing that needs to be emphasized is what she was thinking has no bearing whatsoever on whether or not he was justified in doing it. The state has to prove that he had the intent to either murder her, to kill her, or that it was at least a voluntary manslaughter, a heat of passion, an instantaneous thing. And it's looking pretty grim, especially if this is the last witness. But let's
and folks, this whole notion about he intended to kill. So when you're using deadly force in self-defense, you're not intending to kill. You're intending to stop the threat. Death is a reasonably likely outcome of the use of deadly force in self-defense. But if you neutralize the threat and the person is still alive, you don't have a privilege to then kill them. So the point is not the killing. The killing is inconsequential to the question of whether or not the use of force was justified. That's not the goal, is to kill them.
Yeah. And that this is what you have to work with, people, within the scope of the law. What you want the law to be, what you hope is considered, doesn't really enter into it. Is what is the law and what are the standards? And these are the standards that you have to work with. And who's someone said that, oh yeah, Jeff's channel should be called Boats and Hose. I just want, I think I want to, I would name it after Gary Hart's boat, the Monkey Business. Let's just call it the Monkey Business. But all right, let's get back to this guy. And Megan Fox here throwing up her comments that she doesn't think it's been proven that there was murder committed. Megan, I hope your mother recovers. I know your mother's going through some health crisis. You were mentioning here on Twitter. Bless her. I hope everything goes very well and they get that under control and you get there as soon as possible. Thank you for joining us in the midst of all of this that's going on. Deeply appreciate it.
I saw someone asking about manslaughter. What are the elements of manslaughter? Generally speaking, the elements of manslaughter are simply the elements of murder. But then there's a mitigation, generally referred to as adequate provocation. It could be a fight. It could be some kind of circumstances that creates an emotional state that is said to strip you of the specific intent required for murder. It becomes a hot blood killing as opposed to a killing in cold blood. And because of the emotional circle, and often a fight is typical. So two people are in a fight, one of them kills each other. It's different than if you just walked up and shot the guy in the back of the head while he was walking down the street. The circumstances of the fight act as adequate provocation to mitigate what would have been murder to manslaughter.
Well, let's watch the final bit here of his cross-examination. Where are we at? Which screen is it? I seem to have removed the screen. There we go. Nope, we don't want to remove it. We want to share it. Not that way. This way. Old habits die hard.
So my client had a reasonable belief that she still had the knife when she went in the backseat. It's reasonable for him to perceive another imminent threat. Correct answer, yes.
That's what they're trained to do, right? To perceive that's reasonable for him to believe that, correct?
They are trained to recognize circumstances and suspects and what they do and respond accordingly. Yes.
So at that point in time, when he gets the gun and starts to fire, you're saying that he's not justified? You just said that it's reasonable for him to believe that she's an imminent threat as she goes from the side to the back.
Yes, and then things change. The circumstances continue to evolve.
Let's talk about things change. You can't see anything in that back seat, correct?
Correct.
You don't know what she was doing in that back seat, correct?
Correct.
Have you reviewed the paths of the bullets?
Yes.
Okay. One is going upwards to the left, correct?
Yes.
One is going downwards to the right, correct?
Yes.
One is flat, right?
Yes.
That's consistent or corroboration of objective stuff that the person's moving around, the target's moving around, correct?
Or it's evidence that the police officer is firing unaimed shots from an awkward position where he can't bring his sights to bear.
Not the question I asked you, but I appreciate the answer. The question I asked you is that the different angles of where the bullets are going is common sense consistent with the target might have been moving, correct?
That is a possibility, but the most likely one is that the police officer under stress, when officers get in,
how would you know what's more likely?
Their firearm skills diminish drastically.
So now you're determining what's most likely in these scenarios. Isn't that hindsight, sir?
No.
You're trying to say it's.
I'm looking at the spread of the shots, and that's what I would expect from a severely stressed police officer.
Severely stressed.
In the coroner's report that she had soot and stippling in her leg, correct?
That's a severely distressed cameraman. Jesus.
Be from 0 to 18 inches, correct?
Yes.
Okay. And one of your premises, a premise that you have, is she's just sitting in the back center, right?
I don't know whether she was just sitting there, but
Well, wait a minute.
She's pressed, she's in the back, she's retreated as far as she can get.
Sir, 2 or 3 times in your report, you say as she was seated in the back seat, correct?
Yes.
Okay. If someone's seated in the back seat, let's go into that premise, right? Now, in order to get a wound in this part of your shin, you see where I'm pointing?
Yes.
That bullet came out of the calf, right?
Yes.
And then it went up into the thigh, correct?
Yes.
That would be impossible to receive that wound if you were sitting in the back seat, correct? The bullet would have left the calf and went into the seat that
It
they're
would
sitting
depend
in.
on where her leg was and how it was bent and what, but I'll guarantee, I'm sure she was still sitting in the back seat, even though her legs may have been bent or moving.
Exactly. So you don't know where she was and if she was sitting. You don't know if she was standing up, hunched over. You don't know, correct? If she had the knife and was swinging at him in the back, correct?
I don't know that.
That's reasonable. That could have happened, correct?
My review of the circumstance, no, but it could have happened, yes, but I don't think it's likely that she was swinging the knife at him from the back.
And is there anything in Graham v. Connor and State v. White that gives an expert the authority to say, I don't think it's likely, sir? You've never, that's not in Graham v. Connor, it's not in State v. White, correct?
No.
There is no standard that says it's probably the most likely thing because you're speculating about everything, correct?
No, because I'm rendering an opinion based on the numerous shootings and the analyses I've done. It's I'm not a Graham v. Connor participant, but I'm taking the standards and trying to explain how they are applied and rendering an opinion.
What this means is if you don't know what he's doing, there's a reasonable doubt. There's a doubt as to what happened. So you have to let him go if you don't know what he's doing and you don't know what she was doing.
Well, keep in mind, the defense has to prove self-defense here by a preponderance.
You have the task of determining what happens in a car that you can't see, that you don't know, that something's more likely than the other. That doesn't exist in any analysis regarding the case law, correct?
Correct.
You're making that up, correct?
Making it up?
That's hindsight, correct?
That is applying my judgment and experience to what is available in the forensic record and coming up with an opinion.
It's all hindsight.
You read in my client's statement that he believed as she went from the back seat next to him that she was still a threat and she was grabbing her arms, moving her arms, kicking and stuff like that, correct?
Yes.
Okay. So that doesn't sit with someone sitting in the back seat, correct?
I didn't imply or say that she was sitting there passively. That's quite possible and likely she was moving. I have no question that she was moving her arms and legs.
Let's talk about the knife. You make a logical inference that the knife was recovered from the driver's side front seat. So therefore, at some point, she abandoned the knife. That's what you said in your report, correct? Yeah. You have no idea when that occurred, correct?
Correct.
You have no idea how that occurred, correct?
Correct.
You're making a huge assumption on that in an inference, correct?
I'm making a logical inference, right, as I said.
And you're trying to say that because of based on what you heard from the audio tape, that she was pleading or stopping her attack, correct?
Yes.
Okay. And you can't say even close that my client heard that, correct?
I cannot.
Have you been inside of a vehicle when the weapon's fired?
Yes.
Okay. And how did that sound?
It's loud.
You can't hear, right? Second shot, third shot, all that has damage to your ears, correct?
It stuns your hearing,
okay.
Yes.
So we've had officers already testify, sir, that they can't hear that type of stuff. That's not unreasonable, correct?
No.
Okay. But you rely upon her statements and assume that he heard them, correct?
I rely upon her statements because she said them. Now, I don't assume that he heard them, but it is part of the objective analysis you have to do to look at all the factors and the circumstances.
And nowhere in your report did you, in your objective analysis, did you say, hey, by the way, I'm not saying that Andrew Mitchell heard these. You didn't address anything on the other side, correct? With regards to that.
With regards to him hearing it, no.
You didn't put anything in there, and that's basic common sense, correct?
I can't answer whether that's basic common sense or not.
Using your own words, it's the most likely thing that he didn't hear it, right? Based on the trauma inside of a car with a gun going off 6 times, correct?
Quite likely.
Most likely?
Wow.
Most likely.
More likely than not.
Oops, that was a bad thing to say
for
him.
Well, it should have been in his report. A balanced report would have included that. It's relevant whether or not the officer heard her.
You would agree with me that when she was armed with a knife, she's definitely an imminent threat, correct?
Yes.
Okay. You would agree with me that she continued to fight, she continued to resist prior to the slashing with a knife, correct?
Yes.
You would agree with me that she's the aggressor, correct?
She's aggressively resistant. Yes. I mean,
she's elevating the force, correct?
She is elevating resistance, yes.
Okay. So when you make arrests in general, when you have probable cause and you have those elements, is it fair to say that the best arrest is where they don't know that you're an officer until you put their hands on them, correct?
Oh.
Yes.
Okay. So what you just said was the best use of force to lawfully arrest someone is if they don't know you're an officer and you put their hands on them because that's the quickest way to ensure the safety of both, correct?
Yes.
And you would agree with me that you don't have to announce yourself as a police officer in that situation, correct?
Yes.
Okay. So those are the best ways to do that, correct?
Yes.
And with regards, now, I believe that in a situation like this, where you have 6 shots, right?
Yes.
We can't tell the order of the shots.
You mean as far as where they hit?
Yeah.
Yeah, no, we cannot.
We can't tell where shot 1 went or where shot 6 went,
No.
right? There's no possible, more likely, or anything like that, correct?
No.
Okay. And however, when someone receives a wound, as Ms. Castleberry did, receives the infliction of a gunshot wound. Well, let's keep it general first. I apologize. In general, when someone receives a gunshot wound, they can still be lethal, correct?
Yes.
They can be lethal because their body takes over, and the things in their body, the survival to survive kicks in and makes pain.
Yes, I agree, but it's more complex than that. They may be unaware they've been shot. They may just have the will to
There's
fight,
still a threat.
but there is,
That's the point.
Yes, people can receive a mortal wound and still be dangerous until the effects.
We had
of the
a
wound
military,
accumulate
U.S.
to the point
military
where
guy was
they
shot 27
overcome
times and
mental
still
or
went on to
physical
kill his
disability.
attackers.
Yeah.
Unfortunately, he recently
Depends on where the wounds are inflicted.
ended himself.
And so just because someone receives potentially what's a mortal wound doesn't mean that they can't, at that point in time, still be a deadly threat.
That's correct.
Now, let's talk about the cadence, okay? Well, let's talk about the cadence, okay, of the shooting, correct? Now, a lot of the stuff that you rely upon when you say an officer can shoot in 4 to 5 rounds in a second, that's what you said, correct?
Yes.
That's based on studies in a sterile environment, correct?
That's based on actual shooting incidents.
Sure, a combination of both, right?
Yes.
There are studies that are done in a sterile environment to see what the reaction time is and the cadence time, correct?
Yes.
There's also review of cases in which an officer is fired a certain amount of time, correct?
Yes.
All right. In this situation, would you agree with me to the fact that Mr. Mitchell was slashed and received 34 stitches of immediate surgery and blood transfusion, that probably would have affected how long it took him to pull the trigger, correct?
With that hand.
Correct. Well, you read his statement, right?
Yes.
And he tells you in a statement that he tried to fire with that hand, right?
Yes, and he fired with the other hand.
So my question is, sir, someone with that type of injury is not going to be able to fire 4 rounds in a second, correct?
Correct.
Okay. So there's going to be a delay from one round to another. Or as you put it in your report, a pause. That he paused. He deliberately paused. That's how you phrase it in your report, correct?
Can you pause it a second, Jeff?
He did pause. Yes.
So, folks, just from my own experience shooting competitively on a national scale for 15 years, where lots of the shooting, most of it's done with both hands on the gun, some of it with one hand, your strong hand on the gun, some of it with your weak hand on the gun. You can shoot almost as fast with one hand as you can, your strong hand, as you can with both. When you go to your weak hand to shoot, it's much, much slower. Just like we're right or left-handed, right? It's easier to write with your dominant hand than with your weak hand. All your reflexes, your coordination, everything slows down if you're shooting with your weak hand. And I presume this guy was shooting with his weak hand. So he's not getting 0.2 second splits, 5 rounds a second out of that weak hand on target. It would also explain, by the way, the crazy directions of some of the shots. You just don't shoot as well with your weak hand, setting aside the stabbing, the 34 stitches, the need for a blood transfusion. Even if he had suffered no injury at all, he would be much less coordinated and much slower firing with his weak hand than a strong hand.
There you have it.
You don't put anything in your report. You don't talk about the.
Bring up the video. Where'd it go?
Saying, hey, you know what? He was injured, and when he first tried to shoot, he shot with his injured hand. That's definitely going to slow it down, correct?
Yes.
And how long depends on how severe the injury, correct?
Yes.
How fatigued he is from the struggle, correct?
Yes.
If he has any breath left while after being choked, correct?
Yes.
The trauma of the event, correct?
Yes.
Some people, it might help them shoot faster, right?
Yes.
Some people, it might slow them down, correct?
That's unusual. That would be unusual.
that an injury of 34.
No, that people would, the stress of the, you were talking about the stress of the incident slowing them down. And
people react differently to that stressful situation.
They do.
The times are differently, right? So then he switched the gun from his left hand to the other hand, or the injured hand to the other hand, correct?
Yes.
You don't know which one's his dominant hand, right?
No.
You don't know which one he trains with, right?
No.
You don't say any of that in the report, do you?
No.
So then the fact that the gun goes from one hand to another, that's going to cause a delay in the cadence, correct?
Yes.
Okay. Then trying to shoot at a moving target may cause a delay in the cadence, correct?
Possibly.
Okay. So you never put any of those things in your report when you told ladies on the jury about the 11 seconds, right?
I did not.
Okay. Now, you wrote about knives, right? You remember writing this? That a person with a knife would win every time against an officer who is holstered within 21 feet, correct?
Yes.
Okay.
Tool or drill?
I mean, in context, could get to the officer and injure him before the officer could bring his weapon to bear and fire a shot.
And you specifically said 21 feet, correct?
Yes.
In that case. So you're going to say a person with a knife is always going to be able to injure or get to someone before the officer is going to be able to unholster their stuff, correct?
Yes.
Right. In this situation, my client was seatbelted in the front seat, correct?
Yes.
So my client at some point had to undo the seatbelt, correct?
Yes.
Reach for his holster, right?
Yes.
And at no time was she ever away. Miss Castleberry was never more than 3 or 4 feet away, correct?
Yes.
Let's talk about the door, okay? The door being open. I understand that when you review this after the fact, it's clear to see that the car door was open, correct?
Yes.
In every single statement, in every single thing, you understood that my client believed that the door was shut.
Yes.
Okay. And so the analysis has to be from his perception with regards to that, okay? Right?
But you can't ignore what you see. That's
Okay.
objectively
Absolutely.
apparent.
So was it objectively apparent to him when he was in the car that the door was open, Mr. Patrick?
I can understand that he wasn't aware of it, but he had to open it.
And do you think he opened that based on, hey, geez, let me open the door and do this. Let me do this. Or do you think that he was reacting to a deadly threat? Okay. That's probably more likely, right, sir?
Well, I think opening the door was definitely a reaction.
Right. So the fact that he didn't know the door was open, you have to take it from his point of view, correct? That's a fair statement.
It's understandable, as I said, but you have to look when you examine and assess the incident. You have to look as to whether that is a mitigating factor or not.
Of course you do. But in my client's mind, he did not know the door is open. So you can't take cover if you don't know the door is open, correct? You can't reposition yourself if you don't know the door is open, correct? It's okay to say correct.
Yeah,
Okay.
If you open the door, I mean, I understand he didn't realize it was open, but to say he couldn't take cover would imply that he couldn't open the door. I may not have thought of it. That's fine. I understand that, but he could have.
In order to take cover, you have to know the door is open, correct?
Or open it.
Correct. But he can't, if he believes that he's in an enclosed space, is it reasonable to believe that Donna Castleberry is more of an immediate threat, correct? Imminent threat.
Yes, in that closed space.
Okay. So you're not saying he's lying that he believed the door was closed.
No,
right?
I'm not.
You're just saying, hey, as I see that, the door is open, right?
Yes.
You realize that when he had his first interview, he didn't know that Donna Castleberry rolled down the passenger side window, right?
Yes.
You saw that her put the handcuffs out the window, right?
Yes.
That's her resisting arrest. That's her escalating the situation, correct?
I've agreed all along she resisted arrest.
And she escalated the situation,
Yes.
correct? And you've testified and you've written in your book many times that the best use of justified deadly force is preemptive in nature, correct?
Yes.
Okay. Because if it's timely enough and effective enough, the goal there is to prevent the risk of imminent injury, correct?
Prevent the risk of actual injury.
Right. Here we have an actual injury, correct,
Yes.
Mr. Patrick?
Yes.
And it wasn't prevented, correct?
No.
And it's reasonable for him to believe that he's going to have another injury, correct?
Yes.
So Ms. Pritchard asked you, your analysis of deadly force, the law enforcement officer must look at what the officer knew or reasonably believed at the moment the decision was made to attempt to use deadly force, correct?
Yes.
So let's apply it to here. At that point in time, he knew that Annie Mitchell knew that Donna Castleberry had resisted both verbally and physically.
Yes.
He knew at that point in time that she had committed a felonious assault on him.
Yes.
Okay. He knew at that time that she had seriously wounded him, correct?
Yes.
He knew at that time that he had been the recipient of being choked and almost losing consciousness, okay? Right?
Yes.
And he knew at that time that she continued to use force against him in that struggle, correct?
Yes.
And he believed at the time that when he went to use deadly force that the car door was closed, correct?
Yes.
In deadly force standards, sir, I think you said it.
Thank you very much, defendant, witness.
The imminent fear of great bodily harm, correct? That's the first prong.
I'm sorry.
The deadly force standard that you opined to earlier in the direct. First prong, a subjective belief that the officer has an imminent fear of great bodily harm, correct?
Yes.
Okay. Second prong, that the decision to use deadly force is based on reasonable and totality of the circumstances, and it's judged from the perspective of a reasonable police officer in the shoes of Andy Mitchell of what he knew at that time, believed at that time, and the totality of the circumstances, correct? Okay. And that's based on Graham v. Connor, correct?
Yes, that's yes.
And Graham v. Connor gave us 3 factors, right?
Yes, but they're not exclusive. They are.
Absolutely not. But those are 3 things that when you analyze the use of lethal force, you're supposed to look at, correct?
Yes.
Okay. And they were severity of the crime at issue, right?
Yes.
Whether or not the suspect poses an immediate threat to the safety of others, correct? Yes. That person or others. Third, whether the suspect is actively resisting or attempting to evade arrest.
Yes.
Okay. So we have all those three things here, right?
Yes. Okay. In the front seat.
All right. So when you weigh those factors, we have all of those, right?
Yes.
Okay. So then, as you know, because you and Mr. Scanlon testified, and State v. White then gave us an additional issues or factors to analyze, correct?
Yes, although I'm no longer familiar with the case.
Okay. If not, so some of the additional factors are the suspect's demeanor has to be addressed.
Yes.
Whether the suspect was intoxicated or non-compliant, right?
I don't know. I mean, I have no reason to argue with you, but I'm not versed in the White case. I don't know what the final ruling was. I haven't read it. And what you're telling me is so.
Sir, I'm not here to trick you. In State v. White, they list more factors. And the factors that they list that you're supposed to review.
This is the lawyer testifying now. The state should be objecting here.
Of the confrontation, whether it occurs.
This witness doesn't know any of this.
And the possibility that the suspect may be armed and the size and stature of the parties involved. Do you remember hearing those topics?
Yes.
Okay. And may I approach the witness, Your Honor?
Unless it's already in evidence, I guess.
I'm going to approach you with what's been identified as Offense Exhibit 2023. May I approach the witness? This is the copy of Graham v. White, and I turned it to the factors that are outlined. If you just kind of take a look at that.
Graham v. White, is that a different case?
Nope. State v. White. Graham crackers is something different.
I was like, oh, I've never heard of that case.
Yes.
Okay.
And I think that's a sound ruling.
Sound ruling. Of course, because you testified. All right. So let's go over these factors now that are a combination of Graham and State v. White. Okay.
Okay.
So the first factor that we have is, and I have it up on the screen. Is it on your monitor too?
Yes.
Okay. The severity of the crime at issue.
Yes.
Okay. You would agree with me that a knife is a deadly weapon?
Yes.
You would agree it can cause death, serious physical injury, correct?
Yes.
And in this case, it did cause serious physical injury, correct?
Yes.
All right. A felonious assault was committed on him, correct?
I'm sorry, that I would read this as the severity of the crime at issue being the predicate crime that brought in this case, would have been prostitution.
I understand, but there's also, you can view it from the viewpoint of the crime that was put upon the officer, correct?
But that comes, and in terms of making a reasonable judgment as to whether there's risk or not, the severity of the crime at issue here was prostitution, not assault or armed robbery. So all I'm saying, there's no question that danger can erupt.
Well, he didn't shoot her before she stabbed him.
Which is what this is speaking to.
100%. And you explained that to ladies and gentlemen of the jury. If someone was on child support, you would approach them a different way than if you dealt with someone who had been violent before.
They might still assault you, but.
Absolutely. What I'm saying is because the attack already occurred, that's that you know it's a situation that the severity of crime at issue. Make sense?
Yeah.
Okay. Second one, whether the suspect poses an imminent threat of safety to the officer. We have that here, correct?
Yes.
When you view the factors. Whether the suspect is actively resisting arrest or attempting to evade arrest. We have that here, correct?
Yes.
Fourth, the suspect's demeanor we have to look at, correct?
Yes, it was resistant.
Resistant, intoxicated, on high on drugs, correct? Were you aware that the amounts were high levels and that they were taken either 5 minutes before she came into contact with Mr. Mitchell up to 3 hours before?
No, I wasn't aware, but.
Okay, all right. Donna Castleberry's demeanor, she introduced a knife into the equation, correct?
Yes.
So that would go under demeanor, right?
I would put that under item 2, frankly.
Okay.
Not demeanor. I mean, she brought the weapon to the confrontation.
But she's the one that took it and it was hidden. She took it,
Yes.
opened it, and used it.
Yes.
So in defense of others, if you and I are having a fist fight, whoever brings in the knife, that's not allowed, right?
That's not
allowed, right?
Well, I'd prefer it weren't.
Right. We both would. And so her demeanor was she was the violent person at first. She was the aggressor, correct?
Yes.
Okay. So we have that. Whether the suspect was intoxicated or non-compliant, yes.
Yes.
Yes to both. Whether the suspect appears violent or is dangerous, you'd agree with me she was both violent and dangerous?
Initially, for sure.
Initially, for sure.
But once she was in the back seat, that's where we would differ.
We would differ, but you don't know what she was doing in the backseat.
No, neither do you.
But my client perceived she was still a threat, correct?
Yes.
And that's reasonable.
Oh.
Correct?
Maybe.
Well, that doesn't help the prosecution at
The
all.
duration of the confrontation, right?
Yes.
I think you mentioned a couple times in the report 42 seconds or 47 seconds, correct?
I think it went longer than that, actually. But yes, it was a fairly, relatively long duration.
And that confrontation can take a toll on both people, correct?
Yes.
Okay. So we have a long duration. Whether it occurred during an arrest, we have that here.
Yes.
Okay. The possibility the suspect may be armed. That's a definite.
That became apparent, yes. But it was, again, that goes back to the predicate.
I understand that. And the size, the stature of the parties involved, right?
Yes.
Okay. And Ms. Castleberry is smaller than my client.
Yes.
Okay. And in terms of the size and the stature, Ms. Castleberry probably a little more agile than my client, right?
I reserve judgment.
more than me, right?
Yes.
Okay. And my client was in a seat, buckled in a seat, correct?
Yes.
And it doesn't matter the size of the person when they have a dangerous weapon in their hand, correct?
Correct.
A juvenile, the smallest person, or anyone can inflict serious physical injury or death with a knife like that.
Yes.
And then the last one that they tell you to look at, and it's not, the list isn't exhaustive, is the size, or excuse me, the number of suspects. And here we only have one.
Yes.
Okay. So out of there, other than we only have one suspect, all 10, you would agree with me, have been met in this analysis, correct?
Those are all factors that need to be taken into account.
Right. Okay. And you didn't go through all those factors in your report, did you?
I did not.
Mr. Patrick, I appreciate your time and being here, and thank you for welcome to Columbus. Appreciate you.
Watch out for those hookers.
Any redirect?
Bear with me for a moment. I want to clarify something because I think it's been muddled here. When you say moment of decision, we're
Yeah.
talking about the moment you pull the trigger, right?
Yes. It takes an intentional act to fire the gun. That intentional act is the moment of decision.
And I thought we addressed this before, but you mentioned reasonably necessary. You're not saying that's the standard, right?
Correct.
You're applying the
Correct.
Graham standard.
Yes.
Very good. There was mention that you never talked about the choking in your report, but can I refer you to page 5,
Okay.
third paragraph, not the third full paragraph. Take a look
Yeah.
at that and tell me, did you in fact mention the choking?
Yes, I did.
And you start out your report, pages 2 and 3. Don't you just reciting the facts? Would
Yes.
that be accurate?
Yes, it's yes. Merely my determination of the facts and sequence of events and
So is
what
your
happened.
statement on page 2, Castleberry did not believe he was a police officer, stating the facts based on your review?
Yes.
When we're looking at this objective review, we don't have to take Mitchell's word for it, right?
Correct.
We don't have to believe everything he says.
Correct.
The discussion about the choking and those things that occurred, did all of that occur before the moment of decision?
Yes.
So what we're really needing to focus here on is what happened when he turned and began to pull that trigger. What was happening then?
Yes.
And before, from the moment of the purported choking to the moment of decision, was there a time lapse? Did things happen in between that?
Yes.
Is that when the door opened?
Yes. The door opened. She moved into the back seat. That all took time.
Did he undo his seatbelt?
I think he had to.
Did he pull his weapon
Yes.
from his holster?
Yes.
Mr. Collins said to you he never saw the knife. Do you recall objective evidence on that video of him declaring she has a knife?
Yes.
Would that suggest to you?
It may, well, either he saw it or he realized he had been injured and made the assumption it was a knife. Either one would be logical.
Mr. Collins was indicating that she was a threat from the time she cut him and choked him until she moved to the back because she'd been a threat earlier. Was there any evidence that Donna Castleberry had any other opportunity to do anything else in that vehicle?
Not that I saw.
Did she have any choice to move anywhere to get away from him?
That was the farthest point she could get, was the rear seat. The doors were locked and the side doors were blocked.
So if she is a threat because she had cut him and choked him, if she is still considered a threat, in any part of that car, then does she have any chance? Is she a sitting duck?
That's irrelevant.
I keep saying it all depends on what she does. And we have limited knowledge as to what she did. We have the soundtrack.
If he hadn't shot her, she would
Officer Mitchell
had a chance, right? She would have stabbed him.
But she had no escape. I mean, there was no way she could get out of the car. And I do ask what she would have had to have
unless you stabbed him to death and crawled over his body.
How could she manifest that? How could she manifest giving up and surrendering?
That's irrelevant.
And if Officer Mitchell is aware that there are child locks and she's trapped in the car, then would an experienced officer reason that she has very limited options to retreat or surrender?
He should have known. I would think he would have known that. Yes.
She had other options than surrender. She could have continued to stab him.
Until the shooting, I think about 45 seconds. Would you agree?
Yes.
So what happened when he was cut is irrelevant to what happened at the moment of decision when she was in the backseat, right?
The cutting informs everything that follows.
No, it would be highly relevant. If she didn't continue her attack, no, it would not be. And I saw no evidence. I mean, he suffered no further injury. He was clearly vulnerable to attack.
Well, if he was vulnerable to attack, he can defend himself.
Over hands to draw his, get his weapon out. He was vulnerable to attack when he was still in the front seat with her in the back seat, which again goes back to, it might have been more advisable to get out of the car. But he suffered no injury. There's no damage to the upholstery. There's no indication whatsoever that she was lunging and slashing at him with a knife after she moved into the back seat.
So we're using the objective review, and would you agree with me? It's the jury's province to determine factually whether we believe.
I assume that's your dogs, Jeff.
Yeah, I was just looking over there, man. They're having a day over there. Jeez.
That's not me, folks.
Yeah,
no, sidebar.
It's nobody here. It's the dogs snoring up a storm. Wow. It was take your dog to work day today. I had to take him to the vets, and they are just tuckered out. So sorry, folks.
The legal defense here is self-defense. What matters is the defendant's subjective perceptions and whether they were objectively reasonable, not what the woman thought.
What she thought matters not
that's for the jury to review.
Yes.
You're making the objective review and your opinion based upon your experience, looking at the objective factors without assessing whether or not what somebody says is believable or not.
Yes.
Thank
you. God, I'm going to put the dogs outside. That's too much. I can't even hear.
There was discussion about your book and the intent of the officer and the intent of the suspect. And I think you said that that can't be known.
Yes.
How is that different from an officer considering the words of a suspect in an interaction to determine if they're a threat?
Well, officers have to consider what they're being told and assess it within the circumstances of whatever the confrontation is. They're trained to listen to the people they're interacting with or having a conflict with, but then they have to make their own judgment as to whether what is being said is believable or not, because they can't know what somebody has in their head.
That is something the officer is listening to and considering.
Yes, and considering it in light of the circumstances, the event, whatever, as much information and experience with that individual as they've got.
You were referred to toxicology reports and narcotics in Donna Castleberry's system.
Yes.
Was there any evidence that Mr. Mitchell knew that at the time of the offense?
Not that I saw.
Was there any evidence that he knew that she had a good warrant at the time of the offense?
No, I think he was he was asking her if she had a warrant. And if he'd had communications, I'm assuming he would have checked that.
So if he didn't know that at the time, does that factor into the analysis at all?
Not for me, no.
Was there any information that you recall reading where he said, oh, she was acting like a crazy person on drugs?
No.
So that didn't factor into the list of factors here about intoxication or things like that. That be fair? If not known to him at the time.
Yes.
And whether or not she was dope sick or trying to score dope or anything like that, does any of that, if not known to him, affect what happened when she was in the backseat and shot?
No.
Mr. Collins asked you if her intention might be that she was trying not to go to jail.
It well may have been.
Might her intention, based upon an objective review, been that she was trying not to get raped by somebody she didn't believe?
Also,
I don't object to leading sustained. I mean, we approached once, Your Honor.
We approached on a
No speaking objection. Ask the next question.
Might there be more than one explanation than not wanting to go to jail?
Yes.
There was a discussion about warnings not being required, and I think you agreed they're not required.
Correct.
And I didn't quite catch the rest of your answer. I think you said something they're typically seen. What
Well,
was
it's
it?
unusual for police officers not to verbalize in confrontations. That's all. They're not required. They definitely aren't. But officers are trained to give commands. They're trained to tell people what they want them to do.
They don't
And,
give
in
commands
fact,
often
there's
if they're
situations,
under
arrest scenes where there's more than
immediate
one officer
attack.
involved.
They
Sometimes you have too
respond
many
to the
officers
attack.
telling them what to do. It's characteristic of arrests that officers are issuing commands and telling them what to do.
So while something might not be required, it's often seen or it's good practice, or
Yeah.
it might.
Objection, Your Honor, leading. Overruled.
Correct. Yes.
Thank you. You saw the pictures of the vehicle in this case, right?
Yes.
And you saw video of the vehicle, right?
Yes.
And you know what a four-door vehicle looks like, right?
Yes.
Was there any way for Donna Castleberry to be more than 20 odd feet, arm's distance, I forget what the terms were, within the compartment of that car? Did she have any choice to be any further?
Irrelevant.
No, she was restricted to the confines of the car.
Trying to read my own writing, I apologize. Do you recall whether or not Mr. Mitchell said he saw Ms. Castleberry at any point in the back seat with the knife?
Once again, Your Honor, objection, leading. Overruled.
I don't recall him saying he saw her with the knife in the backseat.
I'm pretty sure he knew she had a knife. True.
There was some reference to whether or not Ms. Castleberry was an aggressor, and I believe you said she was aggressive or aggressively resisting.
Yes.
Is that your terms? Do we need to look at the perspective of the person to determine who we want to call an aggressor?
An objection, Your Honor, leading. 5 minutes to sustain that.
Is there a difference between being aggressive or doing something aggressive and being an aggressor?
I think we're getting into semantics. Aggressive people aggress. I don't,
Okay.
yeah.
That's fair. Is there more than one interpretation based upon an objective review of the video?
Again, Your Honor, objection, leading.
I hadn't finished my question anyway.
Let her finish the question.
I'm sorry, Your Honor, what?
The defense really needs to clean up all this aggressor
objective
thing
review of the
because the
video,
cop was the aggressor
Can you,
in making the arrest,
are there,
but
is
that's
there more than
lawful.
one interpretation as to whether or not Donna was an aggressor, if we look at it from a different perspective, her perspective.
I'm not trying,
Am I not being clear?
yeah, I'm not clear on what you're asking, and I don't think the video allows that nuanced an interpretation either way.
If this had not been a police officer in this case, would Donna Castleberry have a self-defense claim?
Your Honor. Sustained.
What?
It was a police officer.
Whether or not Donna was moving in the
That
back seat
question
is a
was
factual
bad for
determination. Would you agree
several
with that?
reasons.
So what she's doing in the back seat is not subject to the objective reasonable standard.
I'm not
Is it-
sure I understand your question.
When we look
kidding.
at what she's doing in the back seat, we're determining that factually, correct?
Yes, but if you make a determination of what she did in the back seat, that has to be part of the objective examination of the decision to shoot.
Agreed.
This is a good window into what happens when your potential star witness is dead.
You were aware of the hand injury he sustained, right?
Yes,
And you still found the shot cadence problematic. Is that what you're saying?
yes.
I'll give her credit. She's trying, but that's about all I could say.
You said, I believe there was no objective evidence he was
Making
cut
it worse.
again, correct?
After he was injured, hand injury, I saw no evidence that he suffered any subsequent injuries, cuts, stabs.
It's because
Irrelevant.
he shot her.
Did you then consider that objective evidence that she was not a threat anymore when in the
Objection, Your
back?
Honor, leading. I'll sustain that.
Why did you find it significant that he'd never been cut again?
Objection, Your Honor. He didn't testify that it was significant. I'm going to overrule that if he testified that.
When you're within arm's reach of somebody attacking you with a knife, you're going to get cut. No matter how adept you are at fending it off or controlling or handling the nut, you're going to get cut, and you're going to get cut more than once. As long as the attack continues, you're going to get cut. You may win the fight, but you're going to
You're
get
allowed
cut.
to defend against what's
Once he let go
about
of
to
her
happen.
hands, he no longer had any. If she were still attacking him with a knife, he would have been cut. As his hands were otherwise engaged, getting his weapon out, releasing his whatever. He suffered no further injury.
And there was discussion of the door being open. And I think you said you see that on the video
Yes,
objectively.
yes.
And the fact that he doesn't remember it, you didn't get to finish some of your answers. The fact that he doesn't remember it, is that significant?
Not to his decision-making process. That's the kind of thing I would look at in a post-incident review and say, look, these are lessons to be learned here. This is what you should have done, but that doesn't speak to the reasonableness of the decision to shoot or not.
And when Mr. Collins went through the list of factors, did you say all of those factors existed in the front seat?
I don't know about all, I'd have to look at them all, but predominantly, yes. The factors that exacerbate the situation and are important to assess the threat, the imminence of a threat, existed in the front seat, yes. And then in the back seat, that somebody has to make a determination what she was doing in the back seat.
And if an officer
What she
gets
appeared to be
tired,
doing.
does that allow him to use any more force than he would normally be allowed to use?
Again, it's a matter of what's reasonable. I mean, being tired or fatigued is a factor that an officer may have to do something that he wouldn't otherwise because he didn't have the strength or the ability to talk to. And if the circumstances support that, then it's reasonable. It's not something you can just say it is or is not. You have to look at it within the circumstances.
So in the end, your opinion here as to this being unreasonable stems from which moment in time?
At the moment he decided to shoot. When she was in the back seat, she was, again, the lack of injury, the lack of signs of a continued attack tell me that she was quitting, she was submitting, she was trying to get as far away from him as she could, and she was giving up.
This is all mind reading.
Throughout your career, you said you've testified against an officer. This is the second time?
Objection, Your Honor. Again, outside.
Let her finish the question.
Against an officer.
This
For an
would be the
officer.
second time you've rendered an opinion like this?
Once again, objection, Your Honor, outside the scope of cross and ask the answer, move to strike.
Overruled.
Yes.
Do you have anything to gain by testifying here?
Objection, Your Honor. Leading.
Money.
Sustained.
Nothing further.
Very briefly, Your Honor.
Oh God, that was
Mr.
bad.
Patrick, couple things that you just said. I want to start with a big concept, you can't see anything that happens in that back seat, correct?
That's correct.
We had a video expert here testify that he can see no details of anything in the back seat.
Correct.
So we have no idea what she was doing in the back seat.
Correct.
We have no idea if she was a threat or not from our vision, correct?
Correct.
But this has to be analyzed from my client's perspective, correct?
And corroborated by what evidence we do have.
Absolutely. And you mentioned something.
Where's the contrary evidence?
I'll get to that. I want to talk about these factors for a second, correct? And I apologize if you thought I was indicating something not. First one with regards to, look at that, I waited. Number 5, whether the suspect's intoxicated and non-compliant.
Yes.
Non-compliant can be as a result of being intoxicated, correct?
Or not. I mean, people are non-compliant or stone cold sober.
Absolutely. But there's a reason that they put those two factors together, correct?
Yes.
Now, severity of the crime at issue. We're not saying, you don't believe that I said that Andy Mitchell didn't try to kill her when he was putting her under arrest, correct?
Oh, of course not.
He didn't try to kill her for prostitution.
Our severity of the crime at issue, again, is the predicate crime that led to the confrontation. The fact that an officer gets assaulted later on is not severity of the crime.
My question to you is, Andy Mitchell didn't try to use deadly force when he was placing her under lawful arrest for prostitution, correct?
Correct.
Now, you were aware of the lead detective in this case, correct?
Yes.
Detective Shepard, right?
Yes.
And you were aware that pictures were taken, and you reviewed photographs of the car, correct?
Yes.
And you were aware that pictures were taken of my client's hand and other pictures at the hospital, correct?
Of
my client at the hospital.
Yes.
And you were aware that Detective Shepard took 2 pictures of defensive wounds on my client, correct?
Yes.
No, but you just said there was no other injury. There were the knife cuts on my client's other hands from the result of this situation, correct?
Yes.
So that goes against what you just told the ladies and gentlemen of the jury, that lack of other injury. He was injured other than the flashing, correct?
He had another injury on his other hand.
Other hands.
Oh, oops.
So are you lying to the ladies and gentlemen of the jury?
I am not.
Oops.
But you didn't take that into account in your analysis, did you? Of the lack of injury, correct?
I did. There was no injury to his arms, to his torso. I think
no injury to his toes or anything like that.
Sustained.
There was, in fact, other injuries he occurred from that knife, correct?
Yes.
And you don't know when they occurred, correct?
I don't.
And it's reasonable to believe that they occurred after the initial slashing, correct?
It's also reasonable to believe they occurred at the initial slashing.
But again, you told the ladies and gentlemen of the jury that one of your big prongs of this analysis was that there was no other injury to Mr. Mitchell, right?
Yes.
And you were 100% wrong about that, correct?
Yes.
I don't agree with you, but he did have a second injury.
But I agree with you.
A minor injury.
My question is, you told
That was bad.
because there was a lack of any other injuries. When you're in a knife, when you're in a struggle with a knife, there should be other injury. There's corroboration and physical evidence of another injury in this confrontation, correct?
Yes.
So you are 100% wrong, correct?
No.
No further questions, Your Honor.
All right, you can step down, Mr.
Thank
Patrick.
you. Thank you.
Even the judge chuckled there a little bit.
I don't know
Wow.
what you brought.
Yeah, that was bad. You
Oh
can't
my
say
God.
there was no injury. There's evidence of other injury, but I still say there's no other injury. I mean, that's just incoherent.
Wow. Okay. My take is the direct examination went really well, as it should have. Cross-examination went very, very poorly for the state. They made it exponentially worse on cross-examination, and then just devastated him on the redirect, and then was just devastated on recross.
I mean, the redirect
Gentlemen?
focused on the Castleberry's state of mind. That's irrelevant to the self-defense justification here. What she was actually thinking doesn't matter. What matters is what the defendant was reasonably perceiving was happening.
Wow, Sean, we have a question specifically for you from Lizbot. What grade would you give her redirect?
I mean, it was just awful. I mean, she tried. Like I said, I'll give her credit for trying, but there wasn't a whole lot she could do with it. And then when the recross happened just now, pointing out like Andrew was pointing out the injuries there. Your expert has sunk himself. There's only so much you can do at that point.
And I see someone in the comments asking why didn't the Castleberry family sue the city? They did sue the city. I think they got $1 million out of the city, if I remember the media reports correctly.
Yeah.
But folks, civil settlements are irrelevant to the criminal prosecution, and they should be. It's a big mistake to interpret a civil settlement as some kind of concession that the officer must have done something wrong, because politicians are always more than ready to spend other people's money to make their political problems go away.
Well, especially if they politically agree with that cause as well.
Well, I will virtually guarantee you that settlement with the city has a little clause near the end that says both sides agree that there is no admission of liability or responsibility for any of the injuries. There's going to be a no admission of liability clause in that settlement agreement somewhere.
And of course, the people settling are not the defendant. They're other people. Yeah. So it's not him conceding anything.
Wow. We're here at the end of this is apparently the last witness for the prosecution. We don't know what order the shots were fired in. No evidence. I mean, was it the last shot that stopped the aggression? Was it the first shot? There's no evidence to that whatsoever.
Yeah, I mean, of course, we can't hear the shots on the audio, but my recollection is I can, I guess there's these clicks or something. We know the shots were fired, over a 12-second period of time? Is that what they said? Yeah. And I can hear her talking during that period of time. So it's not like she was decisively neutralized by shot one and he kept shooting her another 11 times. The early shots were clearly ineffective at disabling her because she's still clearly communicating to him.
And that's, I don't know if you mentioned this before, Andrew, but unless you hit the central nervous system, like the spinal cord or, right into the brain, shooting somebody does not guarantee they are going to stop. It takes a lot to kill somebody, believe it or not, if you don't hit where it matters.
Yeah, there's a Navy SEAL, Mike Day, who unfortunately just passed away recently. Mike Day, Navy SEAL, was shot 27 times in a firefight in 2007 and still killed his aggressors.
The human body is ridiculously resilient. I mean, it doesn't want to stop functioning. But man, that was bad. I mean, that was about as bad as it could get for the prosecution, I think. Especially there at the end, when he's like, "Oh yeah, that other injury that I didn't tell anyone about and I didn't figure in." That was, yeah. Guys, we've got a problem on our hands here. That's it. We know they're going to make the motion for directed verdict. We know it's not going to be accepted because it never is, unless it's like just crazy ridiculous. But
and it's not over. I mean, again, in this case, it's an unusual self-defense case because the burden on self-defense is on the defense to prove self-defense by a preponderance, and the defense hasn't had a chance yet to do that. So you really kind of have to go forward.
And here we are. We are now in today's stream. Gosh, let's see if we can get away with 1.5 speed at the beginning.
Now, I think the prosecution's being dishonest here. They know what was in Castleberry's state of mind. Whatever she was thinking, however justified she thought she was, is irrelevant to this case. He's not arguing I didn't shoot her. He's conceding he shot her. The only legal question here is the self-defense question. And Castleberry's state of mind is irrelevant to the self-defense question, other than how her conduct would contribute to a perception of threat by the defendant.
Oh man, I'm curious to see how his testimony goes, because he's going to be taking the stand here. We're about real time, about an hour and 10 minutes behind, because there's a lot of downtime. You got a couple of minutes here at the beginning, then the directed verdict motion takes about 20 minutes, and then the defendant will be taking the stand.
If she attempts to surrender, how is that not relevant? It's not relevant unless he's aware that she's attempting to surrender. It's his subjective state of mind.
All right. So there wasn't anything there.
And for all the people saying this guy wouldn't come across as a cop to anyone, have you met cops? They don't all look like on TV shows, folks.
They look more like the cops in the comedy shows than the real shows. And I mean, that's kind of the point too, when you're running vice stings. It's like, oh my God, he looks like a cop. Let's not talk to him. Let's not sell drugs or get in his car to give him a blowy.
Exactly.
That's the whole point, is they're not supposed to look like cops.
Everyone have a good evening last night? Yeah, beautiful night for dinner time. Anything further on behalf of the state of Ohio?
Thank you, Judge. At this point in time, we've had three stipulations, one to venue, one to identity, and one to the authenticity of the cell phone record. I have a few more, I think 5 more to read into the record at this time. This is State of Ohio versus Andrew Mitchell, 19 CR 1662, Joint Exhibit 2. The parties stipulate as follows. If called to testify, Sergeant David Sicilian would state that at all relevant times he was employed as a sergeant with the Columbus Division of Police Homicide Unit. He would testify that he has been properly educated and trained and has significant experience investigating various crime scenes, including homicides. Sergeant Sicilian would testify that he was called to help investigate a shooting involving a Columbus police officer on the morning of August 23rd, 2018. Sergeant Sicilian would state that his responsibilities for that case included examining the firearm used and accounting for all rounds in the firearm and magazine, as well as rounds fired during the incident. Sergeant Sicilian would testify that the firearm officer Andrew Mitchell was carrying was a division-issued Smith & Wesson M&P 40 caliber semi-automatic pistol, serial number HTJ-2357, with a 15-round magazine capacity, plus capacity for 1 round to be in the chamber with the magazine full. He would further testify that at the time of the examination, there was 1 live round in the chamber and 9 live rounds in the firearms magazine. He would state that there was also 1 spent shell casing that was above the live round in the chamber and had failed to eject. Sergeant Sicilian would testify that Officer Mitchell also had 2 additional magazines in the trunk of his plain car, both of them containing 15 rounds for a total of 30 live rounds. Sergeant Sicilian would testify.
Okay, for those of you saying audio is low, turn up the audio, etc., etc., etc. It is at full volume. It is full up volume on the live stream on the YouTube panel, and it is also boosted 600%. So this is as good as it gets. Sorry about that. Calling for more volume is physically impossible. It's technologically impossible. What you're going to have to do if you have a volume booster on your end is use it, because my end is tapped out. We are at 600% of full volume.
That out of 46 possible live rounds, Officer Mitchell had 40 live rounds accounted for. Therefore, he would testify that he determined that Officer Mitchell fired a total of 6 shots. Sergeant Sicilian would also testify that he determined that Officer Mitchell was not carrying a backup firearm. The parties stipulate to the qualifications and conclusions of Sergeant David Sicilian.
So stipulated.
Joint Exhibit 3. The parties stipulate as follows. If called to testify, Dr. John Davis.
All right, I'm sorry. It sounded okay before. Yeah, because that was a different day in court. That was yesterday. This is now today. Different audio setup, different people in the court, different shit going on.
Yeah, and there's microphones in the court that are not being broadcast. Like this looks like a microphone in front of this guy. That might be going into the court recording system, but it's not part of the broadcast. His voice is being picked up from some other microphone distant in the room.
Yes.
So hopefully they'll figure it out here.
This is weird because this is the courtroom they use for media, like trials. Down there, they've used it in other cases, and the audio has usually been pretty decent. So I'm surprised this isn't working well.
Yeah, and it started out the same way with the afternoon session yesterday. They about 25 minutes into it, they said, "Oh, we should probably turn our microphones on."
Yeah, I mean the microphone might be on the camera.
Yeah, I mean, there's nothing there. I think this is probably the microphone here that he's just not using. But anyway, talking about it ain't going to solve it.
Daniels would state that at all relevant times, he was employed as a forensic pathology with the Franklin County Coroner's Office. He would testify that he has been properly educated and trained in the field of forensic pathology and is qualified to testify concerning any issues relevant to forensic pathology.
Well, I like this. I like the stipulation of the ME report. I mean, it's not really in dispute. It always bothers me when they just bring the ME in to talk about how grotesque the injuries and stuff. In a self-defense case where you're saying, listen, I said I shot the guy.
As a result of his examination of Ms. Castleberry. In addition, as per the normal course of forensic pathology, a toxicology report is also prepared and attached. Dr. Daniels would testify that Ms. Castleberry suffered 3 separate gunshot wounds causing injuries to the right ventricle and atrium of her heart, the lower lobe of her right lung, subcutaneous tissues, her lower left leg and left thigh, and a fractured rib. Dr. Daniels would state that the cause of death of Ms. Castleberry was the gunshot wound to the chest, which penetrated her heart and right lung, and that the manner of death was homicide. Dr. Daniels would testify that the gunshot wound to Ms. Castleberry's left leg was not a fatal wound. Dr. Daniels would testify that these findings are accurate to a reasonable degree of forensic pathological certainty. Dr. Daniels would also testify that Ms. Castleberry would still be ambulatory, i.e. able to move for a period of time after the gunshots. In addition, Dr. Daniels would not be able to testify as to the order of the shots or of the wounds. Dr. Daniels also would testify that when he gives directions of an entrance wound, the bullet path, and an exit wound, he does that analysis as per the anatomically correct Leonardo da Vinci model. Depending upon the angle of an individual's body position at the time of the event, Dr. Daniels would not be able to testify concerning an exact opinion upon where the gun might have been in relation to the pointing of it at the subject's body. Dr. Daniels would also indicate from his report and testify that there was stippling on the gunshot wound to the left leg. Stippling is normally seen with a close-range gunshot wound of 0 to 18 inches. It can go as high as 36 inches out, depending upon certain circumstances. Stippling is caused from the heat of the materials leaving the barrel of the gun and coming in contact with the skin. It can be prevented by clothing in some circumstances. A gunshot wound entrance can be categorized as close range or an indeterminate range based upon the existence or non-existence of stippling, fouling, or soot. All 3 are caused by heat or materials leaving the gun and coming into contact with the skin surface. However, the absence of stippling, fouling, or soot can be explained by a barrier in between the barrel of the gun and the surface of the wound. Every coroner's report is attached by a toxicology report. The toxicology report measures substances that were in the decedent's system at the time of death. In this case, the chief toxicologist, Daniel Baker, would testify that the levels of fentanyl and cocaine in Ms. Castleberry's system were high levels. The drugs were consumed within 3 hours before her passing. Furthermore, Dan Baker would testify that the following substances were found in Donna Castleberry's system: norcocaine, benzoylecgonine, and methylecgonine, which are metabolites of cocaine, econidine, which is an alkaloid related to cocaine, and levamisole, which is a veterinary drug to treat worms. Dr. Daniels would also testify called to the stand that in many situations when individuals receive a stabbing wound or a wound from a gun, it triggers a chemical reaction in the body of epinephrine, which could lead to a fight or flight situation. The parties stipulate the qualifications, findings, conclusions, and the admission of the autopsy report of Dr. John Daniels and the toxicology report of Daniel Baker, as well as the identification of Donna G. Castleberry as the subject of these proceedings. The autopsy report and toxicology report is marked as State's Exhibit S1 and S2. Joint Exhibit 4. The parties stipulate as follows. If called to testify, Erica Patty, P-A-T-T-I-E, would state that at all relevant times she was employed as a forensic scientist with the Columbus Police Crime Lab. She would testify that she has been properly educated and trained in the field of forensic sciences and is qualified to testify concerning any issues relevant to forensic science, including determinations as to firearms operability and comparisons of firearms, projectiles, and cartridge cases. She would further testify that she performed tests on the firearm recovered in this case, a Smith & Wesson M&P 40, as well as projectiles and cartridge cases also recovered from the scene of the shooting. Ms. Patty would also state that she prepared a written laboratory report as a result of these examinations. Ms. Patty would testify that the firearm recovered in this case, the Smith & Wesson M&P 40, was tested and found to be an operable firearm. Further, she would testify that she macroscopically and microscopically examined the 5 spent .40 caliber bullets and the 6 spent .40 Smith & Wesson cartridge cases. Erica Patty would testify that in her opinion, all of the spent bullets and spent cases were fired from the same firearm, the Smith & Wesson M&P 40. Ms. Patty would testify that these findings are accurate to a reasonable degree of forensic scientific certainty. Parties stipulate the qualifications, findings, conclusions, and the admission of the laboratory report of Erica Patty. That laboratory report is marked as State's Exhibit T1.
So stipulated.
Joint Exhibit 5. Parties stipulate as follows. If called to testify, Miranda Alfiero Smith would state that at all relevant times she was a forensic scientist with the Columbus Police Crime Laboratory. She would also testify that she has been properly educated and trained in the field of forensic sciences and is qualified to testify concerning any issues relevant to forensic science, including determinations as to DNA identifications and comparisons. She further would testify that she performed tests on many pieces of evidence recovered in this case for the purpose of identifying DNA and comparing that DNA to known standards of both Donna Castleberry and Andrew Mitchell. Ms. Smith would also state that she prepared a written laboratory report as a result of these examinations. The report separates what items were presumptive for blood and what items were positive for DNA belonging to Donna Castleberry, what items were positive for DNA belonging to Andrew Mitchell, and what items were positive for DNA from a mixture of multiple individuals. The reports also detail what person, if any, can be excluded as a contributor from the DNA profile. Ms. Smith would testify that DNA can be left on an object by blood or touch from direct contact with the person or indirect contact by transfer from one person to another. She would state that she cannot testify whether touch DNA was left on an object directly or indirectly. Ms. Smith would testify that these findings are accurate to a reasonable degree of forensic scientific certainty. The parties stipulate the qualifications, findings, and conclusions in the admission of the laboratory report of Miranda Alfaro Smith. The laboratory reports are marked as State's Exhibit U1 and U2.
So stipulated.
And Joint Exhibit 6. The parties stipulate as follows. As it relates to count 1 of the indictment, felonious assault is a felony of the first or second degree and an offense of violence.
Yes, so stipulated.
Wow. That saved days.
Judge, with the exception of the admission of the exhibits into evidence, the state rests.
Okay. Ladies and gentlemen, we're going to take a break this morning for about a half hour, and then we have to do some legal stuff. See you back.
The legal stuff takes about a minute and a half.
Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you.
All right.
You guys have everything you're going to want to move into evidence?
Judge, I'll go in as close as I can to alphabetical order here. State's Exhibit A1 through 8 are the BCI photographs. The laser.
Okay, we probably don't need to watch these.
A9 is the, I'm sorry, Mr. Mitchell.
No objection.
R4 is the knife of Donna Castleberry.
No objection.
S1 and 2 are just
Murder. The underlying offense is a felony.
Okay, this is what we wanted to listen to.
Because of a sudden fit of rage.
apartment building.
No objection.
V2 is the enhancement of that video by David Loomis.
No objection.
V3 is the synced up audio and video version that we've shown in court.
No objection.
W is just the audio portion from Andrew Mitchell's cell phone.
No objection.
I believe that is it.
Do we have a clean laptop for them to listen to everything?
We will get one.
Then everything else was stipulated.
Yeah.
Okay. Is there any motion on behalf of the defense?
Yes, Your Honor. At this point in time, procedurally, we would move for a Rule 29 dismissal, Your Honor. First and foremost, with regards to the voluntary manslaughter count, there is, we don't believe reasonable minds can disagree with regards to the concept of sudden rage or fit of passion. Here, there's, it can't be sudden, Your Honor, if it's 47 seconds later. In addition, Your Honor, I think most compelling is the government's own witness, their expert, indicated that officers are not trained to kill. They're trained to shoot to incapacitate someone. And that's the bottom line. And with a voluntary manslaughter, the concept is because of a sudden fit of rage or passion, you try to kill someone. You kill someone because of that. So if the government's own evidence shows and their own expert shows that you can't have the required intent based on your training, then, Your Honor, I don't see how it gets past the Rule 29. The same concept, Your Honor, with regards to the paragraph B, murder or felony murder. The underlying offense is a felonious assault, knowingly cause or attempting to cause serious physical harm with a deadly weapon. Again, Your Honor, their own expert, their own witness opined that officers do not have the intent to kill. They do not have the intent to wound. They do not have the intent to injure. The intent is to stop the threat and incapacitate the person until they're no longer a threat. We don't believe, Your Honor, that they've met their burden at this point in time with regards to the murder. Their own witness basically agreed with me and did agree with me on the record, Your Honor, that Mr. Mitchell would have a reasonable belief of an imminent threat as Ms. Castleberry went towards him, went by him, and towards the back. and that was reasonable to believe based on the circumstances that he knew at that time and believed at that time, and it was reasonable for him to believe that he perceived a deadly threat. That in and of itself, Your Honor, is evidence that shows reasonable minds can't disagree with regards to that. Their own experts said that's reasonable, and that's the whole issue of this case. So we believe that the state has not met their burden at this point in time, even if you view the facts most favorably in light of the state.
Obviously, Judge, I think that if you view the facts most favorably in light of the state, we have met our burden. A couple things. This isn't a trial about whether the training's appropriate or not. It's about what he did in that car. And to just say they were trained that way so it didn't happen is clearly not the focus of this trial. So we have shown what he did in that car, regardless of what he was trained to do, and what he did was kill Donna Castleberry. And secondly, the issue of whether or not that was justified, whether it was reasonable for him to do that, is the subject of justification, which is not a proper subject for the Rule 29 motion at this point, because that's an affirmative defense that comes after our case, and this Rule 29 is simply for whether or not we've met the elements.
Correct.
At this time, I would deny the Rule 29. You guys need a break, and then we need to we'll put him up about 10.
Yeah, so again, this is a weird case, folks, because at the time this event occurred, Ohio put the burden of persuasion on self-defense on the defense to prove self-defense by a preponderance of the evidence. No other state was doing that at the time. Every other state, all 49 other states, put the burden of proof on self-defense on the state to disprove self-defense beyond a reasonable doubt. Ohio has since adopted that majority position. But in 2018, when this occurred, the burden for self-defense was still on the defense to prove self-defense by a preponderance of the evidence. So that's the standard being applied here, because the change in burden was not retroactive in Ohio.
Yep, that is correct. Yeah, and since then, even Ohio's gotten rid of the duty to retreat, so that's very nice as well.
Mm-hmm. And then again, last thing here, Aspen Phone says, sucks, the volume was perfectly fine before the lunch break. Again, it was not a lunch break. That was yesterday's proceedings. We are now in a new day, new audio setup, and hopefully during this little break, they got things squared away. We'll have to see. The defendants are ready to take the stand, but before we do that, a couple of super chats to get through here. Nicholas, Star of Union Rep, labor law guy. After the video/sound, I was convinced he was guilty of murder, but the prosecution has changed my mind to probably not guilty. Well, that's exactly what the prosecution is not supposed to be doing. And I just can't say how much I love this corralled super chat column we have now on StreamYard as of today. This is awesome.
Oh, yeah. Look at that.
Yeah, isn't that great? They just line them all up. They're all corralled.
Just from YouTube?
I don't know. That's all I use. Hopefully it does for other platforms. Boomer Wow. Cops have enhanced rights to violence. I can't cuff someone, but they don't have an enhanced right to self-defense. If Caruth can't shoot 1 second after an attack, this cop can't 10 seconds later.
Yeah, so that's just not good thinking, because you're asking the wrong legal question. The issue for self-defense isn't simply how much time has passed. It's whether the defender, in the moment they decide to fire the shot, has a reasonable perception of a imminent deadly force threat to themselves. In Caruth, he shot a man 15 feet away who was unarmed, who was not advancing on him. That's the difficulty there. In this case, the defendant, shot a woman who had just stabbed him severely with a knife in the confines of a car. And every shot he fired was within the confines of that car. That's an imminent deadly force threat, regardless, as long as that circumstance exists. If it had existed for 5 minutes, he would have been privileged to keep shooting for 5 minutes until the threat was neutralized.
And Drow on, late and catching up. Hello, everyone. Hi. Welcome. Ryan Acorn. The execution of this sting is so obviously unsafe that a reasonable, person should have known not to run it. That's a civil liability question. That's civil negligence there. You knew this was bad. You shouldn't have done it, and this harm was caused. Therefore, you owe me money. In this case, you were saying about $1 million. No, that was the other case. Sorry, or was that this case, Sean? You're muted.
Oh, what? Sorry, I was reading an email.
Did her family brought a civil suit?
Yes.
Yeah.
It was about $1 million, you said?
I think so. Yeah, I said that, but
That
that's
was
just
okay. That was
recollection from the media.
They made some good money out of it.
So that's what that $1 million pays for the fact that someone knew that this was unsafe and ran it anyway, apparently.
And again, this is simply you're asking the wrong question. There's no self-defense for a situation you intentionally caused. Yes, there is, especially for police, because police have a legal privilege and a legal duty to initiate force when they're making an arrest. An arrest is force. So yes, they're creating the situation. And if violence results from the defendant's conduct, they're still privileged to defend themselves. So yes, there is self-defense for a situation you intentionally created.
You're missing one very important word in that sentence. For an unlawful situation you intentionally created, or a situation you unlawfully intentionally created. You have to have the word unlawfully in there.
I think Ryan's point is this idea of like, oh, well, he had his police ID, and they're saying, oh, well, our policy said you don't have a badge. Well, to most people walking down the street, a cop says, well, here's my police ID. Great, that may follow your police procedure. But I think Ryan's trying to argue the police caused the situation where he didn't have a badge. He couldn't, the average person's not going to say, oh, I've seen that ID. It must be legit. Most people would expect a cop to have a badge. Now, that doesn't mean people don't understand how the police operate. But I think that's what Ryan's trying to get at.
I get it, but again, that we're circling back to what Castleberry's state of mind was, and that's not relevant to the self-defense claim here.
And that's true. Yes, it comes down to what he was doing, but that's where I think he's just trying to come from.
Yeah, cops can't kill people just following awful procedures. Actually, they can. That's kind of the illegal procedures, maybe not.
They literally can, of course. I mean, they kill following bad procedures. And then the procedures get revised afterwards, like happened in this case. And then it's a separate question whether or not the killing was a legal killing.
Yes. And, should people be held responsible for those procedures they implement? That's another question.
Yeah, just because something is shitty, bad, and unfair doesn't mean it's illegal or something that some guy should be thrown in jail for the rest of his life for. Boomer, wow, bringing us up with the last one here. Okay, sorry. In between shots is indicative of murder, no matter how practiced you are at justifying police violence. Again,
no.
So what happens if you go, okay, I'm sorry, and you go, all right, let me put the handcuffs on you, and she knifes you in the face again. Then what are you going to do?
First of all, suspects fake compliance all the time and then reinitiate violence against cops when an arrest. They sense they have an opportunity to try to escape again, and they do it again. Second of all, you're presuming that after firing these shots in an enclosed space of a car with no hearing protection, he could even hear her say these words. Mm-hmm. He says he didn't.
And I'm okay. I was looking for the state's own expert witness. They did such an awesome job there a minute ago. He himself said whether he knew she had a knife or not wasn't important, other than to say he should have known he wasn't being cut further or attacked, which you could, as we've just said, you can fake compliance. That's a problem.
Right. When she stabbed him the first time, that's an indication that she's willing to stab him.
I mean, if I wanted to stab him again, I'd say, "Here, no, I didn't. I quit. Come here a little bit closer. let me whisper in your ear how much I quit." But that's where we are. But now they've rested. The prosecution has rested, and it's time for the defendant to explain himself, and he's going to do it.
It's funny. I'm looking at the chat, and the guy who was talking shit about me before, I don't know, maybe one of your mods blocked him or something, or gave him a timeout or whatever it's called. But now there's a second account, a different name, but throwing the same exact shit. And so the guy obviously has come back. Man, you got a lot of free time on your hands.
Now, don't be so harsh with the blockings and timeouts. I don't know what happened, but err on the side of caution, mods. We know we know you guys.
Yeah, don't block anybody on my account. It doesn't bother me at all.
Okay. Well, before we get back into this, let's bring this back up here, and you got a few hours left to participate in this.
Hey, this Saturday, that's tomorrow. Saturday, law self-defense full day advanced class teaches you how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, your property, all in one day, taught live by me, streamed to you at your computer. And if you can't make it, if you have a scheduling conflict for tomorrow, register anyway. We make the playback of this class available to all the registered students for at least a couple weeks. So you'll have an opportunity to watch it or rewatch it at your leisure. Still 25% off bundles. But tomorrow morning is the class, folks. 9 a.m. Mountain Time, I believe. But all the details are at that link, lawofselfdefense.com/advanced. This is the only advanced class for 2023 scheduled. So if you miss this one, it's going to be a while before the opportunity comes back again. Sign up today. Today is the last day. lawofselfdefense.com/advanced.
And Sean, what about you? What do you got to tell us is coming up these days?
Yeah, on Wednesday night, 8 p.m. So it's 8 p.m. Eastern. I have an interview with Matthew Moore. Matthew Moore was a defendant in one of the trials I covered last fall. He was acquitted of murdering his wife, and he's going to be coming on talking about the whole process of going through it, what it was like to spend 15 months in jail, and he'll be there to answer any questions you guys have. So please swing by on Wednesday night at 8, and really, if somebody's the first person to ask him, did you do it, or who do you think did it, or he's going to answer all those questions, and he'll be willing to answer them for you. So I think it'll be a great time, and look forward to seeing everybody on Wednesday night.
All right, and I'm going to be doing this until it's over. So it'll probably be over early next week, it sounds like, or mid next week at the latest. We'll also be doing our usual OJ Thursday, where you can see some really good defense lawyers doing some really good defense work. Maritime Monday, as always, on Monday. Haven't decided what we're going to do yet, but we'll do something. And then I'm going to be having a few guests on as well. We're working out a few things over the next month, and I'll be guesting on other people's channels, and I'll let you know about that. And we'll be talking more about that as we go forward.
Also, hey, Jeff, I have to step out. I have an engagement I have to go to. So,
all right. Thanks for popping on in.
Good seeing you, man.
Have a great day.
Take care. Let's see what defense has to do here. All right. Here's the man, and let's hope to God the audio sounds a little better. We'll boost this up as well.
On the record, 19 CR 1662, State of Ohio versus Andrew Mitchell. Do we need to put anything on the record prior to bringing in the jury?
I don't think so. No, you're
All right, let's go get the jury.
Bring in the jury.
To the microphone. You may inquire.
Thank you, Your Honor. Good morning, sir.
Good morning.
Could you please state your name and spell your last name for the record?
Andrew Mitchell, MITCHELL.
This is the defendant.
Andy, I'm going to ask you to keep your voice up, okay? And if you don't understand a question, please ask me, okay? Okay. How old are you, sir?
I'm 59.
Okay. Where did you grow up?
Delaware, Ohio.
Okay. Where did you go to high school?
Rutherford B. Hayes High School.
What year did you graduate from there?
1982.
Okay. Did you go to any college?
Ohio State University.
Okay. What was your major at Ohio State?
Criminal justice.
Okay. And when did you graduate from there?
1986.
Okay. Are you married?
Yes.
Your wife's name?
Tanya.
Okay. Any children?
We have one child.
And her name?
Cameron.
And how old is Cameron?
Cameron's 7.
Where does she go to school?
Conger Elementary School.
Andy, after you graduated from Ohio State, what did you do?
After I graduated, I helped my father at his business.
Okay. What type of business was that?
He had a car washing business.
Okay. Tell the ladies and gentlemen of the jury about your family.
I have one brother and I have 3 sisters. I'm the youngest, and they're all here with me today.
How about your father?
My father passed a few years back.
So how about your mother?
My mother's still alive.
When did you start at the Columbus Police Department, Andy?
1987.
Okay. Just explain to the ladies and gentlemen of the jury the process for doing that.
Back in 1987, you had to take a civil service exam, score high enough to get into the academy. Then you did physical, make sure you can pass all the physical exams, which I did all. So December of 87, that's when I started the academy.
What do you mean by the academy?
The training academy, where you go and learn all your APATA training, shooting, all the laws, criminal.
So you're trained. use of force techniques at that point in time?
Yes, use of force is also included. We have legal classes.
When you're going through these classes in the academy, are you actually out working as a police officer?
No, you're confined into the academy for approximately 5 to 6 months.
When do you become an officer after that?
I became an officer May of 1988.
Okay. When you become a new officer, tell ladies and jury what the first steps are in that situation.
You're not let go on your own. You have a field training officer. Back then, we only had 2 phases of training, so we had 2 separate field training officers. My first one was 4 weeks, and my second one was also 4 weeks.
Once that's over, are you now a patrol officer?
Yes.
Okay. How long were you a patrol officer?
Approximately 4.5 to 5 years.
What types of police actions or did you have to do while being a patrol officer? Describe that for ladies and gentlemen of the jury.
Patrol is about everything. You do everything. You respond. You're first responded to robberies, burglaries, homicides. You also do accident reports, domestic disputes, anything patrol related.
Okay. When you're on patrol, what are you wearing?
A uniform. Police uniform, white shirt, blue pants, and your badge.
From patrol, where did you go?
In 1993, I went to the burglary unit, which is a part of the detective bureau.
What does it mean to go to the detective bureau, Andy?
It's just a different unit. You wear a suit and tie. You have to go through detective bureau training in order to become a detective.
Is detective bureau training different than you received for patrol training?
Yes.
Okay. How so?
You have to learn how to put a packet together. You have to learn how to interview people, go out to scenes.
And how long were you in burglary?
I was in burglary for 6 years.
Where did you go after burglary?
After burglary, I went to the sexual abuse squad.
Were you a detective in that squad?
Yes.
Okay. Is there different training from the burglary unit to the sexual abuse squad unit?
Yes.
Okay. How long were you in the sexual abuse unit?
I was in the sexual abuse unit for like 2 years.
Okay. And where did you go from there?
From there I went to the vice unit from 2001 to 2006.
Okay. Now, when you're in the vice unit, are you still a detective?
It's not part of the detective bureau. Usually it's called vice officers.
Okay. And in that early period, I think you said 2002 to 2006?
2001 to 2006.
Okay. What were your duties in the vice squad at that point in time?
Mostly we did street prostitution. We also, as a beginning of the internet.
Hey, Steve.
prostitution,
Talk to you later.
We did a lot of that. We also did, in evening hours, we did the boot joints. We also did underage illegal liquor sales for the underage, and illegal liquor sales, period. That's about it.
And was there training when you got to the vice squad?
Yes.
Was that ongoing during the year?
Yes.
Okay. And why did you leave the vice squad? Or when did you leave the vice squad? I apologize.
I left the vice squad in about 2006. I had a partner back then, and since he was leaving, I decided to also leave, just to try something new.
Where did you go to? What squad did you go to from them?
I went right to the narcotics unit.
Okay. And were you undercover or detective in the narcotics unit?
You're a detective, but you're undercover.
When you were in the vice squad, were you undercover or were you in a uniform?
Undercover.
Okay. And from the vice squad, where did you go, sir?
I went to the missing unit.
Okay. Describe that for ladies and gentlemen.
It was the vice, then narcotics, then the missing unit. Mostly we look for juveniles that were missing, but we also look for adults.
He's done a lot of stuff in a relatively short
Were
period
you
of
ever in the
time.
homicide detective bureau?
Yes.
When was that?
I didn't go to homicide until 2012.
Okay. And again, when you go from one squad to another, are you trained as a detective in the homicide squad?
Correct.
Okay. And how long were you in the homicide squad?
2012 to 2017.
Okay. And where did you go to from the homicide squad then?
Went right back to the vice unit in 2017.
Why did you go back to the vice unit?
Back in 2016, we began process to adopt our child. So she was about 8 months old. So my wife came to me and said, "Hey, you got to give up the homicide job. It's taking too much of your time." So I decided to go into the vice unit because it was days, 8 to 4 during the day and weekends off.
Did you have that ability when you were a detective in homicide?
No. Homicide, they can call you in the middle of the night. You work holidays, you work weekends. You're always on call.
Was that a family decision to go to?
It was a family decision.
Okay. Or was it your wife's decision?
That was my wife's decision.
Okay. In terms of so at that point, you probably have 25, 26 years in, or 27, 28 years in the CPD?
Yeah, approximately.
Okay. When you have that type of seniority, are you allowed, does it make it easier to pick and choose what shift you'd like to go to?
Oh yeah, it was pretty easy when you have that many years on to go where you want.
And who talked you into going back to vice? Besides your wife, I'm sorry.
Okay. Daryl McKissick, who's part of the vice unit. He was in the vice unit for 20 years.
And so when did you go back into the vice unit?
March of 2017.
Okay. Was the vice unit training at March of 2017 different from what you received in 2001 to 2005?
Yes, it was.
How so?
They wanted more accountability of the detectives out on the street. So what they had us do was we had a city cell phone. So anytime we came encounter with a person, we got to hit the record button, put the cell phone safely away.
When you say a person, you mean a potential suspect or a potential person to arrest?
Yes.
Okay.
Prostitute.
Okay. And that wasn't the case back in 2001 to 2006?
No.
Okay. So in 2018, in the vice unit, were you part of a team?
Yes.
Who's on that team?
We had about 7, 8 individuals. We had Laura Evans, Brian Key, Jim Mathias, Daryl McKissick, myself, and Rick Stevens.
Okay. So back in 2018 in the Vice Unit, walk the ladies and gentlemen through what a general day was like, if there is such a thing called a general day.
General day, we would usually start out at the office. The sergeant would tell us what's going on for the day. If we had any complaints, we would go through the complaints and work them. Or if we were going to do a street reversal, or Laura or any other females would go out and try to pick up the Johns. Every day was different. Some days we could start out on the street, radio Sarge, say, hey, we're out here on the street, Sarge. This is where we'll be. He'll okay it, and we'll go to work.
Who was your sergeant back in 2018?
Mike Evans.
Okay. And you mentioned the term complaints. When you got to work at 8 a.m. or dealt with complaints, what does that mean? Explain that.
The sergeant would get several complaints that were called in, and it would get sent to him through email. Work this area because this person complained about a lot of prostitutes working this corner during a certain time of the day. Or, hey, my neighbor seems to have a lot of women coming in and out. Can you look into it? Complaints like that.
So each time you go to an office, fair to say you may be going to a different part of the town.
Exactly.
The city of Columbus, I'm sorry.
Right.
So you don't know that ahead of time?
No.
Okay. When you were a patrol officer, did you come into contact with people who were non-compliant?
Yes, I did.
What would you do when they were resisting arrest?
When they're actually resisting, we do everything possible to get them handcuffed.
Is that based on your training?
Yes.
Why do you want to get them handcuffed?
Get them handcuffed is to get control of that person. And the best way to do is to get them handcuffed.
How does that relate to the individual safety or your safety?
No, it's safety for myself and for safety of the other person.
Okay. When you were a vice officer, you had the lawful elements for an arrest, would you have people that were non-compliant in those situations?
Numerous times.
What would you do in that situation in general?
You try to de-escalate the problem, try to make them not as nervous. Everything's gonna be okay. If you don't have any warrants, you may not go to jail because we could summons you.
You mentioned the term warrant. What's a 50 mean?
50 means a warrant check.
Okay. And back in 2018, did you have discretion on a misdemeanor whether to summon somebody to court or whether to take them into custody?
If they had a warrant on, they did have to go to jail. So if they didn't have a warrant on, we could just summons them.
Explain what summons means for the ladies and gentlemen.
Summons is it's just a court date, 7 to 12 days in advance, and we'd ask them, hey, could you make it on this date? And they would agree, and they'd have that ticket.
Was that paperwork filled out right there?
Yes.
Okay. What did you do with that paperwork then?
Send it into headquarters.
Did you give the person you just charged the paperwork?
They get a copy of it.
Was the date of their court appearance on that?
Yes.
So all that you would have to do by yourself?
Right.
Okay. And when you're working in a team back in 2018, it's a team in an area, right?
Right.
How do you communicate?
Back then, it was easiest just to, we all had cell phones, so it's best if we just made a, put on at the red. So it'll just be between 5 or 6 of us, whoever's working that day.
Why would you not? So it's a team, but you're all in your own individual cars.
Yes, we all had our own undercover cars.
When you're doing engaging to try to charge people with prostitution or charge people in those types of situations, are you by yourself?
Yes.
Okay. And what happens if somebody becomes non-compliant based on your training? What are you supposed to do?
We're supposed to arrest them.
How about in terms of notifying the group?
Usually, typical arrest, you'd have your partner and they'd be 1 or 2 blocks away, and you want to get your elements for arrest and then drive towards your partner to help you with the arrest.
When you're working undercover, Andy, what's the general goal in that? Are you playing a role?
Yes.
Describe that.
When you're in Vice, you want to fit in with the neighborhood. So you wear jeans, t-shirt. Sometimes I wore pants with paint on it, and I pretended as though I was a contractor. You just want to be a blue-collar worker for the area that you're in and try to fit into the society.
Were you ever put through a cop test by a potential prostitute?
Yes.
What does that mean?
The cop test is the female may think you're a police officer. So she's going to say, hey, you're the police. And I'll say, no, I'm not. She goes, well, touch my breast. Well, by policy, we can't go underneath the shirt. We are allowed to do on top of her clothing.
So there would be were there physical actions by the female towards you to try to determine if you're a police officer?
She would also want to try to grab you. So we were allowed to have them just touch her outer area of our clothes, but we never let them to go inside.
What does decop your car mean?
Decopping the car is making sure you don't have your handcuffs out or your badge or your police ID. Make sure your walkie-talkie's underneath your seat. Make sure everything's put away so you won't be discovered you're a police officer.
Back in 2018, was it a requirement when you were undercover to have your badge?
No, it wasn't.
What was your general procedures?
When I did have my badge, I usually put it in the trunk. I would keep it in my pants, keep it in the door, hidden away from where the girl will not see the badge.
How about a walkie-talkie?
Usually a walkie-talkie stayed in the trunk because it's big, it's bulky.
Always keep it in your pants. That's a good policy.
It's happened before where the walkie came on, people were talking, discovered that you are the police officer.
What happened? What type of paperwork or what type of paperwork would you need to keep in the car in order to charge someone and summons them or take them to custody?
Just the affidavits, which is the warrant, and the U-10-100.
Okay. Would you also have your ID?
Yes.
And describe for the ladies and gentlemen of the jury what that ID is.
It's a Columbus Police ID, which clearly states Columbus Division of Police, and it has my picture. I'm in my uniform. and it has my name and my badge on it.
When you go to an area in general, what are you trying to do, or what are you looking for in terms of? It's a bad question. I'm sorry. When after you meet in general, the sergeant says we're going to go work this area. What does that mean, and what are you looking for at that point in time?
Usually, like for working females, they can be dressed any way possible. They can be dressed real nice. They can be dressed shorts and t-shirt. You kind of know when you're going to see a prostitute because they kind of stare you down. They always look at passing vehicles, smile, they wave, they flag you down. Or a lot of them are really discreet and like move their head, like meet me around the corner in the back alley.
Okay. And what is the goal at that point in time?
The goal is to pick them up and arrest them for prostitution.
Okay. And in order to charge someone or arrest them, what do you need?
Probable cause.
The elements of the offense?
Yes, it's the bare minimum to arrest somebody.
When you engage with a person in that situation, why are you putting on the cell phone?
To record the device for court proceedings.
I may approach a witness, Your Honor. I'm handing you what's been marked by the state as the state's exhibit R1. Take a look at that and tell ladies and gentlemen what that is.
That is my Columbus Police ID.
Okay. That ID, is that just an ID?
No, it can get us into buildings also.
Okay. So you have to swipe it as well?
Yes.
There's a code and stuff on the back?
Yes.
Okay. Is that a fair and accurate copy? Is that the original one?
Yes.
Okay. Permission to publish, Your Honor.
Okay, that's interesting.
Well, I'm sure they want to show it to the jury, so it looks, you know,
So on that-
official.
Can you see that on your monitor, Andy?
Yes.
Okay. So on that, how are you dressed?
Police uniform.
Okay. And it says sworn underneath?
Yes.
Okay. And when you are undercover, are you wearing that?
No.
Okay. And then the lower right, what is it, the lower right there?
Picture of the badge.
Okay. And it has an issue date and everything like that, correct?
Yes.
Okay. So that's what you had that day, would you,
Yes.
correct? Okay. Now, on August 23rd of 2018, did you have your badge when you went to work?
No, I did not.
Where was it?
I left it in my personal car, parked at the substation.
Was that something you did often?
Park at the substation?
No, leave your badge in the car?
No.
Had you forgotten it that day?
That day, I had a special duty job at the grocery store right after my 8 to 4, and my badge was on the shirt. I forgot to take the badge off my shirt and put it in my pocket.
Was that a normal thing you forgot, or was that you didn't forget it very often?
I hardly never forgot my badge.
Let's now turn to August 23rd of 2018, okay? Tell the ladies and gentlemen of the jury how you start your day.
That day started out about 8 a.m. That day we had firearms, so people in our group decided to meet at Tim Hortons, have our coffee and donuts.
I have to agree with some of the people in chat that are saying that that ID didn't look as official as it could have.
Sure, but he doesn't design the ID.
I mentioned
right
in our unit. We name their names.
No, that's okay. So how often do you go to the fire range?
We go 5 times a year.
Okay. And what was the concept that you were going over?
That's surprisingly low.
It's called a decision course.
When you're out there, is it just a course, or is it a combination of classroom and course?
We start out in the classroom just to make sure our firearms are safe, and the instructor goes over safety precautions on the firearms.
Is that what we've been talking about as a decision course?
Yes.
Shoot or don't shoot?
Yes.
Okay. When you go through that course, what are you trying to determine, Andy?
It's a course where you shoot, don't shoot, are indeterminate. You make that decision.
Is it based on what you perceive?
Yes.
Okay. So if you perceive someone, are you looking to see whether or not someone's a threat?
Yes.
Is that based on your training?
Yes.
Okay. And so you're visually walking through a course, and what a target pops out, or describe how it happens.
An officer is behind you, keeps his hand on your shoulder to make sure he doesn't get hurt. He guides you around the range, and the posters or target will edge. So they're edged first, and then they turn sideways so you can see the full picture. It could be a lady carrying groceries, but she has her cell phone out, like it may be a weapon, but it's just held out like this, and you gotta make sure, hey, that's a safe target, and don't shoot. Or it may be somebody, when the target turns, maybe somebody with a gun from the UDF pointing it at you, and that's a target to shoot.
And these are all facing forward, correct?
Yes.
Is there training off to one side or the other?
There's this one training officer. Is that
I'm sorry. Do targets pop out from the right or from the left, like
no,
peripherally?
They're in front of you.
Okay. And do targets pop out from behind you?
No.
Okay. And you actually have someone with a hand on your shoulder, correct?
Yes.
And why is that?
Just for safety purposes, so you don't hurt yourself or him.
And is it fair to say do they want you to be able to shoot in all different directions?
Correct. They don't want you to turn around and shoot. That's for sure.
Only straight?
Only straight.
Okay. Now, when you perceive a threat, based on your training, what are you trained to do?
Shoot till the target edges.
Okay. When you see a threat, is there a number of shots that they train you to do?
They say shoot as much as you can within the time that the target faces.
And in that scenario, is the target a threat as long as it faces you?
Yes.
Okay. And you're trying to stop the threat?
Correct.
All right. When you're at the firearms training, do you train with, what hand do you train with?
We train with both hands.
Describe for the ladies and gentlemen jury what you mean.
The majority of our courses are with your dominant hand. I'm right, so train with your right. At the very end, they'll say, "Hey, let's train with our left." Not very many shots, but we do left-handed shots.
What happened? Do you ever train with both hands?
Yes.
Holding the gun at the same time?
Yeah, you can do it with both hands and you can do it with one hand. They do both ways.
What are you wearing at that point in time on your ears?
Headphones.
Why?
It's very loud. FOE. You can lose your hearing with the gunshots.
What types of headphones?
You can put those small sponges in your ears and then put the headphone over it, or you can just put the sponge in your ears.
When that's over, what happens? What does the group do?
During that day, only one person could shoot at a time, so it took a lot of time. I was the last one to shoot, so when I came out, everybody was finishing up, cleaning up their guns, and we all got together and said, "Hey, what are we going to do? We're going to go to lunch."
Yes, Flux. This is the cop, the defendant.
We all decided to hit the west side and go from there.
What do you do at that point in time?
I still had to clean my gun, so I was there for another 15 minutes, 20 minutes, and I told him, "Hey, I'll meet you when I get out there."
What happens next, Andy?
And time was about 11 a.m. I got on the text, and "Hey, anybody out here?" About 11:10, I believe it was.
May I approach a witness, Your Honor? I'm handing you what's been marked previously by the state's Q. Okay. Can you take a look at that?
Folks, you can just order a badge from a police supply catalog. It's the easiest thing in the world. Anybody can get a badge. That's the same badge that the police would order for themselves from that same police catalog.
Yes.
Okay. And we're the timeline, so the jury note starts from the last page. Okay. So, I'm sorry, Courtney. So on this exhibit Q, when I'm pointing to item 7, correct?
Yes.
Okay. So when the subject says no subject, but says anybody out here, who sent that?
That's me.
Okay. What do you mean when you sent that?
As you see off to the left is the thread of the people that were there that day. So I made sure somebody was out there on the west side.
Okay. Did you eventually get a response?
Approximately 20 minutes later, I did.
Okay. And someone says, "Yep, D at the library with 1."
Yes.
That you received that one, correct?
Yes.
What does that mean to you?
D, which is Daryl, he's on the left-hand side. He had an arrest, and Laura Evans was the one assisting him.
Okay. What does the library mean?
The library is just a code name for Powell and Sullivan. It's a big parking lot where we could set up and bring our girls back to make our arrest.
How far is the library from Yale and Bellows?
Oh, it's about a good 5-minute drive.
When I use the term the bottoms, tell the ladies and gentlemen of the jury what I mean.
Bottom is the near west side. There's the hilltop, which is actually on the hill. The bottom is at the bottom of the hill.
And that's the area the team was working?
Yes.
Okay. And when did you first come into contact with Ms. Castleberry?
When I first got down there, I had to go through the bottoms before I got to the hilltop. So I knew Daryl and Laura was up on the hilltop. I didn't know where anybody else was because nobody else responded, but they're supposed to be on the west side. So I decided to start looking at the west side. At first, I was on Central Avenue and I continued eastbound Sullivan towards downtown, looking around for any females walking, but at that time there wasn't any.
And I think you said this was maybe around 11:15 or?
Approximately 11. Right after I talked to Laura, she responded. It's about 11:20.
Okay. And what happens next, Andy?
So I kept going eastbound. I usually go all the way down to Avondale. Didn't see anything. It was pretty dead out. So I was thinking to myself, well, I'll just go up and meet Daryl and Laura. So I turned around on the block of Avondale, came back up Sullivan, past Glenwood, went under the viaduct, and off to the left. That's where I saw Donna Castleberry.
Describe for ladies and gentlemen of the jury what you saw.
Donna was approaching an older red pickup. He was heading eastbound on Sullivan. He was slowing down, and it looked like Miss Castleberry was having communication with them. She was approaching the passenger door. But also, as I was passing, she saw me, so she also waved and smiled.
What did you interpret based on your training experience in the Vice Squad of what she was doing with the pickup truck and then what she was doing with you?
Well, I figured she was a working girl. Like I said, that's one of their indications, a wave, a smile. That's what she was doing. I figured she was going to go get in this pickup truck. So what I decided, I said, well, I'll head down Princeton and park in the back alley, see if she gets in the pickup or not.
Could you see from that area whether or not she was, from where you parked, could you see where she was in the pickup truck?
Yes. I took a left on Princeton, and then I took the first left in the alley. West Park was the next street over. I could look past West Park into the alley down the way, about a half block, and I could see she was talking to the gentleman in the pickup truck.
Now, you mentioned her name, and had you known her at that point in time?
No, I did not know her name.
So you know that because of after the fact?
Yes.
Okay. And so once you're parked and you see it, what happens next, Andy?
I thought for sure she was going to get in the pickup truck, so I really wasn't prepared for her to get into my vehicle.
What do you mean prepared?
I didn't have all my stuff put away, my paperwork, my ID, my cell phone, my city cell phone, and my personal cell phone. It was all out.
Was her was her contact with the pickup truck done?
Yes.
What did you observe her do next?
And then she started walking towards me. And I'm thinking to myself, oh, I don't have enough time to get on my personal cell phone to say, hey, I want to pick one up at West Park and Sullivan. So I quickly put my personal cell phone away.
What did you do with the city cell phone?
City cell phone, we had to record the incident. So I was able to do that. Quickly took the city cell phone out of the pocket of the door where I keep the city cell phone. It was easily just hit the record button and placed it right back into the door.
How about your ID?
My ID was already inside my pocket.
Okay. You're the Columbus ID?
Yes.
Okay. And when you turn on the tape, what is the purpose or what role you're playing now with regards to Ms. Castleberry?
My role I was playing was just a regular John out there trying to pick up a prostitute.
Do you have props in your car that go along with that role?
Yes, I do.
What types?
I have construction supplies, a tool bag. You may have seen them on the video. A tool bag. Because women would ask, hey, what do you do for a living? And they'll look around your car and say, hey, what's that? So I always had some props to show them.
And when the tape recording's on, does she get into the car?
Yes. She comes up to the passenger window. I roll it down. I believe she immediately got in. Usually they want to chit chat while they stand outside the window, but she knew what was up. So
when she got into the car, what did she have in her hands?
She was carrying a large purse.
Did you ask her to place her seatbelt on?
Yes.
Why?
If we have the sync, if you don't put her seatbelt on, the buzzing, the bing, bing, bing continue to sound off. So I told her to put my seatbelt on so we could hear the recording.
And did you see a knife in her hands when she got into the car?
No.
Okay. Was your seatbelt on?
Yes.
Okay. So the conversation starts. Where do you determine to go from there?
Right now we're at the corner of West Park and Sullivan at the stop sign. 90% of our takedowns are at what we call the club. The club is at Princeton and Union, which is just one block over and one block south. So I'm thinking to myself, great, I don't have a lot of time. I really don't have nobody too close. I didn't want to take her there because I wanted to get my elements, and the block was too quick, so I didn't take her over there.
Who directed you where to go?
She wanted me to take a right anyway. She goes, well, I got a spot, take a right. I'm thinking to myself, okay, I'll see where she's taking me. I'll make sure I don't get too far away or out of the area.
So did you know the area where she was taking you?
At that time, I did not know where she was taking me.
Okay. What's going on? Is the tape recording of what the prosecutors played, is that the conversation between the two of you while you're driving?
Yes.
Okay. What happens when you get to the area? Why, do you know why or did she express to you why she chose that area?
I just figured she knows the area and she won't be as nervous.
Overruled. Did she convey to you why she wanted to go to that area?
At some point she did.
What did she say?
When we got to the location, she pointed out that's where she gets her dope.
Okay. And did she tell you where to go?
Yes.
Okay. When you got there, what happened?
Well, on the way over there, we had negotiated the price.
What does that mean for ladies and gentlemen?
I told her I wanted head, and she gave me a price of what she charges.
And what was your response to that?
She said $20, and I said cheap, and she goes, well, $30 then, and I said expensive.
Why did you say cheap when she said $20?
I was just making a comment, just trying to fit in. And we settled on $25.
$20.
What does that mean to you when you say I want a sexual act and you settle on a price? Do you then have the elements to a lawful arrest?
Yes. In Vice, we charge two charges mostly. Loitering. We can charge a loitering charge if they just get into the car, or we can charge a soliciting. We charge soliciting when they name an act and name a price.
So do you have the elements while you're driving?
Yes.
When you get to the area, what goes through your mind in terms of where you're going to park?
Well, when we get to the area, I knew I had my elements. She wanted to go behind the building, but she said that's where she scores dope. I wanted to stay out in the front of the building, out into the public. I was passing a line of gas meters in the corner of the building. But this time I said, I'll just park right here and block her in so she doesn't run out on me.
Why did you do that, Eddie?
90% of these women will run from us. So me being 55 at the time, she's 20 something, I wouldn't be able to catch her. So that's basically why.
Are you trained to do that?
Yes, it's
a training technique of containment.
Yes, it's part of the technique that the vice officers use.
And is that is that for a purpose as well of safety to both you and to her?
Yes.
Okay. And child locks. Tell the ladies and gentlemen of the jury. So this isn't your personal car, correct?
No, it's the city issued car.
And does it have child locks?
Yes.
Okay. What was your memory, or how did you treat the child locks?
To tell you the truth, I never even thought about the child locks. I knew they were always on. I never took them off.
So you have the elements. Now you're parked up to the car. What do you do next?
Identify myself. I said, Columbus Police, you're under arrest for soliciting.
What was her reaction?
Police, like she didn't believe me.
Okay. So at first, did you believe that she didn't believe you?
Yeah. A lot of girls out there were undercover. They don't believe, even if we show them a badge or personal police ID, they still don't believe. But I did show her my photo ID. I said, I am the police. You are under arrest.
Have you had that same situation happen before?
Yes.
Okay. So it's not uncommon for them not to believe you.
Yes, correct.
What steps did you then take to try to show her that you were a police officer?
Well, I told her, I said, hey, I'll text my partner. I'll let them know so they can come down there. I'm sure they had their badge and their ID to prove that I was a police officer. So I was going to text the group text, come down this area.
Were you able to do that?
Yes.
Okay. And when you texted that, how did you know what street you were at?
I knew I was Bellows. For some reason, I did remember Bellows, but I just couldn't remember Yale, which is a popular street down there. At the time, I couldn't remember where I was.
Okay. Did she give you the cross streets?
Yeah, she said Yale. So then I knew I was at Yale and Bellows.
Okay. So so this on the exhibit Q, somebody come to take and Bellows, please, right?
Right.
That's your text, correct?
Yes.
What did you mean by take?
I just misspelled it, or I don't know. Sometimes it automatically puts a name in there and you hit it and it stays. And I guess that's what happened.
Okay. And then Braz?
I have no idea.
Okay. Now, and this one, is that you, Bellows and Yale?
Yes.
Doesn't believe I'm a cop.
Correct.
Right. So at that point in time, you're telling people she doesn't believe I'm a cop.
Correct.
You do that so that they then come to you?
I was hoping they'd see that and get down there faster.
So is the purpose to draw the attention to them to come?
Yes.
If you were not involved in an arrest of someone and you got that and you weren't occupied with someone, would you go to that area to where the person was?
As fast as I could.
Okay. What other steps did you take to try to convince her that you were a police officer?
She wanted to see more. So on the chain that Mr. Collins showed me, I had my handcuff key. So along there, I showed her my
A lot of text to other officers for somebody who was supposedly trying to rape a prostitute.
handcuff keys. So I said, yeah, let me show you my affidavits that I got from the municipal court.
What's an affidavit?
It's basically the arrest warrant.
Did you show her a U-10-100?
Yes. We also have a U-10-100, which is our basic arrest warrant.
And the prosecution already admitted this. Is that a fair and well, that is the U-10-100 that you showed her, correct?
Yes, that's the one I showed her.
Was there talk about you're the police, and if you don't have, what did you say why did you tell her that you were a police officer, number one?
Because I was going to arrest her.
Because I am.
Based on training?
Yes.
Okay. And at some point, was there a question came up about warrants? What did you tell her about warrants?
I asked her about a 50 check. If she had any warrants, 50 check. I told her, you know the lingo. She didn't respond.
Did you ask her at any point, did she have any weapons?
Yes.
Did she respond to you?
No.
Why did you ask her if she had any weapons?
Because usually when we run across prostitutes or anybody, they sometimes had a knife on them or any type of weapon.
What did you tell her? Hey, did you tell her, hey, if you don't have any warrants, I'm not going to arrest you?
Yeah. I told her, I said, hey, if you don't have any warrants, I'll let you go.
You still give a summons, but you
He didn't use his radio because he's undercover. He didn't have his radio with him.
Why did you ask her, after all of that you did during that process, why did you ask her, do you still don't believe I'm a police officer?
Because she kind of had to look like, maybe you are a police officer, maybe you're not. So I said, you still don't believe I'm a police officer? And she said, oh, I didn't say that.
What did you believe at that point in time, Mr. Mitchell, about that statement?
That statement, I believed that she knew I was a police officer. She said, oh, I didn't say that you weren't. So I proceeded to try to arrest her.
Did you tell her in advance that you were going to handcuff her?
Yes.
Was she compliant?
No.
Was she verbally compliant?
No, she never agreed to being handcuffed.
Why did you then, you hear on the audio, you said, fuck it, I'm going to handcuff you.
Correct.
What was going through your mind at that point in time?
Well, that's after the gentleman came out of the building.
I apologize. So while you're talking with her, trying to convince her you're a police officer, a person walks by.
Correct.
What happens with that situation?
I was sitting there, still texting. She's still there talking like, you're not a police officer, this and that. And a gentleman comes out of the building off to our right, carrying a large item at the time. I couldn't see what it was, but he was heading for the dumpster. She rolled her window down and started yelling out the window.
Okay. And based on that, did the gentleman come closer to you?
After he put away his, I think it was a microwave in the dumpster, he came back and stopped.
What did you say to him?
I wasn't saying anything at the point. She was the one yelling everything out the window.
Did you acknowledge him?
Yes.
What did you do physically to show him that you were a police officer?
She was yelling out the window, he's not the police. He's trapping me in this car. He's trying to kidnap me. She's saying all these things. Call 911. And I'm yelling out, I am the police. And I thought it was loud enough for him to hear. But I also grabbed my police ID. I put it up towards the back window because he was looking in the window. And basically, he looked at it and kind of agreed that she's talking a lot of baloney. I'm going back into the building.
So do you know where he went from there?
Back into the building.
Okay. So physically, you're saying you turned towards the right back of the thing and held your ID up there.
Correct.
Okay. What happens next?
She begins to get more violent. Her voice starts to escalate. I've arrested over 500 females for prostitution. I knew what was coming. I knew there was getting ready to be a physical altercation.
Why did you say, fuck it, I'm going to handcuff you?
Basically, I had enough. I was fed up. I'm tired of reasoning with her. I showed her everything I could that I had to possibly show. I was a police officer. I asked her the right questions. I believe she thought I was a police officer.
What did you do? Did you then try to handcuff her?
Yes, I did. That's when I brought my cuffs that were underneath my left leg, which they're always there. That's where I keep them. And I brought the cuffs out to arrest her.
Okay. If you would face, may I approach the witness, Your Honor? If you would have faced, so Ms. Castleberry is, for the record, seated as you're facing to your right, correct?
Correct.
Okay. So describe for ladies and gentlemen of the jury how you did with your hands. What did you do?
I grabbed both her hands like this.
Why do you grab both
hands? And I have my handcuffs with the controls. So she doesn't sucker punch me. I want to control both hands.
So you grab both hands?
Correct.
What happens at that point, Andy?
She started pulling, arguing, fussing with my hands and pushing away, resisting arrest, basically.
Is that a sign of resisting arrest?
Yes.
Is that a sign of noncompliance?
Yes.
Is she verbally telling you that she's not going to comply?
Yes, she's saying, keep your hands off me, don't touch me, basically. Don't touch me.
Do you know if at this point in time when you grabbed her hands, if her seatbelt is on or off?
She did unbuckle. I do remember her unbuckling the seatbelt before she started yelling out the window at the gentleman that passed by.
Were you aware that she had thrown the handcuffs out the window at some point?
No, I wasn't.
At this point in time, while you're grabbing her hands, what do you perceive about her actions?
I was trying to make control. I didn't want her to reach for any weapons. I didn't want her to punch me. I didn't want her to scratch me. I was just basically trying to control her hands so I could put the handcuffs on her.
Anything she's doing led you to believe that she was being compliant?
No, nothing whatsoever. She's kicking her legs, banging on the dash. I mean, she did everything possible to try to get away from my grasp.
When you have her hands, so did you grab my hands? Face this way. When you have those hands, at any point did she break free?
She had to break free.
Okay. What happens next? What do you realize happens?
Well, I'm kind of mad at myself because I never seen it, but somehow she was able to grab a knife and cut me.
What do you mean by cut you? Where did you get cut, ladies and gentlemen?
I got cut from the tip of my thumb all the way down to my wrist.
Why did you reach towards her when you tried to get control?
That would explain the blood.
I was trying to arrest her. She was being non-compliant. She was going to go to jail.
Did you see the knife at any point during that struggle?
I saw my wound first before I saw the knife. While we were struggling, I said, I couldn't believe what I was seeing because it was a pretty deep gash. I'm thinking, where did that knife come from? I never saw her grab it. I never saw it in her hands at the time before I got cut.
What are you trying to do now? What's your focus of control now?
Now I'm trying to get the knife. I look at her right hand and I see about an inch of a blade coming out of her hand. She had it cupped like this.
So describe for me where your hands are at this point in time.
I'm still struggling, trying to control her hand.
Do you have your hands on both of her hands?
Yes, at the time.
Her arms?
Yes.
Okay. What happens next?
I see the knife. I'm thinking, well, at that point, I wasn't too much worried about handcuffing. I was worried about her not taking the knife and bringing it up to my neck or my head.
When you see your cut, when you see the knife, you perceive her as a threat.
Definite threat.
You perceive her as a threat to serious physical injury.
Yes.
Do you see her as a threat to potential death?
Yes.
What is your goal in terms of controlling her hands and the knife at that point?
At that point, I was trying to get the knife. I remember actually prying on her hands and fingers, trying to remove the knife.
Why didn't
She didn't have the knife in her hand because she was complying with arrest, folks.
Why didn't you immediately grab her knife or grab your gun and shoot her at this point in time, which you would say was justified?
At the time, we were struggling over the knife, and I didn't want to get cut again. I'd have to let go of her hand, reach over, get my gun. By that time, she could have struck me again with the knife. So,
were you trying to control her hands to get the knife?
Yes.
Were you able to get the knife?
No.
What happened next, Andy?
We struggled for I don't know how long, and all of a sudden she did some type of acrobatic move where she was able to take her legs out towards my neck, and she put her back against the dash.
Where on the dash?
She was against the radio part.
Okay, so in the center of the dash.
Yes.
Okay, so not over by where the glove compartment would be.
No, she was in the middle.
Not by the steering wheel.
Correct.
Right in the middle.
Yes.
And is your seatbelt on at this point?
Yes, I was seatbelted in.
Had you ever lost contact with your hands and her hands at that point?
No.
Are you still trying to gain control of the knife?
Yes.
As you're trying to gain control of the knife, tell the ladies and gentlemen of the jury what Donna Castleberry does to you.
Well, I wasn't having much success in getting the knife. So still, my main concern was not to get cut again. So I remember keeping my hands as far as I could, just so she wouldn't be able to bring the knife up. So I was using all my energy to keep her away from my neck. Meanwhile, she was able to bring her left foot up against my throat, right about the center, and she was pressing as hard as she could.
What did you believe at that point in time?
I believe she was trying to make me go unconscious, and she could eventually knife me again. So I was trying to prevent from going unconscious.
Did you perceive her as being a threat at that point?
Of course, she was a major threat at that point.
Your Honor, may I have Ms. Stevenson approach the... If you could back up just a little bit, Mr. Mitchell. That's good. So that the ladies and gentlemen of the jury can know a better concept. You don't get to this? So,
Oh, nice.
Yes, I'm pushing as far as that. Yeah. Correct. And where's her foot?
Oh, she's getting comfortable.
Directly, she had it turned. Sorry. And it was mainly right there on
That booty dough.
What were you doing?
This is awkward.
Still had him out as far as I could be.
Did you believe she still had the knife at that point?
Well, she definitely had the knife still in her hand.
Okay. Was she exerting the pressure on your neck, or were you?
She was exerting the pressure.
What did you believe at that point in time?
I'm thinking to myself, oh, I can get out of this. I can wiggle around, get free, and try to get the knife back.
Okay. What happened next?
As much as I tried to wiggle out.
No, we don't do that here.
She was able to get on the
Bye.
right side of my neck and press even harder. On my right side of my neck.
Thank you, Mr. Thank you, Judge, for not having me. At this point in time, with her foot up against your neck and her exhibiting the force and using the dashboard to go back towards you, correct? What did you believe at that point in time, Andy?
At that point, there was a headrest, and my head was back against the headrest, so she was able to apply a lot of pressure. Like I said, as I tried to wiggle out, she was able to get to this side of my neck, which I have, I guess, one of my main arteries. And the harder she pressed, I was almost unconscious.
Had you ever gained control of the actual knife during that struggle?
Not at that point.
Did you have any idea how long that struggle was?
No, I do not.
What did it feel like right before you believed you were going to be unconscious?
I knew I was only seconds away. I was actually seeing lights. I said, I'm going to go unconscious, and she's going to cut me again.
How did you physically feel, if you remember, at that point in time?
I was very fatigued already.
Why did you decide to let go of her arms and reach for your gun, Andy?
Well, I'm thinking to myself, if I don't go for my gun, I was going to die. So what I'm thinking is I'm going to have to reach for my gun as soon as possible. I knew I was taking a risk because that would free up the knife again. But I believe I had no choice. So at that time, right before I was able to go unconscious, I went for my gun.
Did you ever lose consciousness?
No.
Okay. So at the point in time when you realize it's a bigger risk letting go of her hands?
It was a bigger risk, but I was willing to take it.
Okay. What was your belief of what she was doing to you? Was she a serious physical threat to you at that point in time?
Yes, she was.
Not just actual, but did you perceive that as well?
Yes, I did. I totally believed I was going to get stabbed again.
Okay. And so where was your gun?
My gun, I kept my gun driver's seat, between the door and the driver's seat, down in that little area.
Explain for ladies and gentlemen, jury, what happens next, Andy?
Okay. I reach for my gun. I'm still seatbelting my seatbelt. I can't reach it. With everything happening, I was unable to reach the gun. I was still seated in my seatbelt. So with my right hand, I went ahead and unclipped the seatbelt. And I remember going up and getting the gun with my left hand.
What did you do at that point in time when you had the gun in your left hand, Andy?
I'm thinking to myself, I got to do this as fast as possible. So I brought the gun up. It was in my holster. So I unsnapped the holster, brought the gun out with my left hand, brought the gun across my chest, and I began to shoot.
When you believe that you began to shoot, you're saying with your left hand you put it across, so you're still, you believe, facing forward?
Yes.
Where do you believe Donna Castleberry is at this point?
I can feel movement as she's going towards the back of the car.
So she came from here. Did you know she was at your side?
I believe she was at my side at the time.
Is that why you fired that one?
Yes.
Okay. What did you do next? Why did you fire a shot at that point in time?
I fired a shot so I could stop the threat to make sure she wasn't going to shoot or stab me again.
What did you believe if she got behind you?
I believe she's going to cut me in the neck, cut me in the head, do anything she wanted to do.
What happens next, Andy?
I shot 2 or 3 times across my chest this way and my arms across here. I don't know where the bullets went. I just shot as fast as I could. And then I pivoted around to see where she was at. At that time, she was in between the seats, real close proximity, still flinging her arms, kicking her feet, yelling whatever, because with the sounds of the gun, I could not hear what she was saying.
Did you hear any time after you fired the first shot? Did you hear anything that Donna Castleberry said?
No, I did not.
What were her actions at that point in time after the first couple of shots?
She was still resisting arrest. She was still trying to inflict danger upon me. I still felt a threat.
Did you perceive her as a deadly threat?
Yes, I did.
Did you perceive her that she was that she could cause serious physical harm to you?
Yes, I did.
Had she already caused serious physical harm to you?
She already cut me once. She choked me. She's still putting up a resistance. I still believe I was a threat of my life.
Okay. And in terms of, what do you do with the gun? It moves from one hand to the other?
Yes.
What did you do then?
I continued to shoot because I still felt threatened. Every shot I took, I still felt threatened. She was still moving. She was still flinging her hands. The first time I didn't see the knife, and I believe the knife was still in her hand when I continued to shoot.
Could you see the actual knife in her hand when you fired those other shots?
No, I could not see in her hands. It was difficult to see in her hands. We were close proximity with all the movement. It was hard to get a good view.
Was Donna Castleberry sitting still in the back seat?
No, she wasn't.
What was she doing?
Flinging her arms, kicking her feet, yelling, still wrestling. It was a still ongoing battle.
Even though you didn't see a knife, did you believe she still had the knife?
Yes, I believe she still had the knife concealed in her hand.
Why did you believe that?
Because she already caused me physical damage. I already had it cut. She just finished choking me. I was gasping for air. I was under the threat of dying.
Why did you stop shooting?
I stopped shooting because she quit moving.
Was the threat over?
The threat was over.
Each and every shot, did you attempt to reassess when shooting?
Yeah, I reassessed the whole time, the time we started fighting till the last shot.
Was she ever not a threat to you based on your perception at that point in time?
She was a threat to me the whole time. I felt a threat the whole complete time.
Is that what you believed?
That's what I believe.
Subsequently, you gave a written statement, correct?
Yes.
Okay. Subsequently, you gave an interview, correct?
Yes.
Okay. Eventually, a long time later, you realized that the car door was open, correct?
Correct.
Had you remembered the car door being open at all?
I never remember the car door.
What was your belief of when you were in that car, whether or not the car door was open?
I believe the door was always shut.
Do you remember opening it?
No, I don't.
Obviously, you opened it, right?
Correct.
Did you believe it was open during any part of that altercation?
No, I did not.
When you see the video and you see part of your foot being out there, do you remember that occurring?
No, I do not.
Why don't you remember those things, Andy?
It's under a lot of pressure through training. It was a quick movement, muscle memory, instincts. I don't know. I just don't remember opening the door.
Were you fighting for your life?
I was fighting for my life. It was a traumatic event.
Were you fighting for survival?
Yes.
Why did you fire each time at Donna Castleberry towards her?
I still felt a threat. Every time I fired the shot, I still felt threatened.
May I approach the witness room? I'm handing you what the mark that states exhibit. Is it okay if I don't hand them? Okay. May I publish it? Yes, you may. Okay. That's Defendant's Exhibit 6. Okay. What's that a picture of?
It's a picture of my right hand.
Okay. And is that what you meant, where the cut started on the tip and went all the way down into your wrist?
Yes.
Okay. How many stitches did you receive from that?
34.
Okay. Was there a blood transfusion?
Yes.
Okay. Was there multiple surgeries?
There's just one surgery. The doctor did tell me that my muscle was cut underneath my palm.
How about therapy or rehab?
2 months of rehab.
Describe for ladies and gentlemen jury what that entailed.
Luckily, the knife wound did not hit any nerves, so that was luck. But I could not move my index finger or my thumb for about 2 months.
Do you know if you were able to do that while you were shooting towards the threat of Donna Castleberry with your right hand?
It was hard to shoot with my right hand.
In terms of, they also took pictures of your hand. Do you remember them doing that?
Yes.
Okay. And Detective Shepard testified to those, correct?
Yes.
All right. Those are other cuts that you received in this trying to lawfully arrest or trying to stop the threat, correct?
Correct.
Do you know when you received the other one?
No, I don't.
Okay. You don't know if it happened right away, or you don't know if it happened when she was in the back seat?
Correct.
Were you ever farther than arm's length away, or when Donna Castleberry and you were in that car?
No.
Were you, when she moved to the side of you from the windshield back, what did you feel? What did you believe when she was next to you?
That she was coming towards me. She was right next to me.
Did you perceive her as a threat at that point?
Yes, I did.
When she was going behind you, what was your perception? What was your fear?
I was more fear when she got behind me because I couldn't see her actions.
Why is that, Andy?
Being behind me is a worse threat than her being in front of me where you could see. I couldn't see what she actually was doing.
Were you angry when you fired those shots, Andy?
No, I was not angry.
Did she provoke you in any way to fire those shots?
She didn't provoke me, but her actions made me fire those shots.
Did you believe that you already received a felonious assault on yourself, correct? By her.
Correct.
And who was the aggressor here?
She was the aggressor. She's the one that attacked me.
So you've already been slashed and you've already been choked. What was your belief if she got behind you?
I believe she was going to finish the job. That was in my mind. I was still fighting for my life.
In your 30 years at that point in time, had you ever fired a weapon on duty?
No, I have not.
Why did you say fucking nightmare, Andy?
Because it was a nightmare. The whole incident was a nightmare. I just took somebody's life. I had a severe cut to my hand. I was just choked out. I had blood. I had to have a blood transfusion. I had a surgery. It was a nightmare. Still a nightmare to this day.
When you fired the weapon, when did you decide to use deadly force when you let go of her arms?
Yes.
Why?
Because that's how I was going to save my life.
When you fired the weapon, did you perceive her to be as a threat each and every time?
Yes.
Andy, that's all the questions I have for you right now. Mr. Cable asked for you. Oh, I'm sorry.
Wow.
Ms. Pritchard.
Cross.
Wow, that was. What did you think?
I thought it was sound.
Sounded good to me.
I mean, he had a hooker in his car, stabbed him once, was flailing with him, had her foot in his neck, was approaching him as she moved to get into the back seat, was never more than an arm's reach away. He had no reason to believe that she didn't still have the knife in her hand. He had concurrent defensive wound injuries to the slashing injury to his hand. That looks like a deadly force attack to me.
I thought his explanation sounded plausible and reasonable. I still don't know how I think about the choking out thing, but
well, there's his DNA on the bottom of her shoe, right?
Yeah, and I mean, I would argue it's his car. It's his undercover car. His DNA is probably all over that car.
But I don't know. Is it he gets the same car every time, or it's an undercover car that's rotated through a whole bunch of cops? I mean,
but yeah, I mean, other than that, it seemed, seems good. I like it so far. The prosecution,
I mean, it's just the throat thing would be a weird thing to fake because it's not necessary. I mean, he's already got a knife attack taking place.
Okay, we have a couple of comments here. KKB says, so he's trying to handcuff before the other officers arrived. Yeah.
Yes.
That's nothing wrong with that. He's not required.
Normally how this goes, folks, you have to understand, it's not normally a violent confrontation. They get the elements of prostitution, they handcuff, they check for warrants. There's no warrants. They write a summons and they immediately release the prostitute.
Barbara Walker used lethal force over a solicitation crime by a tiny girl who told you she was on drugs.
That's not what happened.
And had a knife.
Yeah, no, he used lethal force after he had a 34 stitches blood transfusion slash to his hand and wrist.
And again, KKB, I see why he would feel threatened, but I also see why she felt she was fighting for her life. I think you created the circumstances.
And both those things can be true.
Right.
And of course he created the circumstances. He's a cop making an arrest. But he's allowed to create those circumstances. He's allowed to make an arrest. And what she was fearing is irrelevant to whether he had a reasonable fear of an imminent threat of deadly force against which he could use deadly defensive force.
That's the thing that, I think this is likely, in my view, what happened. All three of these things. He created the circumstance, of course, because he had to. He's the arresting police officer. It is his job to create this confrontational circumstance. Unless someone goes, okay, great, I'd love to go to jail. Please, here, handcuff me, stranger. That is his job, is to take her into custody physically if she doesn't comply. Also, if some guy I've never seen before pulls up on me in an unmarked car, wearing no clothes, can't show me a badge, shows me a really cheap looking badge ID that looks sort of like my high school ID, doesn't have a radio, and tells me that I'm under arrest, my first reaction would probably be, well, fuck you. I don't think you're a cop. And then it can get ugly. I'm on the defensive because I just know there's some big guy that's coming after me, trying to arrest me and trying to handcuff me. And at the same time, he's thinking, I'm a police officer. She has to comply with my order. I am making this arrest. And then she knifes him and he's like, okay, this is a deadly force attack. So they can both be absolutely fighting to defend themselves. They can both absolutely be in the right. And this is the unfortunate result of a situation. But just because she felt threatened doesn't mean he didn't feel threatened and can't defend himself.
Correct.
It's not a pretty situation. Not everything is cut and dried. Not everything goes according to plan. And Jerry Kyle says, was he on duty or he just saw her and decided? Yes, he was on duty.
He was on duty. It was a police vehicle, just an unmarked vehicle. Undercover vehicle.
Let's see if there's any other comments to bring up here that I found interesting or it's not redundant. A deadly force attack that was over. How do we know it was over? Because she said, I give up, I give up. Now go search YouTube. I know I've seen bunches of where they go, okay, I'm stopping. I'm not resisting. They go, okay. They relax. The guy gets up and bolts. Or in this case, could have turned around and stabbed him with another knife or anything else. Could have stabbed him with an eyebrow pencil. Who the hell knows?
Could have just bit him.
Reasonable sounding until you hear the actual audio of how it transpired. Well, we've heard that. And again, it's not clean, it's not pleasant, but I just don't buy the prosecution's arguments here. I think he has right now I'll just say that I'm saying he should not be convicted.
The state's own use of force expert says if you fire a gun inside a car without hearing protection, it's going to stun your hearing. The defendant says, I didn't hear any of those words from her. So if he didn't hear it, he doesn't know she's surrendering.
And you know, he doesn't remember opening the door. That is possible.
Most common thing in the world. So for many years, I taught this law of self-defense advanced class tomorrow, Saturday, April 15th. You don't have to pull it up, Jeff, but lawofselfdefense.com/advanced to learn more. But I would teach this class live all over the country, and I'd bring a shooting simulator with me, a $20,000 shooting simulator, and it would just project like a potential threat scenario, a video on a screen, and the student would have an infrared toy gun shaped like a Glock. You could change magazines in it. It had that much functionality. And their job was to observe the video, pretend to interact with the person in the video, and solve the threat problem. And that might involve shooting or not shooting. And if they shot the little infrared pistol, it would show where the hits were and stuff like that. It was a very nice system. But we would run students through this. And these videos are 30 seconds long. I mean, they're very, very short. There's obviously no real threat. There's no real danger. It's a video game, right? And then after they had solved the problem, we would ask them, all right, what did you see? What did you do? And why did you do it? What was your legal justification? Because they just sat through a day-long law of self-defense course. And after the 30 seconds, when they had to turn around and explain to us what they saw, what they did, and why they did it, their hands were shaking. Their voice was shaking. They were under clear physical stress. And they couldn't remember what they saw. They couldn't remember what they did. Or if they did remember, they couldn't remember the sequence of events. We had one guy accidentally drop the magazine out of the gun, pick it up, shove it in backwards so hard we needed tools to get it out. And he had no recollection of doing any of that, even though we all watched him do it. And this is under purely artificial stress where there's no actual threat. So it's very believable to me that an officer who's been slashed in the hand once, severely enough, to need 34 stitches and a blood transfusion, and is still in an active fight with this sex worker in the car, might readily open the door and not remember that he'd done it, might readily not recognize a variety of things in the midst of the stress of that fight.
Well, let's apply the same standards to a different case. Everyone say, well, he should have done this. He should have known this. He should have been paying attention to this. He should have known there was no threat. What about the Potter case? Everybody was saying she should be innocent when she grabbed the wrong device and killed someone with a gun when she was supposed to be thinking it was a taser.
Same
we were
dynamic.
all on her side. Remember that? Why doesn't this cop get the same benefit of the doubt as you were willing to give her? It's the I guess we'll call it tunnel vision.
Yes, I mean, just your mental bandwidth gets extremely constrained because so much of it is focused on staying alive. So we simply don't capture and store and recall information the same way under stress as we do when we're not under deadly force attack.
So he should get out of the car.
He says he's fighting with someone who's trying to stab him with a knife. You don't get to casually unbuckle your seatbelt and roll out of the car without getting stabbed in the back.
And I was, well, he could have got out of the car until I heard him testify. Okay, just you're getting choked out, you're seeing stars. Let go of her and then go out of the car. But as he was saying, he thinks she still has the weapon, or believes she still has the weapon, or maybe she still did have the weapon. He doesn't know. And he said he had just enough time to get to his weapon and maybe still be stabbed again, but it was a risk he had to take. He didn't have the time to get out of the vehicle is the implication there. That is a reasonable explanation. And that's the standard here. Is he reasonably justified in doing what he did? Is it reasonable to assume it wasn't that that was his only option, that he didn't have time to get out and he had to do this? It's like a 50.0001% chance that he acted reasonably in doing what he did.
Retreat just doesn't make any sense when you're being attacked by a person with a knife who's within arm's reach. You have to deal with that threat. You don't just get to turn your back to them.
And I'll be honest, I after hearing the original audio, I thought the guy should have been put away instantly. I was definitely thinking that we were going to have an easy conviction in this case. Now, gotta say, don't think it. I don't think that anymore. We got the cross-examination here coming up, and it better be just fucking stellar. Jerry Cow says, no, they usually do stings with female officers who swoop in to arrest. Parenthetically, on TV is supposed to go in there.
No, we know that's not true, because if that were true, the prosecution would have elicited that testimony in their case in chief. So we know that's nonsense.
Yeah, I mean, there's someone that says that they always wear wires. That's TV land. Yeah. And the officer's like, oh, they've got the dash cam in there, and the hooker comes. That's the whole point. You don't have the dash cam in there, so they don't see it.
They have the Mission Impossible contact lenses with the holographic images that are displayed that do X-rays of people to detect weapons. That's not Columbus PD, folks.
They just look at her, brings up her criminal history, scans her for weapons. It's an ugly situation. Somebody is dead, and that sucks. Well, now, man, Surfing Bird, much respect to Jeff and Branca. I know you guys are based in law, but no, just no.
Well, that's not a reason.
Surfing Bird, I love you, but you know how ridiculously absurd that sounds. I know you guys are based in law, but no, I don't want to apply the law. I don't want to follow.
I expect Surfing Bird, if charged, would not like to be judged on that basis. Forget the law. Just, we don't like them.
I'm nonsense. Okay, well,
it's a policy question.
My father's called me much worse. Oh, that Vice. You're all right. Okay, there punctuation. I was like, Vice, you're nonsense. Okay, the Vice Squad. Well, this Vice Squad was eventually shut down because they were all apparently dealing drugs. Vice Squads do have problems. Like I said, when he was talking about all these different things he did in his career, that could be a training course for all sorts of nefarious crap that they did. But whatever they did, all of these things has no bearing on this particular instant in time. The only thing, as I see it, that matters in this case is what was going through his mind for those 45 seconds. Or we'll give him a minute between the time he says he's going to arrest her and the time she is dead in the backseat of his car. That's the only instant in time that really matters. What he was thinking during that time. We did have a few super chats, then we'll get through the cross-examination, and then there's the gigantic lunch break. So.
Yeah, all these TV cop shows have just destroyed people's minds in terms of having any reasonable understanding of how these police departments actually operate. They're not sending out a squad of people to pick up $20 hookers, folks. This is exactly how they do it. Cop picks her up in the car, gets the elements, does an arrest. If there's no warrants, they write a summons, they kick her out of the car. That's it. It's that simple.
Yeah.
There's no SWAT team backup. There's no helicopters. There's no satellite imagery.
I hate to tell you, the last good law show was a show called, I believe it was called One, that came out when I was in law school 30 years ago. That's the last good legal show I saw on TV, because it's all bullshit. Same with the cop shows, I just assume. Like one of my dear friends, he was the head NCIS guy here in South Korea, and I remember we were sitting over at his house having dinner one day, and NCIS came on TV, and he immediately turns it off, and I go, "Come on, Larry, that's not your favorite show." He says, "Look, I just consider myself lucky that they give me a notepad and a pencil. I don't have this office with Star Wars technology in it. It's TV, people." If they showed you what really happened in real life, it would be the worst, most boring television show you've ever seen in your life. But keeping that behind us here, let's put that in the rear view mirror and look at some of these things here. Where are we at here? New member Vince Clortho, thank you so much for joining the Clean and Sober crew. Boomer, wow, you know what actually makes sense? He can't remember any details because he was seeing red. He got hurt, lost it, and murdered her.
Okay, well, that's mind reading. Absent evidence, that's mind reading. Where's the evidence?
And even if you believe that, that only gets you to the voluntary manslaughter, not the murder charge. Cherry Reed, thank you so much for the super chat. And thank you too, Boomer Wow. Cherry Reed, I can see how she was afraid, but her being on drugs could have affected her thinking. I can see how he felt in danger. I believe him. Well, you have one person rational in chat. Jesus. Just kidding, people. I love all of you. Jillian N. Strawberry said, let's go to Taejongdae Park. Yoda replied, nice use of Google Maps too there by Jillian. I used to live like right at the entrance to Taejongdae Park. But then it was only my ex-wife that lived in that lovely house in front of Taejongdae Park, but that's a different story. Yoda replied, don't dogs need to be on a leash there? Strawberry whispered slyly, I have an idea. Oh, thank you so much for that narrative and your use of Google Maps. Spot on. All right, that takes care of the super chats. Anything else before we get into the cross-examination here?
Not for me.
All right, that's it. We do have a couple of the monthly member chats I want to get through here that I forgot about. You guys have probably all moved on because these were quite a while ago. Bifron's member for 3 months of the Clean and Sober Crew says, look what I got, referring to the membership thing. And a member for 7 months of the Clean and Sober Crew, Digger420 says, oh, look, I've got one of these too. And John Gordon, member for 4 months of the Clean and Sober Crew, says, when prosecutors give me defense attorney vibes, I always have a bad feeling about the verdict. And wrapping us up, Flux says he's got a soul patch. He's guilty. Okay. We've got let's see, how long the cross-examination here looks to be about, scrolling through here, somewhere around 30 minutes, and we're at 1.5 speed. So put that right around 20,
Man, that's short.
Minutes or so.
That is short.
Yeah.
You get the defendant on the witness stand. You want to keep him there a couple hours.
Well, let's see what happens, I guess. Bring us on up here. Okay. Share the screen. Why do I have? There we go.
Good and bad policing is irrelevant to this trial, folks, because he doesn't get to decide that. Those are public policy arguments that get made elsewhere. He's not responsible for police policy.
And apparently, from what potentially criminal Sean was saying, those that were in charge of police policy paid him $1 million to the family of the victim, probably for bad policy.
Were you angry when you fired those shots, Andy?
No, I was not angry.
Did she provoke you in any way to fire those shots?
She didn't provoke me, but her actions made me fire those shots.
Did you believe that you already received a felonious assault on yourself, correct? By her. Correct. And it's clear. Who was the aggressor here?
She was.
This isn't where we were, was it?
Received the other one.
No, I don't.
Okay.
This is the defense lawyer.
There we go. Yeah. Okay. There we go. I brought up the wrong one. That's what I did. Well, that's not too bad. Getting we're 4 hours into this already. 4 hours and 47 minutes, and that was really my first boomer moment of the day. I'm kind of proud of myself. So let's get rid of this window so I don't do that again. All right. This is what I was looking for.
Mr. Mitchell, I'd like to just start by talking about some of the different opportunities you've had to give a statement. You gave a written statement back in September 2018, correct?
Yes.
And that was a typed up prepared statement that you provided to Sergeant Philya and Detective Shepard, right?
Yes, ma'am.
And I'm going to just show you quickly. State's Exhibit P1. Tell me if that's a copy of the written statement you provided to Sergeant Philya and Greg Shepard.
Yes, ma'am.
And did you prepare that statement?
Me and my attorney prepared the statement.
So you prepared that statement, it got sent to the Columbus Police, to Philya and Shepard, and then you went in for an interview. Is that right?
Correct.
And at the time that statement was prepared, you had not seen the you had not heard the audio or seen the video.
Correct.
And in that statement, well, first of all, Pilia and Shepard were part of the investigation in this case, right?
Yes.
So people you'd worked for years, you gave your interview to.
Yes.
And in your written statement, you told Pilia and Shepard, or whoever was reading that the suspect started to get increasingly agitated and started saying things like, I was a rapist going around killing prostitutes or something. Do you remember that?
Yes.
You said, I tried to calm her down, and I believe I told her a marked cruiser could come arrest her. Did you write that?
If that's what's in there, yes.
Okay. Did you ever say, I'll call a marked cruiser to come?
If that's what's written in my statement, yes.
Did you hear that on audio later?
No.
And you indicated in that statement she continued to get increasingly upset, and at some point, a male black came outside.
Yes.
You said in that statement you told the man to call 911, but that wasn't true, right?
After listening to the audio, no, I did not say that.
You said she was kicking the dash and hitting the windows, and you grabbed her wrist, and she continued to be combative. Do you remember that?
Yes.
You said, I believe I told her I was going to have to handcuff her since she was getting physical. Do you remember that?
Yes.
So in that statement, you were saying she was already getting very crazy, and you were going to cuff her before she even yelled out to that gentleman.
I can't remember at that time when she was being combative or aggressive, but through her voice, before he came out, I could tell she was getting upset, but not to the quite extreme.
So her voice was getting agitated, and that's when you decided to cuff her.
In the back of my mind, I'm thinking I'm going to have to cuff her, but I didn't cuff her at that time.
Okay. Well, you said I grabbed my cuff under my leg, and that's when you lifted your hand. Your right hand to try to cuff her, noticed a large gash on your hand.
Yes.
Does that sound right?
Yes.
Okay. You told Pilia that you fired 2 to 3 shots with your left hand, and your backdrop was the building and the passenger compartment. Do you remember that?
Yes.
So you told Pilia you fired directly across your body into the front passenger compartment. Is that right?
That's what I believed at the time.
And then you had an opportunity, they gave you an opportunity with your lawyer to go see the video.
No, we heard the audio.
You heard the audio first.
Never saw the video.
Okay. Did they ask you about the video and the door being open?
They never mentioned the video. And I'm not quite sure if he mentioned if the door was open, but I never mentioned the door being open during the interview.
Well, let me slow it down a little bit then. You remember listening to the audio, and then you had an opportunity to clarify your statement and recall anything that just came to mind at that point, right?
Right.
And then I believe you don't recall seeing the building video when you met with Pilia and Shepard?
I never saw the video. The first time I saw the video was at the grand jury.
Well, that's a weird disconnect. Yeah, remember, folks, it's an unusual trial. The burden for self-defense is on the defense to prove it by a preponderance. So he basically has to testify.
Counsel for Mitchell, does this look like a familiar document?
Yes.
Have you seen this? Okay. I want to refer you to page, oh, there are no pages. The second to the last page. And it says, we'll look together here. We're back on the record. We have just listened to the audio recording that you recorded as part of the arrest, and we also watched the surveillance video from the building. Is there anything that you would like to state after having listened and viewed those? And you say, do I need to say what we talked about? And your lawyer said, I would state the things about the time just so it's on the record. Does that imply you watched the building video?
It says I watched it, but I did not watch it.
Okay.
There was no video equipment in the headquarters to watch the video.
Do you recall talking about, or really asking you to explain why the door was open?
He may have seen the video, but I never seen the video. Maybe because he may have heard it, but I don't even recall him saying anything about the door being open.
Okay. Were you asked to comment?
Oh,
about
this
going
is a
back into the
drop
car?
ball
Your
by the
lawyer says,
prosecution.
"And about going back into the car," and you said, "Oh, going back into the car, I was just checking on her. I was checking to see where the knife was, making sure she couldn't do any more harm to me."
Correct.
So, but you hadn't seen the video. You were just commenting on going back into the car.
Yeah, I remember going back into the car.
Okay. So then you're saying you finally saw video of this for the first time in 2019,
right,
when you came to that hearing.
Because I specifically remember Mr. O'Brien stating, was the door open or shut? And I said it was shut.
Okay.
And then he continued to talk. But then he goes, "You're gonna be surprised if the door was open?" I said, "I don't believe it was open." So then they played the video, and my stomach kind of turned because I saw the door open. And it surprised me because I didn't realize the door ever opened.
Okay, well, we'll get back to that. Let me finish up with the first statement and first
Let's,
interview. Do you recall
let's move on to
Sergeant
something
Pillay
else
say,
really
"Why didn't you
quick.
take
That
the
didn't help my
library with the
case.
others
Go
went?"
ahead.
And you said the other precinct gets upset if you take them there.
That's correct.
You didn't say, "I didn't want to scare her and she was directing me," did you?
I believe he was talking about after the arrest was done, or it wasn't in my mind to take her to another precinct to meet the other officers, is what I was thinking.
Well, he specifically asked you, "Why didn't you take Donna Castleberry to the library?"
What was my response?
And your response was, "The other precinct gets upset if you take her there." I can find it if you'd like.
I was thinking he was.
I'm sorry?
He was responding to no question.
Oh, okay. Thank you. So do you also recall talking to Sergeant Pillay about the cuts on your hand?
Yes.
And do you recall telling him that you had a small cut on your left index finger from fighting with her, from the struggle with the knife, and that she got you slightly, in addition to the other big gash?
Yes.
And that you had no other cuts?
Correct.
So you told Sergeant Pillay at that time, all of your cuts happened in the front seat during the struggle, didn't you?
If that's what I said.
And when you were interviewed by Sergeant Pillay, do you remember telling him you didn't know which leg was pressed up against your neck during this choking incident?
At the time, I did not know. That's what I said in my statement.
Has that come back to you since, that information?
Just going over things with my lawyers and remembering what happened. It was determined it was her left foot.
Do you remember it being her left foot?
No, at the time, I didn't remember it was on her left foot or her right foot.
So the demonstration Miss Caitlin did with her left foot, maybe it wasn't her left foot after all, was it?
It was her left foot because that's the DNA was found on her left foot.
So that's why you say it's the left foot, to match the evidence?
Because that's what it was.
Well, you just told us you don't know which foot.
At the time, I didn't know which foot it was. It was a foot.
Now you're making the assumption it was the left foot because there was DNA on it. Is that what you're saying?
This is petty. What difference does it make which foot it was?
Well, she was kicking you this whole time, wasn't she? Struggling, fighting, kicking, right?
Yes, yes,
Kicking with her feet, the bottom of her shoe against you, right?
yes.
That would transfer DNA, wouldn't it?
But you're not helping, prosecutor.
There's no such thing as neck DNA. It's specific to the neck to determine that's where it came from, isn't it?
There is neck DNA. It could be sweat, could be blood. The DNA can come from anywhere.
That's true. But we can't tell that the DNA, if it came from your leg when she kicked you, your hand, or your neck, right?
So you say it's possible, but I believe it came from my neck.
What difference does that make if it came from his hands or whatever? Her feet are still in play.
You said that, and you told Pilia this as well, that right when you decided to release her hands, you decided, I'm going to do it as quick as I can. And that's what I did. You remember that?
Yes.
So as soon as you let go of her hands, you made the decision then to shoot, right?
Yes.
You didn't make the decision to take an opportunity as the circumstances changed and she went to the back to turn around and reassess, did you?
I knew that whatever action she was going to do, it would be very fast, within seconds. And that's why I decided I was going to shoot.
You did not reassess the situation in those seconds from releasing her hands to the time she started moving to the rear seat, did you?
I reassessed the situation because she already had cut me. She was in the process of choking me seconds before. I felt danger, and that's why I shot. I did not want her to cut me again.
Yet you didn't know where the knife was.
The knife was still in her hand when I released it.
You hadn't been cut the entire time. You undid your seatbelt, opened the door, reached for your holster, brought it to your chest, right?
Yeah.
Unsnapped the holster, pulled the gun from the holster, and then turned, right?
Yes.
You had already decided to shoot before any of that happened.
Yes.
So redirect should say,
decision
what if she had dropped,
to shoot her
you'd seen
happened
her drop the
when
knife?
she
Would
was
you
in the
still have
front,
shot her? He would have said no.
When you let go, she
Let
was
go.
still in the front.
Yes.
So you decided you were shooting her then, and then she ended up in the back, didn't she?
Yes, but she still had the knife on her while she was going towards the back.
Did you see the knife?
No.
Someone's characterizing the prosecution as
And
pro-police.
you indicated you.
Have
told
you not
William
been
you
watching
said in your
trials the
statement,
last few years?
You were trapped in your seat. You were in your seat during the entire shooting with the door closed, right?
Yes.
And that you had to kind of turn and try to pivot and fire from being in a seated position, right?
Right.
But in fact, after seeing the video, you realized that
You're a
wasn't true,
millionaire. That's not
What
Right.
wasn't true?
that you had opened the door. You
Yeah.
had made way to somewhat stick body parts out, pivot and turn and look towards the back, right?
Yeah, I don't remember that.
Okay. But there's
There's video
objective
proof.
evidence it happened, right?
Yes, there's video proof that I did open the door. I just don't remember during that interview. And even today, I still don't remember opening the door. I remember going as far to my left as I could. I wasn't seeing her actions. I was going like this. So I didn't know what she was doing at that point.
While you were firing, you were going like this.
The first 2 or 3 shots, yes.
So you weren't even looking at the object in the
The reason I
record.
was looking, I was trying to get as far away as I could, so she couldn't take the knife to my neck or head.
Well, did you even know where she was in the car?
Yes, I knew she was beside me, heading towards the back.
Or was she already in the back?
To me, she was beside me.
And you're aware that the forensic evidence showed all the shots were front seat to back seat, right?
Yes,
In 2019, you gave testimony under oath, right?
at the grand jury.
Correct.
Yes.
And do you recall testifying just regarding the incident that your backup was about 5 to 6 minutes away?
Yes,
You were trying to calm Donna down, and you said you'd call 911.
I believe I said call 911, but I did not.
You said then that you shot across your body, the same as you said in your initial statement, right?
Yes,
And you said you were sure the door was closed.
yes,
And I think you clarified that then you saw video with the audio, right?
yes,
For the first time, and acknowledged the door must have been open.
yes.
You said
The
you were
knife
happy Donna
wasn't
was
to
yelling
his
for help
neck. The knife
because I
never
wasn't
went
able to get
anywhere
to my
near
phone
his
to
neck.
call for help. So I knew by him calling 911,
His
someone
hand.
would get there faster.
Yes,
So you've just told this jury she was yelling to this guy, escalating the situation, right?
yes,
Making things up.
yes.
And you told the grand jury, I was happy for this yelling. What she was doing was helpful to me.
Yeah, because I couldn't get a hold of my partners. I couldn't get a hold of the uniformed police. I was glad somebody was going to call 911. I wanted somebody.
Where was your phone?
It was in my hands.
Okay, 911, right? That was an option, wasn't
It's
it?
an option.
And you said to the grand jury, I wasn't able to get to my phone to call for help. So that wasn't true, was it?
Well, I had to have a reason for calling 911. At that point, there was no reason to call 911.
Well, hadn't you been arguing with her about whether you were an officer or not?
Yes.
So that's not reason to call 911 and say, send me a cruiser right now?
I don't think I would have had opportunity to talk on the telephone.
You had time to sit there and text your buddies, right?
At that point, it wasn't an emergency. It wasn't a 911 emergency.
You said she was faking. She doesn't believe I'm a cop, and that was all just faking, and you knew where this was going, right?
Numerous times we fought with these prostitutes and it never came into the ending of a shooting or a knife act. I just believe, was this going to be an altercation, a wrestling match, handcuff? Numerous times I've done this. And I never pick up my phone and call 911 when I'm about to fight with a prostitute. It just doesn't happen.
Well, first of all, you probably only forgot your badge 4 or 5 times over your whole career, right?
Correct.
So you didn't have your badge, which set this into a bad situation to begin with, didn't it?
I had my ID.
Had you had your badge, like she asked,
She would have said that was fake too.
that's what you're saying.
Most likely.
You recall her saying, I know how the whole Vice thing works. I've never had it happen like this.
Yeah, I remember saying that.
Okay. And Vice generally did take them to the library or Princeton, right?
And we also advise you to make an arrest on your own.
Sure. But generally, I think you said 90-some% of the time, you went to the library or Princeton, right?
Correct. Yes.
So this was unusual.
Not really unusual to me. Maybe it was unusual for her.
And you said to the grand jury you were doing everything you could. You were trying to assure her that you weren't trying to kidnap her, right?
Correct.
Yet using your phone to call dispatch or 911 or somebody, you didn't see as an option.
At the time, I did not think about calling 911.
Even though she yelled to someone, call 911, call the police, right?
Yeah.
And you told the grand jury the only time you ever got cut, both hands, both cuts happened in the front seat, right?
At the time.
During the struggle in the front seat, you told the grand jury that's when you got cut. correct?
That's most likely when I got cut. I don't know the exact time that I got cut.
Well, if you were under oath,
Are you talking about the secondary wound or the major wound?
yes, you had, we talked about it as the small cut on
Yeah.
the left and the big cut on the right.
I was in the front seat when I received the big wound. I have no idea when I received the smaller wound.
Well, that's not what we just talked about a few minutes ago, because I think you just admitted to me that you told Sergeant Pilia you had a small cut on your left index finger from fighting with the knife. She slightly got me. And this is all in context of talking about the front seat struggle.
Yeah. So most likely it happened on the front seat, but I don't know the time that it happened during the struggle. I don't know when.
Okay, but it didn't happen when she was in the back seat.
No, it could have happened
when
when
you were both grabbing for the knife, right?
it could have happened when she was in the center console when she was choking me. It could have happened then. I don't know. Well, I'm saying it didn't happen while she was in the back seat. It had to happen sometime during the front seat.
So now you're saying it didn't happen during that struggle. It may have happened after the release and the transition to the rear?
No, I never said that.
Okay, I'm confused. You're both struggling.
Yeah, you're
for it.
flailing.
At some point, you get cut on the right, you get a cut on the left. At some point during that, then you release your hands. then
She's
you go
too
to the
busy
back.
being
Is that right?
angry and not busy
So it could have
listening
happened before
or
that.
being
She's
rational.
trying to fake an
what I'm saying.
inconsistency in his statements. It's
What I'm
not
saying, it
there.
could- Yeah, it could have happened when we were struggling, when she was choking me. It could have happened when we were actually fighting. That's what I'm saying.
Okay, agreed. And you told the grand jury, you told her, you said to her, I'm not trying to kidnap you or anything. Do you remember that?
Yes,
You told the grand jury you did that because she was acting as though I was going to kidnap her and she was probably worried I wasn't a police officer.
correct.
So is she making this up to go score dope or is she not believing you?
At first, she had a right to believe I wasn't a police officer. But after I showed her all these items, the handcuffs, the handcuff key, the affidavits, the U-10-100, my identification, I even asked her questions like, Do you have a warrant? Do you have any weapons? That's not a question from a kidnapper. That's a question from a police officer.
Well, did you ever say, I'm Officer Andrew Mitchell, badge number 1212?
I don't know if I actually said that, but I showed him ID.
And you said 50 check and I'll text my buddy, things like that? Not I'll text back up, I'll text my buddy.
I believe I said partner too. I also said I'll text my partner.
And you showed her your plastic ID and you showed her
U10-100. Yes.
Right?
Yes.
Papers that somebody could print on a computer. They could fake this paper, right?
If they're very good at it, yes, they could.
You can fake a uniform, a badge, a police car. You could fake all that stuff. We don't let people walk away from arrest.
Well, I can get any paperwork made by a computer, can't I?
And it doesn't matter what she was thinking.
You can order fake IDs, right? Kids have fake IDs all the time.
Yes, but mine wasn't fake. It was real.
She said she thought it was fake, didn't she?
That's what she said.
Good answer again.
Do you recall at grand jury, you were listening to the audio with the video, and there's a point where you said she's lying, saying I was trying to cut her. She was trying to get the male black to help her. She's saying things to try to get away. Do you remember that line of questioning?
Yes.
So you thought she yelled out, he's trying to cut me to get that male black to come let her out of the car?
She was trying to say that to anybody. At this time, I didn't know where the male black was, but she was still yelling out, he cut me.
And she was saying, get off me, right?
She was saying that, but she was the one on me.
She was on you, but she's yelling, get off me.
Yes.
And we'll go through in a few minutes that. But so that's when she's choking you.
That's when she was yelling, help.
She's yelling, get off me.
Yes.
You said she escalated it. I was willing to sit there and wait for backup. She kept going and going. She escalated it by rolling the window down and yelling to the male black. Do you remember that?
Yes.
So in your mind, that was escalation, saying, can you help me call the police?
Yes, it was escalation.
Escalation.
Carla, you doing all right?
That was escalation?
The other things that she was saying was escalating.
Yet you were thankful she was saying that because you wanted someone to come quicker as backup, right?
The police part, yes.
Then at an April 2022 hearing, I think you agreed that you got the small cut on your hand during the struggle at some point when you guys were all in the front, right? I think we've established that.
Right.
And you indicated you reached into her space, correct?
That's what it says.
You were trying to arrest her.
Yes.
And you were never cut again during this incident.
No.
Columbus Police gives you 2 badges, don't they?
Yes.
And that's so you don't have to switch from shirt to special duty uniform to wallet, all the places, right?
Correct.
And you had to.
Yes, I did.
And you knew you forgot your badge before she asked you about it, right? Or as soon as she asked you, at least.
Yes.
And I believe you told the grand jury, you thought, oh man, I'm going to get reprimanded for this, right?
I still remember before I told her I was the police, I'm thinking in my mind, I pictured the chief of police reprimanding me that I didn't have my badge.
But I thought it wasn't required.
It just helped for identification.
You agree it's probably the most important piece of equipment you can have to identify yourself, right?
Yes.
And in your work, being able to identify yourself is pretty primary.
Yes.
Agree?
Yes.
And you've heard of people impersonating police officers.
Yes.
And you knew your backup was tied up with an arrest 5 to 6 minutes away. Not only 5 to 6 minute drive, but clearing up whatever they were doing with a suspect, right?
Yes, and that's one of the reasons why I parked up against the building, because I knew it'd be a minute before anybody got there.
And you knew they were tied up before you picked up Donna Castleberry, right?
Yes, but I'm sure they could break free, is what I'm thinking.
And you decided picking her up and getting those elements was more important than making sure you had backup near her, right?
I wasn't predicting this to happen. I wasn't planning on getting in a shooting or being cut.
Of course not.
I was planning on making a simple arrest.
But at the time, you said you didn't want to take her to the library because you didn't get the elements yet. That's going to scare her off because you don't have the elements yet. So you're going to go drive around. You'll follow her direction, you said.
This was a club. I didn't want to take her to the club.
Okay. Because the
it was only a block away. It was only a block away. And plus, if the prosecutor's been arrested before, there's a known location where we take him.
So you wanted to be sure you got those elements first.
Yes.
And so instead of taking her there, you let her direct you, you said.
Yes.
She directed you to some building.
Yes.
Even though you knew people were tied up, right?
Yes.
And this is for a misdemeanor offense, right?
Correct.
Are you familiar with the vice policies at that time?
Some of them, yes.
Are you familiar with the directive 2.12 that says safety is paramount? Officers shall not attempt to obtain elements of prostitution-related charge without supporting vice section personnel present. Are you familiar with that policy?
Depends what year that policy was made.
I assure you it's a policy. I'll just need a moment to find the right place.
Did he just trip up the state here?
She said, I'm sure it's
That
current
sounds like the new policy.
Yeah.
cover I can, but this might look familiar to you.
Current policy may not have been the
There's 70
policy 3
pages
years
here.
ago.
We have an introduction. The standard operating procedure manual has been prepared as a guide for bisection personnel. Section 2.12, teamwork. Detectives shall not attempt to obtain the elements of prostitution-related charge, i.e. soliciting, engaging, or promoting without supporting bisection personnel present. Right?
That's what it says.
Okay. And safety is paramount during any operation. You agree with that?
Yes.
And while I'm here, police radio. Personnel assigned a police radio will carry it at all times during their tour of duty unless exigent circumstances apply.
Correct.
You didn't have
As
a radio
here.
that day, and it was required, wasn't it?
It was left in my trunk of my personal car.
It was not in your undercover vehicle, right?
No.
And this is also the policy that requires you guys to record the conversation, right?
Right.
But he's not on trial for violating policy.
Prostitution investigation.
None of this stuff killed her.
At least 2 vice detectives will work in close proximity when enforcing street prostitution. And this also is where it says it shall be recorded.
Yeah.
Okay. And yet you knew officers were tied up and 5 to 6 minutes away and still tried to get the elements to make the arrest, right?
Yes.
And are you familiar with the Columbus Police General Directives?
Somewhat.
Are you familiar with the Directive 1.45, requirement to give name and badge number? It says sworn personnel in plain clothes, when exercising their authority under the law and identifying themselves as a police officer, shall display the badge and police identification concurrently or as soon as safe and practical.
Yes.
Fair enough? Okay. So you were ill prepared to do your job on this day, and you even knew you could get reprimanded, right?
Yeah, I didn't have my badge, yes.
Or your walkie.
My walkie. I'm not for sure if I thought about being reprimanded for my walkie, but
But that was a violation of policy, right?
if that's what's written, yes.
And normally in these operations, you would text the team and say, I'm looking at one, right? You'd let them know I'm getting ready.
Like I said, I didn't have enough time to get on my thread to let them know that I was on the fine. Like I said, there was nobody out that day. I was surprised to see Miss Castleberry.
You didn't have time to say, looking at one on a cell phone. It was in your lap or ready at hand because you just text Laura, right?
Right. I didn't have time. By the time she came up on me, I didn't have time to say, hey, I want to take her to so-and-so. I knew I couldn't get to the library because it was too far away.
Well, is there something about your cell phone that
You got to
has a badge
Steph
on it
the
that
Alter
makes it
Nerd
look
sighting. Welcome,
like anything but a
Steph.
cell phone?
Good
Hey,
to have
Steph.
you here.
Personal cell phone?
The one you were using to text the team on?
No, it doesn't have a
Just
badge.
a regular cell phone, right?
Yeah.
And you were worried that if she saw you texting, that was a giveaway.
Yeah, it happens all the time. I ran into it numerous times. When women come up, they see you on the cell phone, they think I'm contacting somebody to make an arrest.
So
I'm in
instead
such a
of
good
saying
mood. You're my
sorry
newest
without
mod.
coming,
Congrats, Steph.
it's more important to make sure she got in your car and you tried to get the elements than to alert your team that you were about to engage someone.
I wasn't planning on getting into a shooting. Like I said, I was just planning on making a simple prostitution arrest, handcuffing her, and taking her to jail. I did not foresee this happening. It wasn't going through my mind. Maybe I got lax. Maybe I made one too many arrests. Or I had no problems. I wasn't foreseeing any problems. And maybe that's the reason why I didn't notify the team, because I thought I could handle it myself.
You got too relaxed.
Council want to approach? Off the record. Carla, off the record.
Okay, wait, I just missed that. Why are we going off the record? Didn't hear that.
Maybe he wants to know how much longer she plans to go. Maybe it's getting to lunchtime.
Council want to approach?
I had no problems. I wasn't foreseeing any problems. And maybe that's the reason why I didn't notify the team, because I thought I could handle it myself.
You got too relaxed.
You got too relaxed.
Council want to approach?
So it sounds like they testified to something they weren't supposed to bring up.
Off the record.
Off the record. So it's not.
Huh.
They're talking about lunch or something.
We're going to take a 15-minute break.
Yeah.
Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to.
And
form
he didn't say he got
opinion on the
lax.
case
He said
until
he
the
got
final
relaxed.
For the record, I don't know how much more I want to question, but the case law and the constitutional law is absolutely clear that a violation of a policy in no way, shape, or form has anything to do in the analysis of whether or not the court.
Hey, keep it down, people.
So the constitutional law and the safeguards laid out by Graham v. Connor and State v. White are very clear. Multiple jurisdictions, all jurisdictions have said a violation of policy has nothing to do in the analysis of whether or not a lawful force was allowed to be justified and reasonable. So I believe we're at a very close situation, Your Honor. Well, it would be a mistrial, and I'm not sure if they're going to argue that in closing arguments, but those are the issues that with that line of questioning. So I don't know what their intent is, but it cannot be argued, and it says it shall not be argued that a violation of policy in any way, shape, or form has anything to do with the analysis of whether or not force was justified.
Judge, it all goes to his credibility on his past statements and what he said he saw.
Nope.
What he actually
If it goes,
We're not gonna argue that that violation of policy had something to do.
That's what they're arguing right now. You forgot your badge. You forgot your walkie-talkie. That makes it murder. Just look at the chat. That's what they're buying.
Yeah.
And we know what the law is and how to argue it. We're not gonna.
but you don't know what the labor laws are. You don't know what administrative hearings are. You don't know what those things are. So those are a whole separate process that you're trying to give a connotation that somehow he violated something. But not having a badge, guess what, can't be a reprimand. It can only be an oral reprimand. It can't be a violation. So that the terms that you're using indicate that somehow he's violating something internally when that's not the case.
You have the ability to answer the question. You have the ability to redirect. I'm reading from policies that he says were in effect.
And that's why we don't have administrative hearings in criminal cases.
No.
Because in criminal cases, there's rules about criminal evidence. There are no rules for administrative procedures in administrative hearings. That's why they're kept separate from being involved.
Little lady.
That's
mansplaining, ladies. That's short for man explaining things to you.
That's not allowed in this type of case in a Graham v. Connor and a police shooting, Your Honor. Administrative processes and terminations are not allowed in this type of case. It's clear in the case law, and they know that, Your Honor, but they're trying to couch it under some credibility argument.
Mr. Collins, I mean, they're trying to show your client, he's not even here. Nope. I was like, oh my God, he's not even in the argument. Show that he was ill-prepared, sloppy, and that could go to the credibility. They can go into this. I don't know why, but
understand credibility, Your Honor, but you can't use it in any argument about the decision to use deadly force, or that the ill-preparedness made a conditions that made it more permeable or more possible.
I'm going to allow them to get into it. I don't know why, but. And how much more do you have, or do we just want to take?
I'll allow it.
I'm gonna play the video. So this could be a bit. Sorry, Your Honor.
You want to come back at 1?
Whatever the court decides.
Whatever you want to do.
Everybody's moving everywhere. Let's just take a break. If you're going to be more than 15 minutes, and I know you're going to have a little bit of redirect, not much, I get it. Come back, let's start back up at 1:15. I got to go out of the building for a little bit.
Thank you, Judge.
Ah, my ears, stop. Shh. Wow, that was great. So that's like an hour from now.
Can you advance? Are we behind the clock here? Or?
That is it. He said one come back at 1:15, and now it's 1:23 Eastern.
Right.
So
well,
yeah.
So they should be back.
Yeah.
Right?
Let's see. Let's refresh.
Oh, they should be back shortly.
She wanted to score some dope.
Okay, guess they are back. Oh, they just came back right now. Like right now, less than a minute ago. Ow, stop it. Stop it.
No, it's like bad character evidence, this policy stuff.
That was pretty good timing. They came back 52 seconds ago. All right. Yeah, so let's see where they go with it. All right. They clearly didn't fix the audio during lunch. So play.
She never said that, did she?
She never.
I'm sorry, you never said that.
Wait, let's go back to the video.
Donald, your statement.
Pat, stop it.
You made quiet.
Here we go.
Mr.
Oh,
Mitchell, at
we have
no
subtitles now.
time Previously, not in your written statement that you prepared and typed, your statement to Pilia, or the 2019 hearing, did you say Donald Castleberry was trying to score dope, right?
I'm not for sure. I don't know unless I read those.
Okay.
Wolf, you get the comment of the day.
Never mentioning that she acted like she was higher on drugs. She never said that, did she?
She
No,
never.
I'm sorry, you never said that about her.
No.
You never put that in any statement that she appeared to be on drugs to you.
No.
And you're saying you don't remember whether or not you would have said she was trying to score dope?
I know she said that in the when we were together in the car. She wanted to score some dope.
Okay, I understand you're saying that now. Did you ever say that in your written statement?
I didn't say everything in the written statements. No. It's hard to gather all that information and put it into one thing. I didn't remember everything that happened.
Okay. And so you didn't say that to Pilia, and you didn't say that in 2019?
No, not in the interviews.
And you yelled, "Fuck you, I'm gonna have to cuff you," after she yelled out to the bystander, right?
Yes.
You escalated that situation right there, didn't you?
It was already escalated. She was the one escalating.
Her yelling to the bystander is the
Police are
escalation
allowed to
you're referring
escalate.
Yeah.
If you're non-compliant.
Why was there a sudden need to cuff her right then?
Because, like I said, in numerous arrests I've had, you know when a person's going to be physical, and I knew she was getting ready to be physical. The best way to control it is to handcuff her.
And with
Because
all
she
the
yelled,
love that
"Help,
people
call the
get for the
police to
police,
somebody."
she's telling some
She was getting
bystander
ready
to help
fight
her
me. I
out.
could tell. Just the way her voice was raising, her actions, her yelling out to the guy to help her to escape, basically. That's
You
what
were
she was.
happy she yelled out to the guy, right?
Yes, because I wanted some backup to get there as fast as
I
possible.
would have been the other way. I would have been
Yet
worried
you
that he was
never
going to
used your
start
phone
beating
for
on the
backup.
cop.
Because I knew it was going to be escalated. It didn't happen at that point. But if it was going to happen, it'd be nice to have the police respond.
Shea States Exhibit X.
Maybe if he'd offered her an extra $20, she would have let him handcuff her.
You could approach.
Do you want to approach? Okay,
Or
we're
you
good
can
on.
approach the witness.
Are we good?
Boomer Wow says, I would argue it's mind reading to think she was faking surrender as her voice got weaker in between shots.
It's a better version of Donna Castleberry.
Who says she was faking surrender?
Oh, that was one thing we were saying. That's a possibility that she could have been faking it.
Oh, sure, but it's not necessary to the defense. It's just,
yeah.
it's
And
his
how many
perception.
times have you seen the police shooting videos where
So
the
you
guy
said
has
there
been
was the
blasted and
struggle with
bleeding and
her,
they're still like,
dash.
put your
And I
hands
think as you
behind your back.
described it,
They're just
she
make
was-
sure.
Had her back
Anyway.
like to the radio area
Yes.
and her back to the windshield.
Yes.
So is she right next to your steering wheel?
Yes.
Okay, it looked like Miss Stevens was right in front of you during the reconstruction here. She was actually a little off to the side, you're saying?
Yes.
So if I'm facing you then, if this is the front of the car, you're here, so she's kind of.
Get up
where
on that rail,
the
prosecutor.
Correct.
And you said.
This attorney almost looks like Nick's sister.
Yes.
Or you're surmising that now?
One of her feet was on my neck.
And
Yeah.
And
Yeah,
you
I
said
noticed
your
that, Luke.
head is against the headrest.
Yes.
You're in your seatbelt. She's pushing really hard and your head's trapped.
Yes.
You can't go anywhere.
No.
moment for exhibit. Sorry, Your Honor.
You don't need to be an MMA master if you have a knife, folks. That's rather the point of having the knife.
Kingslayer Damocles says, I was focused on the knife trying to pry it away. Also, I have no idea what was going on with the knife. These are contradictory positions.
Fights are dynamic.
I'm going to show you what's been marked as State Exhibit H25. May I, Your Honor, this has been admitted. Courtney, please, thank you. I know it might be a little more difficult to see here. Everything's clear on the small screen for us than it is for the jury. But this vehicle has, so we see the center console, there's a gear shift there in the center, isn't there?
Yes.
I guess we know where that
And
went.
there's an emergency brake, right? In that center area. I can show you, let me switch. I'll switch to H27. Does that provide you with a view?
Yeah, I can see.
So that's
yeah.
in that center console area.
Yes.
And I'm looking for a better photograph, but fair to say, then the radio is right here in front of the gear shift and the emergency brake.
Yes.
And that's the area she was sitting in.
Yeah.
And one more, States Exhibit F29. We could see a little bit off to the right of our screen. A little difficult to tell. There's a knob. That's the radio. That's the area we're talking about.
Right.
And we have a rear view mirror there at the top, right?
Yes.
I'm finished with Elmo. Thank you.
Someone will have to point out the supposed lies he's told. Because
I was going to ask about that, too.
misremembering is not lying.
At this time, Your Honor, I'd like to play the video, Exhibit V3, and review that with Mr. Mitchell.
110 pounds is not normal today for a woman, not in 2023, not in America.
It's a tiny
more like
woman
170,
today.
180.
So you can see that in front of you, correct?
Yes.
It's obviously a little bit clearer.
She was 5'5",
than
so it could have been
looking here,
200.
So if you want to refer to your own screen. And I'm going to stop this periodically.
Oh, this helpful video again. Why haven't I embiggened that? There we go. It took him 45 seconds to shoot her after the cut because he was trying to subdue her and get her handcuffed without having to shoot her.
You probably picking up Miss Castleberry, right? And you're starting to engage in conversation.
Yes.
Resuming at 1:08. That was 1:08. Stopping a minute and 21 in. Do you know what you're talking about there? Can you hear?
Yeah, that's when we were talking about her tattoos.
11:45. Can you make out what's happening here?
I couldn't hear.
Fair enough. Sounds like $30, $25, negotiating the price, right?
Yes.
Stopping at 2:35. What's happened to this point until you pulled onto the lot?
She was wondering why I pulled up to the meters, and I said not word for word about so she couldn't get out.
You told her something about so she couldn't get out?
Yeah, that's what it sounded like.
Okay. And then we hear police.
I identify myself as a police officer.
By saying police.
Yes.
Okay.
Police.
There's police. So you say, I'll show you my ID, and you were going to show your CPD.
That's
ID
what I
card,
was
right?
doing. Yes.
And then you say, I ain't trying to kidnap you or anything.
That's because she looked a little worried, a little scared that
Okay.
I wasn't the police.
All right.
Just what a kidnapper would say.
Hold on, let me see it. You ask if she has any weapons, and she says, hold on, let me see it. She wants to see her ID card?
That's what I was showing her at that point.
Okay.
Did the chat. Come on,
So where's your rat?
Don't be off flag.
Oh, I didn't say that.
I'm gonna cuff just for my safety. I'm not gonna do that to you. I'm just gonna cuff.
No, I'm not doing anything. Stopping at 3:23, you say, I'm not going to do nothing to you. Why do you tell her that?
Because she still looked apprehensive, like, what are you getting ready to do?
Okay.
You're being under arrest. If you don't have any warrants, I'll let you go.
Okay, well, I'm going to have to see some other type of ID badge.
I just showed you my ID. I don't have my badge on. I'm calling my buddy.
So at 3:39, you say, I'll call my buddy, and she says, you're going to have to do that.
Correct. Yep.
So at 3:56, you're asking her the street, and she's cooperating. She's giving you the right street, correct?
Yeah, and that's when I was texting it to the thread of where I was.
Brad, he's not guilty until after the second shot. Why the second shot? Which ones hit her? We don't know. Maybe the last three were the ones that hit her.
Right.
Maybe the first three missed.
Just to stop at 4:18. So we've got some silence. Is this you probably texting
Yes.
the group? Okay. And we kind of, as I said, you can see here, you're in the driver's seat, she's in the passenger seat, right, at this time?
Yeah, nobody's handcuffed. I'm texting. She's just sitting there.
Okay. Because I don't know who my situation was.
No radio.
I've never had any of this happen like this way. So.
Why? Because I don't have my badge that I left on my police shirt.
You don't have a badge, you don't have your walkie-talkie.
Yeah, I do.
So she's told you, I've never had it happen like this, right?
That's what she says.
Okay, and so she's asking you for more identification. You don't have your badge, you don't have your walkie. She still doesn't believe you, right?
Right. That's when I was grabbing. That's when I was grabbing the paperwork from the back seat.
Okay.
What is that? There's no way to do it.
And we can see, if you look carefully, a little bit of movement in your seat. Would you agree? I don't know if you were watching at the right moment.
No, little bit I saw.
Right, so I'm a policeman. You can keep that out.
Well, any shot after she starts begging is murder. What if he hit her with the 3 shots before she started begging? And he didn't hit her after that. Come on, we don't know.
Pause at 5:18. So you say handcuffs, ID, what more do you want? And you both sit there.
Yeah.
Right? She's not screaming, nothing's going on. Everybody's in their seat, right?
At this point, yes.
You're waiting on backup now, hoping someone's gonna come or what?
I think I just heard the text. I might be still texting.
So we're at 5:45 on the counter. So we hear some clicking. You think that's you texting. Is that when you say she doesn't believe I'm a cop?
Probably, most likely.
And you text that because she didn't believe you were a cop, right?
Right.
Can you help me, please?
Help you what?
I'm a police marine.
I am the police.
You're not the police. I know you're not. And that's false identity.
At 6 minutes. So she's yelled to the bystander.
Yes.
And at that moment, you're saying that's the escalation by her right there.
Starting to begin right there.
And at that moment, you're not trying to cuff her right there, right?
No.
You're just sitting, she's talking to the bystander, and he's getting close to the car now, right? Or is he headed out? I'm not sure.
He already passed when she started yelling at him. He just kept walking. Now he's coming back.
Okay, so he's getting close to the car now.
When he's trapping me in here saying he's a police officer and he's not a police officer.
Yes, I am.
He's acting like he's a police officer. And he's not. He has this in a fake ass badge. Kidnapping.
6:14. So she's saying, he's saying he's a police officer. He's not a police officer.
Yeah.
And he's trapping me in here with this fake ass badge.
Correct.
And I believe you said that was escalating because she's trying to get away.
She's trying to have him open the door, obviously.
So she's saying that because she wanted to get away from you,
Right.
because she didn't believe you were a police officer.
Because she knew she's going to get arrested.
How would she know she was going to be arrested?
Because
You can't look.
Because he told her.
I told her. Because I told her he's only arrested for soliciting. That's why I showed her the badge.
If you don't have,
talk over each other, Carla, don't scream at me.
if you don't have a warrant, I'll let you go. And you didn't know she had a warrant at that time.
That's correct.
So after the fact, you're surmising that's what she.
He's arresting her in the moment.
Most
There's a
likely in her
difference
head,
between
she knew she
arrest
had a
and going to
warrant, so
jail.
She's going to go to jail.
So she was crafting this story to yell to the bystander that you were impersonating an officer to try to get away.
That's my belief.
That's your belief.
Wait a minute, I've already heard about, he already is wanted, this house is just showing the picture, you know that, right?
Yeah.
They just showing the picture.
6:27. So as soon as she says, they've been showing your picture, right? You say, yeah, fuck you, I'm gonna have to handcuff you.
Yes.
Your voice is risen. And
Because hers is risen.
I'm sorry?
Because hers has risen, I knew an altercation was about to happen.
You were getting mad.
No, she was getting mad.
You weren't getting upset at her for calling you. and
More
impersonating-
frustrated, not upset, more frustration, because I told her the things that I've already showed her. I showed her my ID. I showed her my handcuff. I showed her my handcuff key. I asked all the right questions. She knew I was a cop, to my belief.
yet she asked a bystander call the police, right?
That's just to me, that was a ruse.
Don't put your hands on me. Don't put your hands on me. Do not put your hands.
I want you to watch the video. At this point, you've moved out of your seat and you're leaning her direction, correct?
Yes.
You're trying to put handcuffs on her.
She's under arrest at this point.
Okay. You've moved over into her space.
It wasn't her space. She was under arrest.
In order to effectuate your arrest, you had to lean out of your seat across to her seat, right?
She's under arrest. She was non-compliant. I'm going to handcuff her.
And to do that, you leaned over.
To do that, I grabbed her to arrest her lawfully.
Would you agree with me? You've moved over from your seat, leaning over towards the middle.
That's what you have to do to place her under arrest. I can't arrest her sitting in my seat. I have to lean over and grab her.
I'm not criticizing that. I'm asking if that's what
You are criticizing.
Kind of were.
That's what I did.
That's like literally what she's doing.
Hands on me. Do not put your hands on me. Don't put your.
Now we see some movement.
I just want to make one quick comment here. I think this is a really big mistake for the prosecution to show this video like this. Why? Because she's going to be asking questions, and he's the only one that gets to give his side of the story as to what happened. He can spin this any way he wants. The only other witness is dead. I think this is a huge mistake. What do you
So
think,
the state's
Andrew?
trying to suggest that him entering this woman's space is him engaging in some kind of unlawful aggression. That's not what's happening. He's making a lawful arrest. The police are allowed to be aggressive when they're making a lawful arrest.
I just think it's bad because he can say whatever he wants, and she's got nothing to counter it.
She's
No
under
other
arrest
witnesses.
when he tells her she's under arrest. It doesn't have, the handcuffing is not the arrest. The handcuffing is part of the process of being arrested. But the moment you're told you're under arrest, you're not free to leave, you are under arrest.
Over towards the wall on the passenger side. Would that be where Donna Castleberry was?
Yes.
So you're still trying to put her under arrest, trying to cuff her. Over on her side, she's still in her seat area, right?
Yes.
Hands on me. Help. Help.
She's got a knife.
Help. Help.
642 in. First, you say she's got a knife. So you saw the knife, right?
Yeah, after she cut me.
Okay, well, you say she's got a knife, then she cut me. So
I didn't see the knife till after she cut me.
And you're still over on her side of the car. You're leaning across towards the passenger side, correct?
Yes.
Cut me.
Help me, please. Open the back door. Help me. Open the back door. He's coming.
We see a little bit of movement near the window. Did you see that at 653 row?
Yes.
And is that the handcuffs going out the window?
Most likely.
You didn't recall at the time, but that's what we surmised.
Yes.
So she's still over on that side near the window, pressed up against that door, correct?
I believe so.
Well, what's going on now? You're struggling.
We're still
to get the knife.
struggling. We're still trying to, I'm still trying to get a knife. I'm still trying to pry her fingers from the knife so I can grab it to end the threat.
So you're leaning from your seat. She's over on her side and you're struggling for the knife, right?
Yes.
And is she kicking you or anything at this point?
She's probably kicking her legs, flailing her arms, but not at me at that point.
Please help me.
701, we see some more movement. That's Donna over on her side, right?
Right.
So she's still there and we still see the shadow of you leaning across, right?
Yeah.
707, looks like you're moving even a little bit further over that direction. You guys still struggling in that
No.
area?
No. It looks like I'm right. seated in my seat. That looks like me off to the right.
You're saying you're seated in your seat completely at this point?
Yeah, this is when she starts to strangle me, choke me.
Well, let's back up a minute and have you watch that a second again. That was at 7:07.
Yeah, all right. They just show you. Don't put your hands on me. Don't put your hands on me. Do not put your hands on me. Do not put your hands on me. Don't put your hands on me. Help! Help!
She's got a knife.
Help! Help! Get off of me!
It's cut me.
Help! Help! Help me, please. I'm in the back door. Help me. I'm in the back door. He's nothing.
That's where she says he's trying to cut me.
Yes,
And you said you thought she was saying that so the guy would open the back door?
that's what I surmised. That's what I believe she was doing.
And the handcuffs had fallen?
Right.
Good work, cameraman.
Okay, we're back at 7:07. Would you agree with me that that's still you in the same position?
Objection, Your Honor. Ask the assertion.
Sustained.
Continue. All right, now is it clear? 7:11. Do you see the figure, Donna, off to her side, moving around?
I think this is when she was choking me.
You're saying during this, she's sitting on the center console, choking you with her foot?
Yeah.
That's what's happening here. And she's yelling.
I'm just, I'm not for sure. I mean, the video's unclear, but it sounded like I was having a hard time breathing. And I remember when she was pressing the foot up against my neck, I was having a hard time breathing. And I believe this is the time, but I'm not quite sure.
Any chance she's kicking you with the back against her door with her foot
No,
on your neck?
no. On my door?
No, her door, I'm sorry.
No.
So she's not, you're saying she's left her passenger seat?
Yes.
She's sitting in the center console. No way is she still in her passenger seat, possibly.
Why is the prosecution doubting this? Because the video doesn't show anything to the contrary. You can't make anything out of the video.
We'll keep playing. At 7:20, would you agree with me that the shadow we saw in that middle area moves and the door opens?
Yes.
And that's you, right?
Correct.
You open that door.
Yes.
And can you see the rear view mirror? Looking at the small one, see the rear view mirror?
Yeah.
See the open space between the seats?
Mm-hmm.
Okay. We're 7:24 in. Did you see Donna move from her seat through the middle to the back?
In the video, that's what it appears to happen.
Her warrant was for sentencing. She didn't show up for sentencing. So if she had showed up, she would have gone to prison.
Somehow come out of the car. We don't know if you're completely out, right?
Yeah.
And you've pivoted and you're facing the back now.
Right.
And she's saying, okay, sorry, but you did not hear that.
No, I did not.
And you say, God damn,
Yes.
right?
And that's weird that she can't say when the shots were fired either.
At 7:41, you were swearing, you said fuck.
Yes,
Correct?
I did.
Fucking nightmare.
We're finished with that. Thank you.
Weird.
You agreed in a prior hearing that when you got cut, you were in her space, her part of the vehicle, right?
Like I said, it wasn't her space at that point. She was under arrest. I was in the area of the passenger seat.
I wonder if her space is going to come up in closing
Did you
argument by
disarm
the
Ms.
state.
Castleberry?
No,
Did you ever reach for the knife to cut your hand?
no.
You didn't know.
She was the aggressor. She attacked me. I did not injure myself on the knife.
She believed you were a rapist. correct?
Doesn't matter.
That's not an evidence. And it doesn't matter. It's irrelevant.
You testified at a hearing previously. You don't remember where the knife was. It all happened so fast. Some of the details are missing, aren't they?
I don't know what details you said are missing.
Well, you don't remember the door opened, right?
Yes, I don't.
You didn't know she threw the handcuffs out, right?
We're in a struggle. I didn't catch that.
You don't really know which foot was on your neck, right?
Doesn't matter what foot she had on my neck. She had one of her feet on my neck.
Yet you're convinced you didn't grab that knife.
I know I didn't grab the knife
And
because I didn't see the knife.
how did the knife get into your seat?
I didn't see when she placed it on the seat. I didn't see that.
Well, you were sitting in that seat, weren't you?
Fighting in that seat, struggling.
You were pinned in that seat with your back against that seat, right?
Right.
That gun, or that, I'm sorry, that knife was found right in the back of the seat where your back would have been, right?
Right. I never saw the knife till after the incident was over. It even could have got moved by me, and I didn't even realize I moved it. It was on the seat. Maybe it was further over on the seat, and it stuck up somehow. I don't know.
So maybe it was somewhere else and you moved it there?
I'm just saying it could have been on that seat, not positioned from where it was found, but it could have got moved on the seat when I got up from the seat.
Sure.
So some of the details are foggy.
The seat's angled back, right?
I remember everything. I just don't know if the knife was moved. It could have been on top of my leg. It could have been on my hip. And when I got up, it moved to where it was. I don't know how it was positioned when she dropped it.
Yet you don't know that, but you're certain you didn't grab it from her and disarm it.
I already know I didn't grab it and disarm it.
Why would it be hard to distinguish those two things? You don't know that, but you're certain you didn't put her head in a wood vise?
There were no pictures taken. You suffered no neck injury, right?
Well, it still hurt.
She has
when I
no
was in the
neck.
hospital.
You never had anything documented, right?
I doubt you could see anything. I have brown skin. It's hard to see any kind of markings.
Dumbass white prosecutor.
When you were fresh coming from your training that day, right?
Yes.
Fresh at shoot, don't shoot scenarios, right?
Yes, ma'am.
And would you agree with me? An officer can fire 4 to 6 seconds, 4 to 6 shots in a second?
It's possible.
You've practiced right and left-handed shooting, right?
Yes.
You guys train 5 times a year.
Yes.
And
pathetic.
you were doing these scenarios where it might be groceries, I think you said, a cell phone or a weapon.
Correct.
You had to determine what was the threat and when to shoot, right?
Yes.
Focus in on that object and decide, is this a threat?
The best you can. Yes.
And you had to,
Sir, can you take off your hat?
and when the object went away from you, it was no longer a threat and you were to quit shooting, right?
Sorry, Chief.
Correct.
Did they teach you shoot until the gun goes dry?
No, they say shoot till the threat stops.
Have you ever said that the training was shoot until the gun goes dry?
I never heard of that phrase.
would you agree with me that you had Donna Castleberry contained in that car when she was getting feisty with you, and you could have stepped out and shut the door?
Objection, Your Honor. Sustained speculation.
Yeah, there's always some other thing he could have done in hindsight. He could have stayed home from work that day.
Would you agree with me there is no support for your memory that the door was closed? We know it was open, right?
We know it was open because of the video, but I do not remember the door being open.
But you opened it. Nobody else opened it, right?
I'm not disputing I didn't open it. I opened it.
At the time, it was a voluntary act, correct?
It was a muscle memory act. It was instinct. I don't know what it was. Muscle movement. It happened. It was a flow. It was a flow of things of what I was doing, and part of that, the door was open.
It was a series of seatbelt,
Correct.
door, gun. It was
Part
and
of
you
training.
remember-
Excuse me.
You remember all of that sequence except opening the door, right?
Yeah, it's all part of one motion act. I don't remember opening the door. If I would have remembered opening the door, I would have told the detective, I remember opening the door, pivoting my foot, which I did. I don't remember it.
As an officer, you're trained to pay attention to
You're not allowed to not remember.
nonverbal action,
Murder.
but verbal cues, right?
Yes, but in this situation, I could not hear her.
But you recognize nonverbal cues might be somebody putting their hands up or backing away or making some sort of motion to show some sort of surrender, right?
I never seen her put her hands up.
I'm not saying that. I'm asking if those are nonverbal cues you look for.
Yes.
And verbal cues might be something like someone say, I'm going to kill you, right?
Right.
Or they might say something like, I give up. I'm sorry, right?
Yes, but whatever they say usually is not their actions. It could be something else. They could say, I'm not going to kill you and still kill you.
Mm-hmm.
Right? But that's important information you're trained to listen to help provide context, right?
Right.
To assess a threat. Go through a few things that you discussed, Mr. Collins on direct. Get some of these already. I think you talked about parking in the fashion you did against the building.
Yes.
While other officers might have done that, that's generally not what you used to do, right?
The reason I usually didn't do it a lot is I would have somebody really close, a couple blocks off. So usually Officer Key, Brian Key, me and him worked a lot together, or any other officer. And if we do that, there's no need to have to block up against a building.
So it wasn't the norm for you.
No.
And you told Mr. Collins her voice was escalating and I was fed up. I guess that's how you were feeling before you cuffed her. You were fed up.
Fed up, tired of the situation, tired of trying to convince her I am a police officer.
You'd been sitting there calmly before, right?
We both were.
She had
I'll be right
cooperated, told you where you were, what street you were on, right?
And if she would have just stayed calm the whole time, none of this would have happened.
If you had de-escalated and stepped out of the vehicle and waited for a cruiser,
Objection, Your Honor.
would
Sustained.
Again, he could have gone on vacation that day and she would be alive. What's the point? If you had decided to go into the ministry rather than be a police officer, wouldn't she be alive
Hear the
today?
words. Donna said some words before the first shots. Do you recall that?
Help me.
I'm sorry?
Okay, help me. From the audio.
Do you recall hearing her say anything before you?
No,
Nothing at all.
I knew she was saying something, yelling something, but I never heard what it was.
I don't think you know what a straw man argument
Mr.
is.
Collins asked you about other cuts, and do you know when you received your other cuts? And I believe you said you didn't know if it happened in the front or the back.
Of course. Jeff steps away and the video freezes.
I'm gonna overrule it.
Thank you, Anna. I want to be clear. Before lunch, we tried to establish the cuts all happened during the struggle in the front seat, right?
Correct.
And you recognize.
Nope, there goes the audio. All right, folks, this Saturday, tomorrow, Saturday, Law Self-Defense Advanced Course, my full-day class on how to be hard to convict. If you're ever compelled to use force in defense of yourself, your family, your property, it's taught live by me, personally. Streamed to you at your computer, plenty of opportunity for Q&A. The only one of these scheduled for 2023. Tomorrow, Saturday, April 15th. If you can't attend in person, I would tell you to register anyway, because we'll make the replay of the class available to all the registered students so you can watch it at your convenience over the next couple of weeks. Yeah, this is the one, folks. Not another one scheduled until next year sometime. When are you going to need to be hard to convict? When are you going to be attacked and have to defend yourself? It's not up to you. The bad guy makes that decision. We answer over 100 very specific self-defense law questions in the course of the day. And I bet you don't know the answers to those questions right now. Certainly not the correct answers. Join me tomorrow. But first, you have to register at lawofselfdefense.com/advanced. Just like it shows there on my name, lawofselfdefense.com/advanced. You may also consider getting your own copy of our best-selling book, The Law of Self-Defense Principles. Check it out on Amazon. Over 1,200 reviews, 4.8 stars, because 0.2 people suck. But the book is very, very well reviewed. Check it out on Amazon, but don't buy it on Amazon. They'll charge you for the book and the shipping and handling. I only ask you to cover the shipping and handling. I'll give you the book for free. And you can get the book for free at lawofselfdefense.com/free book. Real physical book, folks, not just some PDF download. Or if you'd like to go fancy, these make lovely gifts. The hardcover edition of Law of Self-Defense Principles. These are not free because they're too costly to print up, but they're lovely books. They make great gifts. Father's Day isn't that far away, folks. I know you know somebody you love who would appreciate this book. Looks great on the bookshelf. You can get this one at law. You know where. You all know where. To get the hardcover, Law of Self-Defense Principles, you can get it at lawofselfdefense.com/gethard. What else have I got? I've got this. I've got our free 5 Elements of Self-Defense Law cheat sheet. These are the 5 building blocks of any claim of self-defense or defense of others. If you don't know these, you don't know self-defense law. You can pick this up for free at lawofselfdefense.com/elements.
Wow, that was
just
unplanned for event. Yeah, it was like how long after I left?
The video froze pretty quick, but the audio kept playing, which was fine, and then the audio quit too. So that's when I started.
Weird. All right.
The impromptu grift opportunity.
Yeah, I figured you had that covered. Good thing I didn't take any longer than I had planned. I was just stretching the legs. I've been sitting down for 18 and a half hours, pretty much straight.
I've got about another 20 minutes of stuff to grift. It would have been fine.
Yeah.
Turn into a law self-defense infomercial.
We're good here. Now I've got to bring everything back up. That's the problem. Let's see. Go back about 3 minutes, I guess. 4 minutes, 5 minutes. We'll go back 5 minutes and see what happens. Because I didn't see it. All right, gotta bring us back up to 600%. And I think we should be good to go. All right, everyone. It's good to be back with you here. Well, while we're back here, we got 513 of you here and 558 likes. That's pretty good, but most of you have probably already changed over. So continue to hit that like and subscribe button. I haven't grifted that yet. Got to do that. I think we're all caught up on super chats. Interesting. All righty. Oh, that's interesting. Yep, looks like we're caught up. All right, bring this on back up. Share the screen. Sex worker. There we go. Shooting trial. All right, I have no idea when, where, how this stopped, so this is just kind of what we're going to go for.
Hear any words in the car once? Do you remember hearing any words in the car once the struggle started?
No, I do not.
Okay. Is there anything that you're trained on, Mr. Mitchell, that regards to, hey, don't go into their space when you have the lawful elements and the lawful arrest and the lawful duty to put your hands on someone?
Yes, we're allowed to do that.
Is there anything about, hey, don't go into their space or give it enough time to get into someone's space?
No.
Does space matter at any point in time when you're going to handcuff somebody?
No.
Did you tell her in advance that you were going to handcuff her?
Yes.
Did you tell her in advance that you were going to arrest her?
Yes.
Well in advance of when you actually physically tried to cuff her, correct?
Correct.
Were you able to hear any words whatsoever when the first gun went off, when the first shot went off?
No.
Mr. Mitchell, when she tried to kill you with the knife and choking.
I like that. That was a good question.
Were you able to say, hey, stop, I want to replay this and freeze here, Miss Castleberry, because I want to examine how everything is situated there?
No, I did not.
Were you able to sit outside and watch it as this belief? Did you have a belief at that time that she was trying to seriously injure you?
Yes.
Were you able to say, hey, I'm going to
Okay,
replay this to try to determine what your intent was?
No.
Could you sit there for 34 minutes in hindsight and review when this was happening to you at that instant?
No.
Are you trained in any way, shape, or form, in any capacity in your 30 years there to call a buddy in order to make someone feel more comfortable?
No.
Okay. Once you have the lawful elements for probable cause and you're going to arrest one, does it matter to you what their intent is, whether they believe you or not, if you're an officer?
No.
Is there anything in your training or experience that says you can't arrest someone if they don't believe that you're an officer?
No.
Is this how Miss Castleberry looked on State's Exhibit S when she cut you with a knife?
No, it is not.
Is this how she looked when she choked you?
No, it is not.
Mr. Mitchell, were you required to give a written statement?
No, I was not.
That was a voluntary act. Was that a voluntary act?
Yes.
Why did you do it?
Because I wanted the facts to be out there. I wanted to tell the truth.
Were you required to sit down for an interview?
No, I could have refused.
Why did you give an interview?
Because I had nothing to hide. I wanted to tell the truth.
Did you tell the truth to the best of your belief and memory when you gave a written statement?
Yes, I did.
Did you tell the truth to the best of your ability when you gave an interview?
Yes, I did.
Man, that jacket's working.
Grand jury?
Yes, I did.
Were you required to go to the grand jury?
No, I wasn't.
Why did you voluntarily do that?
Oh.
Because I wanted the truth to be out there. I wanted the people to know the actions that I did that day were Donna
This
Castleberry
jacket's designed by the Donna
actions, and I
Castleberry
reacted to her actions.
Design Studio.
Do you have anything to hide?
It's screaming for help.
Each and every time there's been a hearing or anything, have you ever declined to tell what you remember happening there that day?
No, I never declined.
In terms of the knife, may I approach a witness, Your Honor? Miss Pritchard asked you a couple times of whether or not you believe this, the knife was in there, I mean, in her hand when she went to the back, correct?
Correct.
Okay. And at a prior. Hey, we approach.
You want
May I approach the witness stand?
Yes.
At a prior hearing, okay, you were asked whether or not you believed that she had the knife when she went to the back seat. What was your answer to that?
Yes, I did. I believe she still had the knife when she got to the back.
At a prior hearing, were you asked that again? What's the answer?
She had it in her hands when she headed towards the back. Okay, you thought she had it in her hands when she was heading towards the back. And I answered yes.
Was it asked to you again?
She is still putting up a fight. She was still, this is my answer. She is still putting up a fight. She was still swinging her legs. She was still swinging her arms. So the knife could have been in her hands.
Do you have any idea, sir, how the knife got to where it ended up?
No.
Were you trying to speculate from Ms. Pritchard how it wound up seated there, correct?
Correct.
Does your training, sir, require you to get a second gash of 34 stitches before you are allowed to shoot to stop the threat?
No.
You're actually, does your training indicate whether or not you can shoot before the threat actually occurs?
Yes.
And does that training indicate that you can shoot before another threat occurs?
Yes.
Did you perceive her to be a threat the entire time from when she went from the side of you to the back?
Yes.
Does it matter which foot was choking you?
No.
Did you tell him which foot was choking you in your written statement?
No.
Did you tell him what foot was choking to you in your interview?
No.
Did you tell him what foot was choking you in the grand jury?
No.
Did you try to explain why you said the left foot today?
Yes.
When you've arrested people in your 30-year career and have you had people resist?
All the time.
Was there ever a time, based on your training, that you called 911?
Never.
Are you trained to call 911 ever?
No.
In this situation, after you had been slashed, after you've been choked, what did you text to the group?
I texted 10-3, which means officer in trouble.
Are you trained to do that?
Yes.
Now, let's clear up this when working. Ms. Pritchard told you some policies from the vice squad, okay? You remember seeing those?
Yes.
One of them was about close proximity, correct?
Yes.
Right. When it says you have to work with someone else, correct?
Correct.
Are you allowed on your own at any time to go out when you're a member of the vice unit and arrest people for prostitution?
Yes.
No, I mean specifically with no one else knowing it.
No, they got to be in that side of the town.
Does there have to be a team?
Yes, at least one other person with you
So if
in
there's
the
two-
area.
Correct. So my question, Mr. Mitchell, is one day you show up to work and no one's there. Can you on your own go out and arrest people for solicitation?
No.
Has to be another person, right?
One day I did come into work by myself. I went home because there's nobody else there.
Okay. Now, when you have another person, that's what the directive is, correct?
Correct.
Now, when you have another person, that person, do they have to stay within close proximity?
Proximity, meaning the same side of town.
If one person, if you're both on the west side of town or the bottoms, can one of the people then go to the northeast side on their own and work prostitution cases?
No.
Is that your understanding of what close proximity is?
Yes.
How many arrests have you had for solicitation and prostitution in both times you were in Vice with two officers in the same car?
Never.
And again, anything requiring you at the Vice directives and those 70 pages that Ms. Pritchard handed you, requiring you to have your badge while you're undercover?
No.
Is your job to get the elements?
Yes, for prostitution.
That's your job, correct?
Yes.
Is it why you're in a hurry to make sure you can get the elements before, is that why, before you're going to somewhere?
No. But, yeah.
In order to charge someone for prostitution, do you have to have the elements first?
Yes.
Okay. So your job at that time is focused on getting the elements?
Yes.
Okay. So in the situation that Ms. Pritchard said, you didn't, let me back up. Oh, thank you. Ms. Pritchard asked you about why you didn't text somebody when you saw her, right? Ms. Castleberry, or why you didn't text somebody that you had one, right?
Right.
Okay. This is out of the governance exhibit with the text threads, okay? Okay. And again, I think we've established that's you saying anybody out here, right?
Right.
What's that say right there?
Yep. D at the library with 1.
Who's D?
Daryl McKissick.
Did Daryl McKissick text the group ahead of time? Hey, I'm about to try to charge someone with prostitution.
No.
Did D text anybody? Hey, I've got one. Come to this area.
No.
Okay. Is there any? So when you receive D at the library with one, does that mean he's already gotten the elements and he's already charged the person and they're at the library?
Yes. Okay. Handcuffed and ready for Lord to search.
So D McKissick, he didn't notify anybody that he potentially had one.
No.
He didn't say, hey, I'm taking someone over to the library. That was Detective Evans saying, yeah, out here, D has one at the library.
Yes.
When you tell someone they're under arrest, does that mean you have to take physical custody of them to process the arrest?
Not at all times.
Okay. Can you take physical custody of them at that point in time to place them under arrest?
Yes.
Okay. Does under arrest mean I'm taking you to jail?
No.
Okay. Taking you to jail means you're going into custody.
Right.
Under arrest means I'm charging you with something.
Correct.
You told her from the get-go that you were a police officer once you had the elements.
Yes.
Then you told her, I'm charging you.
Yes.
You are under arrest.
Yes.
Lawful, she's not, is it based on your training, is she then supposed to be non-compliant with arrest?
He's been answering leading questions for like 15 minutes and you haven't
tell
objected.
someone, Mr. Mitchell, that they're under arrest, okay? That's the hypothetical. Make sense?
Yes.
Okay. Then if they don't comply, what do you do based on your training?
We handcuff.
Did Miss Castleberry comply in any way, shape, or form, verbally or physically?
No.
When you reassessed, when you made the decision to use deadly force, why did you fire your gun?
She was attacking me.
Did you believe she was a threat to you when she was on your side?
Yes.
Did you believe she was a threat to you when you went back?
Yes.
Had you already been cut and slashed?
Yes.
Had you already been choked?
Yes.
And did you believe that if you didn't use deadly force that you were going to be seriously injured or harmed?
Correct.
Thank you, Mr. Mitchell.
Any questions as a result of those?
Mr. Mitchell, I believe you testified at all of the prior hearings that you didn't know where the knife was when she was in the back, right?
Yeah, I didn't know if it was in her hand or not. That's what I meant.
It was in your hand.
At the time you gave all of these voluntary statements, you didn't know there was video synced with audio, did you?
At the grand
Until
jury.
the 2019 hearing.
The grand jury, yes.
Correct. And when McKissick had his at the library, he was at the library where Laura typically waits to search people, right?
I'm not sure she was sitting there waiting.
You don't know if he was there. He was there with the team. He had people there with him, right?
I don't believe. I believe it was by himself.
Well, nobody was coming to help you, right?
Right.
So where's everybody else?
I have no idea.
So you don't know where the
Question's
knife is. And as long as you don't know where the knife is, Donna's got no chance, right?
I believe the knife was in her hand.
You never saw that knife in the back seat, did you?
I never saw the knife when she cut me the first time.
You saw it when you were struggling with her, right? In the front seat.
Yeah, after I focused in on it, after I got cut, I knew she had a knife, and I looked into her hand, and she had a knife.
And you never looked to assess and see if she had that knife in the back seat. You never saw it.
I did not see it because it could have been concealed in her hand. She was flinging her arms. She was kicking her feet. She was yelling. There was all kinds of things going on. I did not see it.
You didn't even look at her your first shots, correct?
First couple shots, I didn't look at her.
All right, ladies and gentlemen, we're going to get at the other witness, about a 15-minute, about 15 minutes. Do not discuss this case among yourselves. Do not prevent anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it's finally submitted to you.
All right.
Wow.
So I guess that's it for the defendant. Testimony.
I thought he did a very good job, and I thought
he could have answered those that last series of questions better.
Yeah,
you know, he just kind of he's speaking like, well, he had no idea where the knife was. He'd seen the knife in her hand by this point. He should have answered, I had no reason to believe she didn't still have the knife in her hand.
I thought the redirect was very, very, very good. I gotta say, I think I'm kind of won over to his side on this as far as the burden of proof goes.
And of course, that's just him. Now the defense has their other witnesses. Presumably, they'll have some kind of use of force expert to counter the testimony, the weak testimony for the state's own use of force expert.
And you said you might
interesting stuff. And I'm seeing the usual pattern in the chat of a lot of mind reading, a lot of emotional investment in a desired outcome, dissatisfaction with a bad outcome in the sense that theoretically there were ways this didn't have to begin or end this way. But nobody has a time machine. We don't get to go back. Policy violations are not murder or manslaughter. He didn't stick a knife in her hand and stab himself. And it doesn't matter what she was thinking. That's legally irrelevant to this case. He concedes he shot her and killed her, and he raised a legal defense of self-defense, and her state of mind is irrelevant to his claim of self-defense.
Where are you sitting on this? Are you at this point? I know we can never predict what juries are going to do. If there's one lesson you ever want to learn from watching these streams, it's you can never predict what the jury's going to do.
Right. Yeah. Juries are dangerous and unpredictable creatures, which is why I never predict verdicts. I can only say, based on the legal merits, this would be the rational outcome here. And so far, the rational outcome would be not guilty. To my mind, the state has, the defense has the burden to prove self-defense by a preponderance, but that's the same way of saying the state has the burden of disproving it by a preponderance, right? It's a 51% either way. And I haven't seen the state come close to doing that.
And they're essentially done with their case in chief. So they are done with their case in chief. We've got
people think I'm disparaging the jury. I'm not disparaging the jury. I expect that they'll come back with a rational verdict. That's my expectation. But they could not. Sometimes juries are irrational. And it's not a matter, keep in mind, folks, it's not guilty or not guilty. It's proven guilty or not proven guilty.
Right. Okay.
So I don't know whether he got mad and murdered her. I don't know what was in either of their heads. I wasn't there at the scene when all this happened. But that's not the test. The test is, what can the state prove, and can they overcome the legal defenses?
And that's something that I have trouble with telling clients. Everybody wants you just to understand that I'm right. This has to go my way. Make this case go my way, whether it's criminal or civil.
It's not fair. It shouldn't happen this way. I can't believe this is happening to me. But don't you know about all these other things, like this guy's federal prosecution?
Yeah.
Right. I'm not going to research the federal prosecution because it's not admissible in this case.
And nobody wants to hear the thing that's just very, very hard to tell clients. And that is, you may be 100% right, but unfortunately, the law has nothing to do with who is right and who is wrong. It has everything to do with who can prove what. You may be 100% right. If you can't prove it, you're fucked. And
yeah, so this trial is taking place in Columbus, Ohio, which is where the shooting took place.
Yeah,
and at the time the shooting took place, Ohio was the last state that still put the burden of proof on self-defense on the defendant to prove self-defense by a preponderance of the evidence. Since then, Ohio has joined every other state to put the burden on the state to disprove self-defense beyond a reasonable doubt. But at the time this event took place, and that's the law that's being applied, the change was not retroactive. This defendant has to prove to the jury that it was self-defense by a preponderance of the evidence.
Yeah, and we're getting at 3:30 a.m. here. I don't think I can.
Yeah, I figured you want to wrap up.
Yeah, I don't want to get behind again on a Monday, so I was thinking of maybe doing a Sunday-ish stream. I don't know. Are you going to be around on a Sunday? Or are you going to be out enjoying a motorcycle ride like a normal human being?
I don't know. I'll have to play it by ear. I'll be talking for 8 hours on Saturday, so I'm not sure what shape I'm going to be in on Sunday.
I have to see what I'm going to do because I already know I'm going to be drinking a lot with some friends coming back from Spain on Saturday. So I don't know what condition I'm going to be on Sunday either. But if I am, I'll shoot you a link and I'll see if you're free. So we'll probably just do just a Sunday.
Yeah, send me the link. Just DM me. I mean, I'll let you know, but I probably won't know until at least Sunday morning for sure.
That works. Well, thanks for joining us for almost 6 hours.
All right, guys. Take care. Thanks for having me on, Jeff, and best to everybody. And I hope I see a bunch of you in tomorrow's Law of Self-Defense advanced class at
got a couple hours.
lawselfdefense.com/advanced. Register right now. Register today. That's
right
it,
there.
right there.
lawselfdefense.com/advanced.
Be hard to convict, folks. Don't be an easy target for prosecution just because you defended yourself or your family. lawofselfdefense.com/advanced. Tomorrow, Saturday. The only one of these scheduled for 2023. Be there or be square. All right, brother. Take care. I'll talk to you soon.
Take care.
Bye-bye.
All right. Have a great day. We'll see you. All right, everybody. And that's about that time over here. 6 hours and 23 minutes into this stream. It's a Friday where you are. It's now early Saturday morning where I am. I've got a bunch of stuff to do today. And some drinking to do tonight, which is it's 3:30 a.m. So I got about 14 hours before the drinking begins. And then Sunday I've got a bunch of stuff to do. So probably about the same time on Sunday morning. So it was for US. So probably somewhere around 8 or 9 a.m. on Sunday morning, I will catch us up with the afternoon session, and then we can just join everything live on Monday. So we don't have to do the 1.25 speed thing. But it also means we're stuck with the giant breaks that they do. Delisandra, I'm so diplomatic. Why? What did I do? I didn't do anything. Why am I diplomatic? It just calls things as it sees things. We do have one super chat that came in. Boomer Wow, audio is perfect right now, by the way. I didn't do anything. They unintercourse themselves, I guess. So, hey. Oh, and the one thing I'm trying to do also, with my busy schedule, I've got to do it tomorrow. John Wick 4 has finally opened in Korea, so I gotta catch up on that. I got to see that tomorrow, hopefully. Let's see. Anything else we got going on here in chat? Oh, Jillian N. Jillian N has gifted the universe 5 Legal Vices memberships about 45 minutes ago. Thank you so much for that. That is deeply, deeply appreciated. And I know a few people, at least 5 of you, got Legal Vices memberships gifted by Jillian N. If you're one of those and you were still here and you haven't already done so, give her a big thanks for doing that. Let's see, just kind of scrolling through here to see if there's some comments. Oh, look, it's a super chat. Fondin, bring the super chat. How was she choking him with only the bottom of 1 foot? DNA was found on only 1 sandal. At that point, she was behind him supposedly. Now, she was still in the front seat, choking him. She wasn't grabbing him. He was grabbing her. And she had her feet. She had one of her foots. She had one of her foots. Had one of her feet up on his throat, and was pushing on him while he's pulling on her. That's how I understand it. I don't know. It's. But one of the things I do not like that even the prosecution couldn't say, okay, here is your first shot. Okay, here is your second shot. Here is your third shot. Here is your fourth shot. Here is your fifth shot. Here is your sixth shot. They couldn't do that on the video. And there was no medical evidence to testify as to which ones were the kill shots. Was there one kill shot? We just don't know. And I don't like that. So I said it could have been, people say, the first 2 shots are good, the rest are murder. Maybe the last 3 shots were the ones that hit her. We just don't know. Maybe she was already all shot up before she said, okay. And even though he fired, none of them hit her. We just don't know. And I don't like not knowing. And as I said, I thought it was really bad of them to put on the video evidence for the prosecution to break down the audio and the video the way she did. Because any question she asks, the defendant gets to spin that question any way he wants, because there are no living witnesses to testify otherwise. There's nobody there to contradict him. He gets free reign to answer her questions any way he wants, and he did. I thought he made her look very, very bad. And then the redirect came in, and I thought he crushed the redirect. And then, like Andrew said, it was a pretty good deal, but the last few questions he didn't kind of answer very well. Nobody's gonna give perfect testimony. Everybody's gonna have some problems, and if a witness never contradicts themselves, or if a witness is never unsure about something, to me that's a good sign they're lying, because you're just human. Why can't we hear shots in the audio? If you can probably do this with I don't know if you can do them with phones anymore, but like other microphones and things, you can over modulate the microphone. Like if I were to scream really loud into this microphone right now, it would modulate itself to where it would drop the audio down to low levels to compensate. But in most recording devices and things like that, if it can be so loud that it overmodulates the microphone, and the microphone can't handle it. A gain cutoff, yeah, that's what Captain Chrome was saying. But essentially, like it was like Andrew was describing the other day. It's like when you shine a flashlight into a mirror, into your camera and whatever, and all you see is just a white noise. That's essentially what's happening, but on an audio level. It's just, the gain. Well, here, I have this automatically set to off, but I think we can kind of try to recreate it here with my microphone. All right, I'm going to turn my gain all the way up. Okay, so I should be coming in a little bit hotter than I normally do because I've got the gain all the way up. Now, what would happen is if there's an exceptionally loud noise, it's going to cut this off, and then it's going to drop it down. And then once the volume recovers, it will bring it slowly back up again. So that was just that was a manual demonstration of what happens automatically. Yeah, I'm going to fire a gun in my house. Bang. Yeah. Unfortunately, we don't have those here. So anyway, yeah, muted. Yeah, thanks, Adriana. That's the point. Anywho. Yes, it just happened. It automatically it just white noises itself out. It just cancels itself out, and it just overwhelms it. So that's why what's happening is you're in a closed car with a phone, and you have this exceptionally loud noise 6 times. You're not going to hear it, and that's why if you listen to the audio, you can hear some clicks, just like some little. That might be the shots. So, anywho, that's kind of the answer to that question. All righty then. Well, I think I'm going to get myself some 3:37 a.m. sleep here. Thank you. I just want to thank everybody for joining me for 6.5 hours. Wasn't expecting that, but the defendant, the prosecution rested. The defense started their case in chief, and they got the guy they got the witness himself, the defendant himself, to testify right out of the gate. That's a good thing. And I know he said the other witness, so there's a possibility this may be the last witness for the defense. I mean, I don't know what else they would have to do. They've got the guy himself and then a use of force expert. And that might be the end of this case. And if it is, I have no idea what I'm going to do next week, because I thought this was supposed to be a 2-week case. We'll just have to see what happens. I got a lot of stuff to talk about, but I love doing these trials. These trials are fun. Some of the bigger ones that come up, I want to do another split stream with Ozzy. Well, speaking of Ozzy, is he going live now? I need to see who we need to redirect into. Last time I tried it with Mike, for some reason, nobody got forwarded there. So let me bring up the studio, see who is live right now that I can funnel us off into. Oh, see now, God damn it! I swear to hell, if you please like and subscribe this video, and if you have subscribed, make sure you're still subscribed. I thought we were out of the clutches of the YouTube dropping people off of the subscription thing, but since we've done this, we've dropped like 10 subscribers. Like I said, it goes up to 36,026. I haven't got past 26, but we've been there several days. It goes up to 26, then it drops down to 35,995. Then it goes back up to 36,026. Then it goes back down. But we held pretty steady at 36,014 today. But now we lost like 10. We've got a few back, so now we're at 36,007 subscribers. We're still above 36,000. So that's good. But if you haven't subscribed, please do. This is what we love to do. We love to do fun stuff. And a few things that I wanted to talk about coming up, just total random. There's a lot of random stuff to talk about, which we'll get to at some point next week. But Maritime Monday will be back. OJ Thursday will be back next week. And I've got some really cool stuff on the horizon. Some cool people. 3 things coming up that I can think of off the top of my head relating to Maritime Monday. I'm talking now, working out. He happens to be kind of sick right now, but when he gets better, I'm going to be having on a Maritime Monday show a decorated retired Coast Guard lieutenant commander who is one of the people who flies helicopters into do helicopter rescues of maritime disasters. We're gonna talk to him about some of the crazy stuff that he does as part of his work. That's one thing, and I have a really cool interview lined up. Well, I have a friend who I've been waiting to do a really cool interview with, and I'm going to line him up. A certain maritime disaster that he was actually, he's one of my friends, and he was actually on the ship that we're going to be talking about. And it's a big deal. It's a big incident. And one of my good friends was on the ship. So we're going to be talking about that. And also we do some of Brick and Mortar's videos. We talk about, in our maritime disasters and things. Brick and Mortar has some great videos. And we have the Maritime Horrors has some great videos. We interviewed the creator of Maritime Horrors recently. Well, he has asked me to collab with him to do one of his videos. You remember? Okay, I won't spoil which one we're going to do, but he's asked me to be part of that video and to talk a little bit about the legal side of things. So I'm going to be collabing for one of his videos, which I think is pretty damn cool. And then there's a couple other things coming up too that we're working on. On May 8th will be the couple that talked to us about the last cannibal case we did off of the coast of Australia before it was Australia. They're going to come on and talk to us about the Franklin expedition. They're going to be doing a little more Franklin expedition with this. So that Maritime Monday is going to be pretty damn fun for the next couple of months. OJ still be OJ, and we'll see what other trials come down. I just kind of wanted to throw a little bit about that out there and what's coming up. I hope you'll all find it interesting, because I sure do. All right, what? Legal Vices, one more time. You missed a super chat. Well, there's still 3 here. Well, there's still 2 here that I haven't done. And I'm going to do those, and we're going to wrap them up. See, this is a cool thing now. I never have to worry about if I've missed super chats. I just have to click this super chat tab, and boom, they're all right there. So that's pretty damn awesome. Fondin, thank you so much for your super chat. I guess we already did that one. All right, I'm starting to get tired. We have one last one left from Delasander. Don't have much dollars, but I love your take. So here you go. Della, that is so nice of you and so kind of you. You don't have to do that. So if you don't have it, you don't. I'm not begging or doing the pay pig stuff. I mean, anything anybody gives me, I'm grateful for, and I very humbly and very graciously accept everything that comes my way. But if it's something you can afford, great. If it's not, if you can't afford it, I don't expect anything. But thank you so much for that. Just don't, and nobody should feel pressured to give super chats, except for on F at Friday. We do once a month, where that's the whole purpose, is for me to grift as much money from you as possible, so we don't have to do it on other days. But thank you, Della. We love you too. Thank you so much. All right, back to where I was going here. Looking to see what's live content. We have to go to today's show. Content for today's show. Go to live. Live. Go to live. Yeah. There's our live stream. Go to customization. I am fading fast. Redirect. Oh, excuse me. Retrial. Let's see. Nobody's live right now. Guess Ozzy's not doing his thing. Flux is coming up in the morning. Legal Mindset's coming up in the morning. Cellulite Podcast is coming up sometime. I don't see anybody going live right now. Does anybody know anybody that's live right now? Anybody watching anybody that's live? I can just bring up the YouTube feed and look and see. I know that's live. Maybe we can try. I don't want to just shut this down if someone else is doing something live. Wouldn't it be funny if we just kind of redirected to Law and Crime? Should we just redirect you to Law and Crime? I don't even know if they'll let us. Oh, Nina Infinity. Oh, that'll be fun. What's Nina talking about? Nina Infinity. She is talking about something. If you guys don't know Nina Infinity, you need to meet Nina Infinity. Do me a favor, everybody. I'm gonna. Oh, please, Nina, let me be able to forward this to you. That would be so awesome, Nina. Nina, where are you, Nina Infinity? Come on, where? No, that's not what I want. ID, Nina. Just one word, Nina Infinity. Okay. Nina Infinity. Yes, cool. Boom. Redirect privileges are needed. Nina, we can't redirect to Nina. But what I'm going to do is I'm going to put a suggested stream here that you all should watch. Nina's I love Nina to death. She is so funny. She is so sweet. She is so good. And she's telling good stories about it. Right now, she's telling a story about an Uber driver apparently who donated his kidney to help some people. He donated his kidney to a writer. So, all right, that's enough of that. Let me do. What are we looking at here? Super chats again have come in. Gee. Jillian N says, please read Della Sanders super chat. I already did. We just had a big discussion about it. We just had a big discussion about it, Jillian N. All righty. There you go. I think we're done. Yep, that's it. So here is the Hundley's. I was supposed to be on Hundley's stream because I thought we would wrap this thing up about 4 hours ago. So I was supposed to be on Eric's streams, and I got to apologize for not being on his stream. All right. This is the link for Nina Infinity. I'll spam. Oh, that's too many spams. There we go. That's what it is. No. I can't even spam myself. That's how degenerate I am. Right? StreamYard doesn't react as fast as I want. So here is Nina Infinity's stream. Everybody go over there and just tell her Legal Vices sent you. If that's what you want to do. That's where I'm going to go. I'm going to go over there and listen to her while I get ready for sleep. I know, Jillian, you're great. Thank you so much, everybody. Good to see you here. We'll probably see you at some point around Sunday morning U.S. time. So thank you, Super Chats. Thank you, mods. Thank you, people visiting us. Please subscribe and like on your way out. That's all I can ask. Oh, and we have our poll. Our poll is wrapping up here. 20% of you said as of now guilty of murder. 30% say guilty of voluntary manslaughter, and 50% say not guilty. I think I'm in that 50%. All right, we'll talk to you on Sunday. If not, we'll talk to you definitely on Monday for Maritime Monday and then this trial. See you later. Have a great weekend. and enjoy your legal vices. I'm going to be up to my elbows in legal vices. We'll see you later. And Lorax out.